I know I'm a little late. My bad. Gotta get my kid off to school on the bus, so it takes a minute to come here after all that. So I apologize that I'm a few minutes late. That is my bad, but I have it ready to go here on the screen. I'm gonna bring it up on this screen. Oh, come on, computer. If it hasn't started, oh, maybe it did start. We'll go back after. Hold on. One second. I'm just trying to bring it up. Good morning. I'm late, so people found other places to watch, I guess, but they can trickle in after they realize I'm here, and I'll go back to the beginning after we have a break. There you go.
The reason why it's important and relevant is that Mr. Carney, but relationship and where information, some of the suggestive grand jury minutes was past purpose of Mr. Carney. Originally, a third party was used, an intermediary, where
I'm not understanding why it's spotty like that, y'all.
Appeared in the public record.
I don't know that. I know that the attorneys are very well aware.
I'm gonna look and see if it's on a different channel or if that's just what
Let
Coach
Let me ask you this,
That's
counsel.
weird.
Does the name of the intermediary appear in Trooper Tully's affidavit, either in the substantially itself or in the addendum A?
I would re-review, but it very well may.
Well, that's a critical issue here with regard to the purported relevance of the data sought. Let me ask you this, Attorney Brennan. Have the extraction reports been requested, been generated?
I understand they are available to Special Prosecutor Cosgrove and that they have the reports that have been generated.
Has the underlying data from the two phones in question been assembled?
Relationship between Karen Reed
Do this
and Mr.
one
Carney,
instead.
in which Ms. Reed would provide information indirectly to Mr. Carney. That information would then be reviewed by Mr. Carney, posted on social media, and consequently was used, we believe, allegedly.
Sorry, guys. The one that I had up was like going out every 10 seconds, so I'm gonna undo law and crime so that it doesn't keep going in and
To the
out for you
court,
guys.
I can
I'm
offer
gonna go
some
back
of
a
the most
tiny
important
bit.
parts if Your Honor would like.
It's important what he's
Counsel, I don't
saying.
think that's necessary. I elaborate on relevance as it relates to consciousness of guilt.
Yes. As Your Honor is aware, consciousness of guilt is a different standard than trying to prove a case of intimidation of a witness beyond a reasonable doubt. What we expect evidence will show, separately and in Mr. Carney's phone, is that there was a relationship between Karen Reed and Mr. Carney, in which Ms. Reed would provide information indirectly to Mr. Carney. That information would then be reviewed by Mr. Carney, posted on social media, and consequently was used, we believe, allegedly, to intimidate and harass witnesses. In the search warrant itself, there is extraordinary detail on how Mr. Carney targeted witnesses in Ms. Reed's case, with the express purpose, according to Mr. Carney, that this trial of Ms. Reed never go forward. We have a many-page affidavit that we have provided to the court. I can offer some of the most important parts if Your Honor would like.
Counsel, I don't think that's necessary. I've reviewed the affidavit in support of the search warrant thoroughly, and here's where I struggle. So the case law says the party seeking the data in question has to make a initial factual showing that it's relevant, not potentially relevant, relevant. That's the initial burden. So to demonstrate her alleged consciousness of guilt, defendants, don't the communications sought or the data related thereto have to only involve communications between Mr. Kearney and the defendant?
I'm not clear on your question, Your Honor.
How is anything beyond communications between Mr. Kearney and the defendant in this case relevant to her consciousness of guilt? Here's my issue. You have sought a broad swath of data. We don't know the volume yet, but it is from the addendum A to Trooper Tully's affidavit in support of the search warrant. It calls for data including calendars, alerts, reminders, notes, text messages, pictures, or videos from April 1st, 2023 through and including October 5th, 2023, 7 months of material that ostensibly could include everything from meeting notes, calendar invites, texts, videos, things that have absolutely nothing to do with communications between Mr. Kearney and the defendant. So how can the Commonwealth make the threshold showing that those are relevant?
First, this is a ruling with Mr. Kearney, so I'm asking that Mr. Kearney and his attorney be at the table. I'm not sure why we're being joined by Ms. Reed's team unless they have standing in this.
Your Honor, we're a little confused, and I don't mean to interrupt the proceeding, but as we're...
Can you state your name for the record,
Of
please?
course, I'm sorry. Alan Jackson on behalf of the Juror. We didn't see which case number was called for this Rule 17, if it was Mr. Kearney's case number or if it was Ms. Reed's case number. We were told, or at least our impression in talking to Judge Giannoni, was this issue was going to be on our case number. I specifically asked that question at sidebar day before yesterday, and she said, yes, the Rule 17 that Mr. Brennan's dealing with is on Ms. Reed's case number as it pertains to her rights and the
This
issue.
meeting is being
Counsel.
recorded.
Counsel, it has been called in this case, but I don't know that your client has standing with regard to this particular issue.
So the case number, I just want to make sure procedurally I'm on the same page as the court and Mr. Brennan and Mr. Kearney. The case number that was called was the Commonwealth versus Karen Reed.
00117.
Okay.
That's correct.
Then she needed to be here and she has right to counsel, and we have a right, we believe we have a right to be heard on this issue because it does attend to her rights going forward in terms of her case. I mean, this is her case.
I don't know that yes, it is her case, but what standing does she have to challenge a Rule 17 request related to documents produced in another case?
Because it specifically pertains to the prosecutor asking for information in her case to move forward, her consciousness of guilt, et cetera.
Those are evidentiary issues, counsel,
Correct, but we,
which can be dealt with at a later time. Those are what you're suggesting are evidentiary issues which are not before the court. All of it before the court is a Lamprin hearing on material sought from Mr. Kearney's case. The evidentiary issue will be dealt with at a later time.
I
This is
understand, and respectfully, I don't necessarily disagree that from an evidentiary standpoint or the disability standpoint, that can be dealt with at a later time, but the case should never be called without my client being here. She has a constitutional right to be here and to be heard, even on a Rule 17. The Commonwealth there's been Rule 17s for 2 years on this case, over and over and over, Your Honor. The Commonwealth has taken positions on Rule 17s. We've taken positions on Rule 17s dealing with third-party information, be it cell phones or text messages or whatever. I'm only asking that we be entitled to be heard on this issue, even though it deals with Mr. Kearney's phone and he's got legal representation. It also attends to Ms. Reed's rights, and it's her case number. And the reason the Commonwealth is trying to bring it in is to deal with her case, not Mr. Kearney's case. So she has to have a right to be heard.
Counsel, this motion's been pending for a week and a half now. I don't have any opposition from you. I don't have any submission from you.
We intended to submit oral argument as it attends to, and we're
And
prepared.
did you give the court notice of that?
We did to Justice Cannone,
Okay.
day before yesterday.
And what do you propose, counsel?
The only thing I propose, I don't want to interrupt Mr. Brennan's argument, but when Mr. Brennan is finished, Ms. Little is prepared to address the court on the very issues that Mr. Brennan is bringing up.
I'll take it under consideration. Is there any issue, counsel, with the current configuration, the court, such that that causes any issue for any of the parties?
No, absolutely not, Your Honor. Again, I will step back. I will be a little mouse in the room. I just need to be in the courtroom. And once Mr. Brennan is finished, before the court makes the ultimate ruling, and once Mr. Gradle is finished, I think we should be provided an opportunity to be heard.
I'll consider the request.
Okay.
Judge, I have no objection procedurally. The council wants to join in my file. That's an issue in terms of the filing. So, just put it
Thank
down.
you. Thank you,
Well,
Attorney.
Your Honor, I do object. Ms. Reed's counsel and Ms. Reed do not have standing for this motion. I don't believe they should be sitting at the table for this motion. It's a Rule 17 motion of third party. She has no privacy interest in these materials. She has no standing to object, and she's not a party on the Rule 17.
Thank you, ADA Brennan. She is a party in this case, and I'll allow her to sit at council table and to have representation, and I'll consider whether I'll hear from her counsel concerning the substance of the motion and her
Thank you, Your Honor.
considerations there
We
too.
appreciate the court accommodating us.
So, ADA Brennan, with the court's apologies for the interruptions, the crux of the issue, as I see it, with regard to relevancy and the Commonwealth's burden at this stage to show that the requested materials are relevant.
Oh, dish soap is on sale. We need it.
Yeah, I think we need ketchup too.
What's in there?
Not in the fridge?
Ketchup does not go in the
You
fridge.
playing. Ha 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 ha.
I'm not.
Download the Instacart app and save with flyer deals.
Two plus one is equal to 3. Super! Did you see that?
John O'Keefe to include but not limited to Matthew McCabe, Jennifer McCabe, Brian Albert.
Sorry, I was in the bathroom.
Colin Albert, Juliana Albert, Michael Proctor, Elizabeth Proctor. And so limited, including but not limited, would suggest any witnesses in the Commonwealth versus Karen Reed case. E is pictures or video depicting evidence of intimidation of a witness. So similarly to D. And F, data evidence disseminating data depicting evidence of intimidation of witnesses of those same people. And so D, E, and F are squarely on point and relevant to the Commonwealth versus Reed case. If there is probable cause to obtain a search warrant, believing that there is information of those 3 categories on those phones, then I believe we're entitled because we'll clearly have met our burden of proof, not only because a Rule 17 is that it's likely relevant, much less than probable cause, but because of all the attendant information that we've provided. There is...
Hey, Brennan, let me stop you again. Would any of those categories include communications from Mr. Kearney with counsel from Ms. Reed?
No, I think those would be privileged. Secondly, there are motions filed in this case, not Karen Reed case, it's Mr. Kearney's case. One is the Commonwealth's opposition to defendant's motion to suppress and to restrain any searching of a computer or telecommunications devices. This was filed by Special Prosecutor Cosgrove. And in that motion, on page 5, he notes that the 2 phones that I'm seeking information from have already been searched. And he also notes in the motion that there does not appear to be any attorney-client privilege materials. There is a second source as well, and that is in the Commonwealth versus Kearney case, docket number 53, Commonwealth revised proposal for examination of digital material seized. That's relative to the 4 phones that I'm not seeking. However, it's instructive because in that motion as well, it talks about the history, and it gives assurance that there are no attorney-client privilege communications in the 2 phones that I seek. And so, given the separate evidence that we have, and these are clearly witnesses in our case, And the admission by Ms. Reed herself, I do not have the video, but she was recently on an air broadcast on a documentary last night, the night before, and the night before. There are admissions that she was, in fact, providing information to Mr. Kearney. And what is notable is that she specifically reflects upon the consequence of Mr. Kearney's actions, which she helped fuel by providing this information and identifying the witnesses in her case. I do have a clip, if the court is interested, because it gives great depth and understanding to the intentions of the party in sharing this information. I have a clip available. If the court wants to hear it, I can play it for the court.
I don't think that's necessary, so I'll decline respectfully the offer, ADA Brennan. Thank you.
And so in light of the fact that this information was seized pursuant to a warrant of probable cause, in light of the proffer in the affidavit, in light of Ms. Reed's admissions of the sharing, and inevitably the obvious consequence to witnesses, this is relevant to conscience of guilt. The evidentiary basis is clear. I do not have access to this material if a Rule 17 is necessary. And again, I've filed the Rule 17 out of an abundance of caution to be beyond reproach. If it is not necessary, I will simply go and obtain the information on my own, but I think it's more prudent to have a court order. It's necessary before trial. I'd like to review the materials that are relevant, and I agree the scope should be limited to D, E, and F, not the entire phone. And those materials would be provided to Judge Cannoni in a motion in limine regarding conscience of guilt. Also, will dictate what witnesses we call at trial, which advance notice is important for both the Commonwealth and for the defense. It's in good faith. I provided both pleadings from Mr. Kearney's case, the search warrant, affidavit in support of the search warrant. I've offered videos of the admissions by Ms. Reed to the relationship. And so for those reasons, I ask you.
What the hell? Oh, of course.
Counsel.
Thank you very much, Your Honor. Good morning, Your Honor, counsel.
Morning.
Judge, this is a Lampron request, is the case, and I know you're familiar with it, Your Honor. The purpose of the court's focus here, Judge, is on preventing unwarranted harassment of witnesses and third parties.
Yep.
The focus in Lampron as well is avoiding unwarranted delays. So this search warrant was done back, I believe, in February of 2024.
Oh, for fuck's sake.
So here we are at the 11th hour, and the Commonwealth is throwing, last-minute bombs out. I happened to look at the Reed docket last night. It's amazing to me how many motions in limine are filed. The government's trying to try that case through motions in limine versus, the immediacy of a trial. It was my impression of that. So, we're now getting sucked into these motions here at the 11th hour.
Judge should stop him
And
from
in
doing
terms
that.
of a Lampron analysis, Your Honor, there's relevancy, evidentiary, meaning it has to be evidence. As you said, not potential relevance, but actual relevance.
There is actual relevance.
Not otherwise obtainable at trial. You can't prepare for trial without it. And most important, Judge, is that the application is made in good faith and not as a general fishing expedition. This is the ultimate fishing expedition, Your Honor.
Yeah.
And I want to go back. When this happened, Judge, we didn't have a dog in the fight back then. As far as my client and I knew, they were going after Ms. Reed for communications with my client on this witness intimidation issue. Well, counsel wants to tell you that, there was probable cause in a search warrant, but then they took it to a grand jury. So we're
Here we go with this
They
nonsense
had
again.
the two easiest forums you can have for a prosecutor: sitting in the judge's lobby, shooting the breeze with a search warrant affidavit in front of
He
you.
doesn't know what to do
nobody
with
else
himself
there.
if he can't just
And then they went
narrative
to
and
the
speculate.
lowest hanging
You,
fruit.
not me. When you say you, not me.
Right,
Counsel.
not you, Your Honor. And then they had the lowest hanging fruit you can get as a
You're a
prosecutor,
dumbass.
going to a grand jury
Insulting the judge.
without anybody else there, crafting the evidence in any sort of way they wanted to. And thankfully, and it doesn't happen very often anymore, but the grand jury said no. The grand jury said there is not probable cause. Again, the lowest hanging
Well, there is
fruit
now.
in our
Might not have
system.
been then.
They
But the
couldn't
fuck is now.
establish probable cause based on this information. And I remembered when this happened, just sort of not even so much representing Mr. Kearney, but just as a constitutionalist, as a person interested in the Constitution, as an attorney, I saw this I read the search warrant, out of the Herald or something.
Bullshit.
And
Riddle.
I was prompted to write this press release that I sent out about this exact issue. And I went back to it, I looked at it again this morning, and it really covers exactly what's going on here. And in that search warrant, Your Honor, it's very clear that the government just wrote a 30-page short story about its efforts to try to find and isolate, and you have it in there, right, to find and isolate communications. And the government wants to criminalize communications. And if you look at my press release, and I'll submit it, or I'm just going to read a few things from it. We have in this Commonwealth a very special provision in our own Constitution that Ms. Reed has the right to present all proofs. And she has the right to fight any way she wants and talk to anyone she wants and communicate with anyone she wants and say, hey, don't share this. Hey, keep this between us. That's her right, her constitutional right under the Massachusetts Declaration of Rights to present all proofs. So when the government cites that just as a bare proposition, she tried to keep this secret. She communicated with Aiden Carney. Then we're going to make this gargantuan leap that she's sharing the intent to intimidate witnesses.
She did.
So the whole thing is completely bereft of any evidentiary value, Your Honor. Just the notions that they put in the search warrant, and ultimately the fact that they tried to use it to get an indictment and failed. So that's why this has no evidentiary value.
Because they didn't get an
Relevancy
indictment.
is
It has no
zero, because
evidentiary value.
They can't put it into evidence.
Terrible argument.
And then further, Judge, as a practical matter,
Oh, please.
I looked at the docket. I spoke with counsel from the Reed matter. It's my understanding, and everyone's here and they can correct me if I'm wrong. The government agreed to not put anything in their case in chief relative to this issue about communicating with Mr.
different.
Carney and consciousness of guilt, unless it was quote unquote, the door was open, which of course is
Not the
sort of
same
a
thing.
proposition
Told you
that
guys
is,
the other day, it's not the
out in
same
the
thing.
ether, and that
Separate
ain't never going to happen in this case, Your Honor. And so that adds to the issue of whether this is evidentiary or not. The government's already backed off. The government got a search warrant filled with nothing but investigative pronouncements. We took a trip to California. We talked to this lady, and they were communicating. All they say is they were communicating. They don't say, hey, let's really get that person and let's get them off this and let's try to have that person not testify. Let's scare that person. Let's harass that person. There's no communication.
That's exactly
like that.
what you
They
guys
just have
do.
the fact of communications. And that's not evidentiary. That's not relevant. So, Judge, here,
Look at his face. He thinks it like
they just want to get in
Like an
Mr.
idiot.
Carney's phones. We're not concerned
They already
about
got
what's in Mr. Carney's
into his
phones.
phones.
We're concerned about their bizarre interpretation of the witness intimidation statute that they will try to graft onto any communications in our client's phone, in my client's phones, Your Honor. So there's a few more complicated things, Judge. I feel like you have it, but I just want the court to be
feel like
aware,
you have it, but
having
I'll
come
tell you
into
some
this
more.
case at this point. There's a pending motion to dismiss with Judge Doolin, basically
That's going
saying
to
that
happen.
all these witness intimidation allegations don't cut it under the Constitution, under the First
And it was
Amendment.
already
So
denied.
that's pending, number one. Number two, Judge, is this taint team issue. Counsel's doesn't have it right. Went to say that, oh, these first two phones, we already got into them. So the taint team covers everything, all of Mr. Carney's phones. So the fact that the state police snuck in
They didn't sneak in.
and forged ahead and searched some phones before the taint team could get set
There was
up
no taint team at that point.
should not inure to the benefit of this Commonwealth. And this
And
is
they had that right.
a firewall type of a case with respect to a
They had
special
that right until you
prosecutor
asked for a
on the
taint
one side and the Norfolk County DA's office on the other side. A Rule 17 motion is absolutely required here, Your Honor. That's the whole point of keeping this confidential and separate. So the Rule 17 territory is entirely appropriate, Your Honor. In terms of,
Counsel, what's the legal import of the pending motion to dismiss
Sure.
in
So-
Mr. Kearney's case?
Sure.
How does that change
It doesn't.
either the relevancy
It doesn't.
analysis or the
point.
evidentiary
It does
value analysis
It
in
doesn't.
this case that I must make in the Rule
doesn't.
17 context?
Sure. So we expect Judge Doolin to come back with a decision that says all of these communications,
You can expect
maybe they're
one.
distasteful, maybe they're
Doesn't matter what you
obnoxious, maybe we don't like them. They're all protected by the First Amendment.
No.
So let's look at the search warrant. They're looking for communications between Ms. Reed
The motion
and Mr. Carney.
This is
They don't
already
even have
denied.
that much. They don't
You just
have
pulled it.
quotes. They don't have communications. They just have the idea that Well, they communicated. The fact that they communicated cannot be a basis for a criminal investigation.
That's not what they
and it's
said
the
at all.
extraordinary
Okay.
step of getting into the phones. A couple of quotes on the cell phones, Judge, just to set the context.
No, don't let him do it, Your Honor. He's just spewing fucking nonsense for his little fucking mob.
This is what from Commonwealth versus Onyx White. That is a landmark case that involves the notion, and you know, the government is always pushing the envelope, Your Honor. That case was very dangerous. The government was trying to set up a state of the law where just because we all have cell phones in our back pocket, in almost every case, let's see in that cell phone whether they communicated
That
about
happens.
a crime.
That happens
And it
all the
would have
time.
been an unbelievable expansion of government power to search people's private information.
They had a
Thankfully, the
reason to
SJC
search
said,
us.
no,
And
you
they
need to have a
had
nexus
to.
between the phone and the crime. And they talked about,
They do.
they cited some other cases in terms of quotes about cell phones. Just two quick quotes, Your Honor. The cell phone is a repository of just about everything that is materially important to a possessor.
I missed like
Documents, messages,
4 minutes.
emails, notes,
I'm gonna go back
thoughts,
after
communications, photos,
in the very
loved
beginning.
ones, information involving loved ones. The court should not view lightly what the Commonwealth is seeking here. Cell searches would typically expose to the government far more than the most exhaustive
This,
search
I don't
of a
even know
home.
why he's arguing. This has
So,
nothing to
I
do with this.
appreciate that, counsel, but at the same time, the phone has been searched. The data has
Period.
been obtained by the Norfolk
Yep.
District Attorney's Office.
done.
It's in it's in 88, Special 88 Cosgrove's possession, custody, control.
That's right.
It's already been seized. 88 Brennan is looking now, it seems, for a very narrow subset of that information that does not contain the long list of materials that you just rattled off from the Onyx White case.
But it never should have happened. It never, the search.
It doesn't
never-
matter if
that
it shouldn't
issue
have
isn't
happened.
gone
It
forward.
did.
Counsel, that issue isn't before me. The issue before me is what he's looking for relevant?
Bradel
Right.
doesn't know.
What do they have? What do they have to set that up? They have the fact that they spoke, and the fact that they spoke is not evidentiary.
No.
It's not relevant.
Stop it.
If the fact that they spoke was the basis, we'd be at Onyx White.
It did.
We'd have the wrong
I did see that part.
decision in Onyx White, Your Honor, that just because people speak, the government gets to ferret around in their phones. It's a horrifying concept, Your
That's
Honor.
irrelevant
That's really
to
the
this.
crux of why I'm here. And the last thing I'll say,
He
Judge, is
just loves
that
viewing narrative.
the
has nothing to do
fact
with
that
it.
they got around the taint team we shouldn't just forget
You didn't
about
ask for the taint team.
This,
You didn't get
these
around it.
phones need to go back through the taint team if they want to look at them.
No.
And on the taint team issue, there's more litigation to be done where the
Go ahead, tell on him.
court already
Do it.
allowed scrutiny of the phones by a taint team for attorney-client privilege information.
That's right.
And my client at the time had many civil and other cases going on at the time.
Oh, wow.
So Attorney Cosgrove's statement, there's no attorney-client
Where is it?
privileged information in the phone is ridiculous. There's a ton of it. We're also
There's
asking
also
right
like-
now, Your
he's
arguing
arguing things that are completely irrelevant, and the judge
the
called him on
taint
it
team to
right after I
scrutinize
did.
the phones for, we're going to ask for husband-wife
Counsel,
communication.
you're not asking.
No, not
You
you.
can
I
ask
just
whatever
wanna
you
know what's
want.
out there. I just want to know
Relevant
what's
to
out
this.
there.
I
We're
understand.
asking for husband-wife communications. We're asking for that journalists
You're
source
not married
materials,
anymore.
of which there's a plethora.
So no, you don't
We're
get
asking
those.
that those be scrutinized by the
They're not
taint team.
married anymore.
And all that stuff be taken out. So the taint team issues are still in flux. You know, the fact that they did this, the court should deny this, Judge, just on the fact that this is an 11th hour
They're not
request.
going.
If you look at Lampron, it talks all about undue delay.
There's no delay.
They had this back in February of 24, and here
Not
we
a
are
delay.
now on the eve of trial on their case. So for all these reasons, Judge, we object. This is a gross invasion of privacy. It's a fishing expedition.
Sure.
There is no
Whatever you say, dude.
hook that they have to say, we will find something criminal in those phones. Thank you, Your Honor.
Yeah,
Thank
they
you,
do.
counsel. So, ADA Brennan, before I hear from you any further in response, I am going to hear from counsel for
Ugh.
the defendant in this case.
It's going to be Attorney Elizabeth Williams, Your Honor.
What if the lottery was on your phone?
I'm just don't understand why
real
they
tickets.
even allow
Real winners.
her attorney to say anything. This has nothing to do with her.
First, I just wanted to thank Your Honor for allowing us to be present and to be heard on this issue.
There's a lot to hide in his phone, Tricia. That's why.
Defense
A lot.
joins in Mr. Bradle's request in opposition to this Rule 17 motion. There's just two very brief points that I wanted to address that I don't believe were addressed by Attorney Cosgrove. Your Honor, if you take a look, Attorney Bradle, apologies, Your Honor. There are.
She is, I don't know why they're letting her argue this, because I don't think it's important, maybe. I
Your
don't
Honor,
know.
the Commonwealth's affidavit in support of the Rule 17 is facially deficient as to both elements 3 and 4 of Lampron. The Commonwealth does not include a single fact in the affidavit to show that it cannot properly prepare for trial without the production of this evidence. So just on that basis alone, the Rule 17 is deficient. That's the same with regard to element 4. If the court looks closely at the affidavit that was filed in support of the Rule 17 motion, the Commonwealth is required to show that this is not a fishing expedition. The Commonwealth, again, does not set forth a single fact or even a conclusory allegation as to element 4. And that's because the Commonwealth knows full well that a grand jury has already rejected.
Doesn't matter what a grand jury did. It's irrelevant whether it's evidentiary here.
Witness intimidation with Mr. Kearney.
I'll be back.
And on that basis, because it's facially deficient, this has to be denied. We therefore respectfully request that the court deny this Rule 17 motion.
Thank you, counsel. ADA Brennan, I'll hear from you in response briefly.
I think most importantly, the parties are conflating two issues. Whether there is probable cause or beyond a reasonable doubt to convict a person of intimidation of witness and the relevance to consciousness of guilt. It's two separate assessments. It is true there was a no bill, and it is true that there is litigation in Mr. Kearney's case, but these phones are in the possession of the district attorney's office. The information is available. It's been represented. There's no attorney-client privilege. There is nothing to slow down or stop the availability of the information. It is relevant for the judge in Commonwealth v. Reed to assess whether or not this information establishes consciousness of guilt. That is the issue, not the complaints or the concerns or the personal opinions, the constitutional prowess of Mr. Bradle. It is this reflective of consciousness of guilt?
Hey, Brennan, on that issue, on the consciousness of guilt issue, there was some suggestion, there was an agreement that the Commonwealth was not intending to pursue introduction of evidence concerning that issue unless...
That is not entirely accurate. There was a motion filed by the defense, and they were concerned that when they were cross-examining witnesses in this case, that at the past trial that I was not at, the witnesses then offered to the jury that they were being harassed by social media bloggers, suggesting at the behest of Ms. Reed. That is an entirely separate issue than consciousness of guilt. I agreed that unless the door is opened, a witness should not get up and talk about their state of mind and how they believe they were harassed. I agreed to that because I will instruct the witnesses unless the door is open and you have an invitation, that would be improper. Separately, a consciousness of guilt motion in limine, which I expect to file if it's viable based on the information, is an entirely different proposition. It's an entirely different proposition than opening the door to the state of mind. The consciousness of guilt has more to do with the conduct of Ms. Reed. Did she do something that reflects her consciousness of guilt to try to cover for the crimes that she's alleged to have committed? We know she was providing information, even protected information to Mr. Kearney. We know he was publicizing it, appearing at witnesses' homes and addresses. We know that the witnesses, whether it is a conviction on intimidation of witness or not, felt very intimidated. We know the mental anguish they suffered. The defendant, in our case, Ms. Reed, knows it as well, because if you do see the video, with a smile, she acknowledges the consequence of her actions and seems to encourage it impliedly. And so this evidence should be available to me. I should be able to assess it. I should be able to provide a motion to eliminate to Judge Cannoni if appropriate, and then she should decide the admissibility in the Commonwealth v. Karen Reed trial. Thank you.
Thank you, counsel. Folks, I believe I've heard all I need to hear. I will take this matter under advisement. I appreciate your your filings and your oral advocacy today, and I'll endeavor to get your response as soon as possible. Thank you.
Thank you.
It's been worn. Yes, and my teenage kids dinner. Yes, exactly. Right. Exactly. So if you want to, reupholstering is really expensive, right?
Yes, it is.
So if you
I'm trying to make a coffee. What happened? That, I mean, I heard it, but like that was it. That was just it. Like that was just it. I think we can go back a little to the beginning that we missed because I kind of want to see exactly what went down in the very, very beginning that we missed. What I don't understand is, are they still going to have any of the hearings for Karen today? Or did the judge approve their thing to put it off and then so they weren't going to do it today? Like, look at, okay, so maybe it's all the way. So it cuts in when he starts talking. I might have to go back to court TV to see. I know, right? What did just happen?
See any case law that specifically says under these circumstances, a Commonwealth lawyer is obligated to obtain a Rule 17 subpoena to pursue or obtain other information available in a separate case. But these are a bit unique in circumstances in that I am a specially appointed prosecutor to Karen Reed's case, Commonwealth versus Karen Reed, and Judge Cosgrove, special prosecutor Cosgrove, is specially appointed to Mr. Carney's case.
Hold on.
Because of that, I have from the beginning kept a very
no
strong
lie.
line of
So
separation
it looks like
between both
I mean, would they have?
Mr.
They would have
Carney's
ended it
case
if they weren't going to do
and
something.
Ms. Reed's case.
feel like.
I have only sought information that's been publicly available, and that's why my motion cites a search warrant, an affidavit in the search warrant.
Or it's on a
and
short
there are
break,
two
it
pleadings
says.
as well in my
So,
motion that are on
hold
the
on.
public docket.
I'm gonna go back to the
And so what I
beginning
learned
here.
is from my public reading and from watching hearings. And so what I know is that there are two
Mhm.
phones that were searched
On this one?
by Trooper Tully and is in the possession of the Norfolk County District Attorney's Office. And the information is relevant material to Karen Reed's case. The reason why it's
It does.
important and relevant is that separately, I possess information that establishes not only a relationship between Karen Reed and Mr. Carney, but a relationship in where information, some of it private, some of it suggestive grand jury minutes, was passed purposefully from Karen Reed to Mr. Carney. Originally, a third party was used, an intermediary, where allegedly Ms. Reed would send the information to the third party, would then be sent to
Counsel, let me stop you there. Has the name of the intermediary appeared in the public record?
Yeah.
I don't know that. I know that the attorneys are very well aware of that person's name. It may be, but I don't know that, and that's why I've refrained.
Let me ask you this, counsel. Does the name of the intermediary appear in Trooper Tully's affidavit, either in the substantially itself or in the addendum A?
I will need to re-review, but it very well may.
Well, that's a critical issue here with regard to the purported relevance of the data sought. Let me ask you this, Attorney Brennan. Have the extraction reports that have been requested been generated?
I understand they are available to Special Prosecutor Cosgrove and that they have the reports that have been generated.
Has the underlying data from the two phones in question been assembled?
I understand that it has. I cannot personally confirm because I have not asked to review it personally.
Do you know the volume of the underlying data?
I have no idea because I've purposely not asked to see it or ask questions about it.
Okay. Please elaborate on relevance as it relates to consciousness of guilt.
Yes. As Your Honor is aware, consciousness of guilt is a different standard than trying to prove a case of intimidation of a witness beyond a reasonable doubt.
Yep.
What we expect evidence will show separately and in Mr. Carney's phone is that there was a relationship between Karen Reed and Mr. Carney in which Ms. Reed would provide information indirectly to Mr. Carney. That information would then be reviewed by Mr. Carney, posted on social media, and consequently was used, we believe, allegedly, to intimidate and harass witnesses. In the search warrant itself, there is extraordinary detail on how Mr. Carney targeted witnesses in Ms. Reed's case with the express purpose, according to Mr. Carney, that this trial of Ms. Reed never go forward. We have a many-page affidavit that we have provided to the court. I can offer some of the most important parts if Your Honor would like.
Counsel, I don't think that's necessary. I've reviewed the affidavit in support of the search warrant thoroughly, and here's where I struggle. So the case law says the party seeking the data in question has to make a initial factual showing that it's relevant, not potentially relevant, relevant. That's the initial burden. So to demonstrate her alleged consciousness of guilt, defendants, don't the communications sought or the data related thereto have to only involve communications between Mr. Kearney and the defendant?
I'm not clear on your question, Your Honor.
How is anything beyond communications between Mr. Kearney and the defendant in this case relevant to her consciousness of guilt? Here's my issue. You have sought a broad swath of data. We don't know the volume yet, but it is from the addendum A to Trooper Tully's affidavit in support of the search warrant. It calls for data including calendars, alerts, reminders, notes, text messages, pictures, or videos from April 1st, 2023 through and including October 5th, 2023, 7 months of material that ostensibly could include everything from meeting notes, calendar invites, texts, videos, things that have absolutely nothing to do with communications between Mr. Kearney and the defendant. So how can the Commonwealth make the threshold show that those are relevant?
First, this is a ruling with Mr. Kearney, so I'm asking that Mr. Kearney and his attorney be at the table. I'm not sure why we're being joined by Ms. Reed's team, unless they have standing in this.
Which I don't believe they did, really.
Proceeding.
They didn't.
Can you state your name for the record, please?
Of course, I'm sorry. Alan Jackson on behalf of. We didn't see which case number was called for this Rule 17, if it was Mr. Kearney's case number or if it was Ms. Reed's case number. We were told, or at least our impression in talking to Judge Cannoni, was if this issue was going to be on our case number. I specifically asked that question at sidebar the day before yesterday, and she said, yes, the Rule 17 Mr. Brennan's dealing with is on Ms. Reed's case number as it pertains to her rights. And the issue
is counsel. Counsel, it has been called in this case, but I don't know that your client has standing with regard to this particular issue.
So the case number, I just want to make sure procedurally I'm on the same page as the court and Mr. Brennan and Mr. Kearney. The case number that was called was the Commonwealth versus Karen Reed.
00117.
Okay.
That's correct.
Then she needed to be here, and she has a right to counsel, and we have a right, we believe we have a right to be heard on this issue because it does attend to her rights going forward in terms of her case. I mean, this is her case.
I don't know that that's, yes, it is her case, but what standing does she have to challenge a Rule 17 request related to documents produced in another case?
Because it specifically pertains to the prosecutor asking for information in her case to move forward, her consciousness of guilt, etc.
Those are evidentiary issues, counsel.
Correct, but we,
which can be dealt with at a later time. Those are, what you're suggesting are evidentiary issues which are not before the court. All of it before the court is a Lamprin hearing on material sought from Mr. Kearney's case. The evidentiary issue will be dealt with at a later time.
I understand, and respectfully, I don't necessarily disagree that from an evidentiary standpoint or the admissibility standpoint, that can be dealt with at a later time. But the case should never be called without my client being here.
Right,
she has a constitutional right to be here and to be heard, even on a Rule 17. The Commonwealth there's been Rule 17s for 2 years on this case, over and over and over, Your Honor. The Commonwealth has taken positions on Rule 17s. We've taken positions on Rule 17s dealing with third-party information, be it cell phones or text messages or whatever. I'm only asking that we be entitled to be heard on this issue, even though it deals with Mr. Kearney's phone and he's got legal representation. It also attends to Ms. Reed's rights, and it's her case number. And the reason the Commonwealth is trying to bring it in is to deal with her case, not Mr. Kearney's case. So she has to have a right to be heard.
Counsel, this motion's been pending for a week and a half now. I don't have any opposition from you. I don't have any submission from you.
We intended to submit
but you didn't.
as it attends to, and we're prepared.
Did you give the court
She doesn't
notice
have
of that?
standing because
It's
it's
to Justice Canoa.
related to communications, getting Aiden's communications,
And what do
not
you
hers. It would
propose,
be an
counsel?
The
evidentiary
only thing I
issue that
propose-
he would
I
bring
don't
up.
interrupt Mr. Brennan's argument, but
for that.
Mr. Brennan is
Nothing.
finished. Ms. Little
This
is
is
prepared to address the court on the very issues that Mr. Brennan is bringing up.
I'll take it under consideration. Is there any issue, counsel, with the current configuration, the court, such that that causes any issue for any of the parties?
No, absolutely not, Your Honor. Again, I will step back. I will be a little mouse in the room. I just need to be in the courtroom. And once Mr. Brennan is finished, before the court makes its ultimate ruling, and once Mr. Gradle is finished, I think we should be provided an opportunity to be heard.
I'll consider the request.
Okay.
Judge, I have no objection procedurally.
No, it's only evidentiary. Like, so I'll explain it after. Hold on.
Thank you. Thank you,
Well,
Attorney.
Your Honor, I do object. Ms. Reed's counsel and Ms. Reed do not have standing for this motion. I don't believe they should be sitting at the table for this motion. It's a Rule 17 motion of third party. She has no privacy interest in these materials. She has no standing to object, and she's not a party on the Rule 17.
Thank you, ADA Brennan. She is a party in this case, and I'll allow her to sit at counsel table and to have representation, and I'll consider whether I'll hear from her counsel concerning the substance of the motion and her
Thank you, Your Honor.
considerations there
We
too.
appreciate the court accommodating us.
So, ADA Brennan, with the court's apologies for the interruptions, the crux of the issue, as I see it,
It looks like a
with
fool. Look at him
regard to
smirking. Like, look
relevancy
at idiot, dude.
and the Commonwealth's burden at this stage to show that the requested materials are relevant involves the breadth of what has been requested. And perhaps you could speak to that and how materials that would be swept into this request are in fact relevant.
I understand the court's concern, and I've looked at Addendum A as well, and I've identified the information I think is relevant to the Rule 17 subpoena. So I agree the Rule 17 subpoena speaks broadly, but what is relevant is sections D, E, and F. Now, mindful that there was probable cause to obtain this warrant, which is a far stronger standard than what is needed for a Rule 17 motion.
Counsel, pardon me, did you say D, E, and F of Addendum A?
Yes. So if we look at Section D, there was probable cause granted for communications between Mr. Kearney and any witness or family members of witnesses involved in the murder of John O'Keefe to include but not limited to Matthew McCabe, Jennifer McCabe, Brian Albert, Christopher Albert, Colin Albert, Juliana Albert, Michael Proctor, Elizabeth Proctor. And so limited, including but not limited, would suggest any witnesses in the Commonwealth versus Karen Reed case. E is pictures or video depicting evidence of intimidation of a witness. So similarly to D. And F, data evidence disseminating data depicting evidence of intimidation of witnesses of those same people. And so D, E, and F are squarely on point and relevant to the Commonwealth versus Reed case. If there is probable cause to obtain a search warrant, believing that there is information of those three categories on those phones, then I believe we're entitled because we'll clearly have met our burden of proof, not only because a Rule 17 is that it's likely relevant, much less than probable cause, but because of all the attendant information that we've provided. There is...
Hey, Brennan, let me stop you again. Would any of those categories include communications from Mr. Kearney with counsel for Ms. Reed?
No, I think those would be privileged. Secondly, there are motions filed in this case.
I don't think those are privileged because he's not their client.
Karen Reed case, Mr. Kearney's case. One is the Commonwealth's opposition to defendant's motion to suppress and to restrain any searching of a computer or telecommunications devices. This was filed by Special Prosecutor Cosgrove. And in that motion, on page 5, he notes that the two phones that I'm seeking information from have already been searched. And he also notes in the motion that there does not appear to be any attorney-client privilege materials. There is a second source as well, and that is in the Commonwealth versus Kearney case, docket number 53, Commonwealth revised proposal for examination of digital material seized. That's relative to the 4 phones that I'm not seeking. However, it's instructive because in that motion as well, it talks about the history, and it gives assurance that there are no attorney-client privilege communications in the 2 phones that I seek. And so, given the separate evidence that we have, and these are clearly witnesses in our case, and the admission by Ms. Reed herself, I do not have the video, but she was recently on an aired broadcast on a documentary last night, the night before, and the night before. There are admissions that she was, in fact, providing information to Mr. Kearney.
Yep.
And what is notable is that she specifically reflects upon the consequence of Mr. Kearney's actions, which she helped fuel by providing this information and identifying the witnesses in her case. I do have a clip, if the court is interested, because it gives great depth and understanding to the intentions of the party in sharing this information. I have a clip available. If the court wants to hear it, I can play it for the court.
I don't think that's necessary, so I'll decline respectfully the offer, ADA Brennan. Thank you.
And so in light of the fact
Decline
that
the
this
offer,
information was seized pursuant to a warrant,
it's
for probable
relevant
cause,
to this.
in light of the proffer
So why?
in the affidavit, in light of Ms. Reed's admissions of the sharing, and inevitably the obvious consequence to witnesses, this is relevant to conscience of guilt. The evidentiary basis is clear. I do not have access to this material if a Rule 17 is necessary. And again, I've filed the Rule 17 out of an abundance of caution to be beyond reproach. If it is not necessary, I will simply go and obtain the information on my own, but I think it's more prudent to have a court order. It's necessary before trial. I'd like to review the materials that are relevant, and I agree the scope should be limited to
I'm told it's
D,
starting
E,
over
and
there,
F,
so
not
hold
the
on, guys.
entire phone.
We'll come
And
back to
those
this.
materials would be provided to Judge
we watched
Canoni in a
already.
motion in
Go
limine
back to the
regarding
live.
conscience. I understand the trial strategy for...
Back it up just a smidgen, like a minute ago or so. What the hell? Come on, man. Wait, okay. Here we go. All right. Yeah, no worries. While we're waiting, if anybody wants to give a like, a subscribe, a share, if you want to donate to the channel, that would help us. We're a small channel. We only run on our donations from you guys. I read them when I get them. The information is down the bottom here: Cash App, Venmo, PayPal. It's very much appreciated. There's a ticker that runs at the bottom of the screen that shows it. It's right at the bottom there. Make sure this is unmuted. Yeah, it's unmuted. So
Come
this.
on in, give your attendance, you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
22117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves for the record, starting with the Commonwealth?
Good morning, Your Honor. Barbara Blackman for the Commonwealth.
Good morning, Mr. McLaughlin.
Evan for the Commonwealth. Good morning, Your Honor.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson from Ms. Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Good morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr. Alessi.
Maybe somebody else has Apple Pay who can send
Good
me
morning,
Reed.
Ms. Giannetti. Good morning, Ms. Reed. All right, so we have a lot to cover this morning, but what I want to start
have an
with,
iPhone,
I was
so.
just handed a couple of things too that I'm going to need some time to read. What I'd like to start with is paper 613 filed yesterday. Defendants assented to motion to continue trial date to a date on or after April 25th. Who's going to argue that? Because just because it's an assented to motion does not mean it's not likely going to happen. So I need to hear argument on why I should do this.
I'll address the court with the court's permission.
Yes.
As I indicated to the court the day before yesterday, there is an issue, a very ripe issue that is currently pending before the First Circuit. We believe very strongly that if the First Circuit were to take some action as to count 1 and count 3, just to reiterate what I've already said, but I can sort of clarify it and narrow it down. If the court were to take some action on counts 1 and 3, which is currently before the First Circuit, for instance, if it were to be remanded for either dismissal or something else, additional hearings, etc., then that puts the entire case in jeopardy. Once the jury ultimately is impaneled and thereafter sworn, jeopardy will attach. There will be, if in fact there is action taken on count 1 and count 3, we will be in a position where we will seek a mistrial. Jeopardy will have attached. She will be held once in jeopardy on count 1, 2, and 3, and we believe that puts the entire case in peril. The case that we're defending right now, very clearly, is a murder case, ultimately, along with
all three indictments, correct? You're defending all 3.
But it starts with murder. That's the sun rises and falls on a murder charge. And there's also vehicular manslaughter, and then there's the leaving the scene, count 3, and the subordinate counts beneath count 2 as well. That's a very different jury and a very different trial strategy than simply count 2, if we were to be defending count 2 or it's the subordinate charges. So I think it puts the case in jeopardy if we do not have at least some time for the First Circuit to act and determine whether or not it wishes to act on counts 1 and 3. Hence, that's why I suggested to the court the other day that it might be more prudent and less perilous for the case if we were to put this case over for at least a few weeks. We've spoken to the Commonwealth, and the Commonwealth tends to agree that that probably is the better practice. And we've asked for the court to extend the beginning of the trial to April 25th, which is about a 3.5 week continuance. And I'll submit.
All right. Does the Commonwealth want to be heard on this?
Your Honor, the Commonwealth is relying on advice of appellate counsel.
Yep.
I don't contest any of the defense's perspective for wanting continuance. I think the Commonwealth's perspective is different, but not adverse. The concern is that this case in the federal court gets delayed for an extraordinarily long period of time, and we have an interest in this case going to trial as soon as possible.
Yep.
There is an expedited scheduling order, which could hopefully imply that there's going to be quick progress in the federal court, but we don't directly communicate with them or have any control. Our hope is that if there is a short continuance, it accommodates the defense's concerns. I understand the trial strategy for different charges is somewhat different, but most importantly for the Commonwealth, the hope is that it sets a benchmark that will allow the First Circuit to resolve the petition, or if they're going to allow oral argument, a benchmark to do it quickly. And so really the primary motive for agreeing to the defense request is that we hope by offering a short continuance, the federal court will act more quickly and that we can have this trial in April.
Okay. Well, I'm not going to grant the motion. All right. We have jurors coming in that were summoned months ago. I called the jury commissioner yesterday and asked how long it would take to get the right numbers that we were able to get starting April 1st. At a minimum, 10 weeks.
No.
I'm not going to do that. What I will do is we'll start impaneling on April 1st. It will likely take a while. If we get a jury before April 25th, I'll rehear you on your motion. We won't swear the jury because obviously that's when jeopardy attaches. And we'll take it from there, but we will start April 1st with impanelment.
Thank you, Your Honor.
Okay. All right, so let's go to
There's
the
no double
next
jeopardy and it'll
motion,
be
then we'll go
denied
back
again
to doing them
anyway.
somewhat in order. Commonwealth's motion for a buffer zone. Jimmy, do you have an extra copy of what you just handed me? Because I don't know where I put it.
Can get one.
I have it here somewhere. I'll find it.
I can get
So we did hear from people this morning. I know you all have, I have it. I have it, Jim.
Thank you.
I think Mr. McDermott gave you a copy of, I guess, what local merchants have requested.
We received it, Your Honor. Thank you.
Okay. All right, so I'll hear the Commonwealth on your buffer zone motion.
Your Honor, the Commonwealth's primary concern is the sanctity of the jury and the jury process. We are concerned based on past reports and information that noise, interruption, and other uncontrollable events can potentially impact the jury's consideration in this case. They should be free from outside influence so it does not in any way oppress or push them in any direction, either way in this case. The courthouse is very close to the public areas where people congregate. It's been reported that during the trial, the jury would be able to hear outside noise and influences, not just honking of horns, but other types of noise that could be influential, intimidating, concerning. And so we've proposed what I think is reasonable and minimal recommendations to the court to move certain parts of the buffer zone, especially on the left side of the courthouse, where there seems to be a bit of attention, noise, and potential adverse influence of the jury.
And that's the same area that these merchants are talking about?
I've read that this morning, not being wholly familiar with the Dedham area. It seems that is one of their concerns. I think they mentioned an open market. In my memory from coming by on other cases at other times, there appears to be open markets in that area. And so if that's influencing their business, that is a separate but related concern that they have expressed to the court. And I do think that the court should be sensitive to the community's concerns. But importantly, that closeness and that amount of volume and influence on the jury, I think, can affect the sanctity of the jury. I don't think it is a strong imposition to consider the streets that have been identified in our buffer zone motion and have the buffer zone include limitations to those certain streets. And I think that will potentially help some of the outside impact and adverse influence on the jury.
I did, Anna. I read it during stream. You must have
There's a
just
portion
bounced
of your
out when I
motion that I
did.
disagree with. Do you want to be heard on it? About the court enforcing or enforcing the buffer zone?
I don't believe the court has authority, nor should it be upon the court to enforce anything. I think law enforcement should enforce the laws and regulations as law enforcement sees fit. And so I don't think that burden should be imposed upon the court.
Thank you. All right, with that, does the defense object to the buffer zone?
We take that position.
Okay. All right, I'll take this under advisement. I have to figure out exactly how far this is, and I have not yet had a chance to read and consider today's email from the merchants. Okay. Yes.
Can I just have this marked for
Jane's
identification?
businesses sent an email.
Identification. And from the record, that came from the Dedham Square Circle, the organization that
It's
runs
not
the
complicated,
Dedham
I know, Anna.
Farmers Market.
But do you have to punch in the person's email or the person's phone number, Ren,
Thank you. So
when you send it to them?
we can talk about the witness list when we talk about impanelment, when we really have the heart of the final trial conference. But I do need at least cities and towns from these witnesses. Neither side gave them to me on the civilian witnesses, so.
There's a reason.
And there's a lot of overlap, and you'll have to fix
That's
that for any final trial conference report anyways. All right.
The businesses that are all along that strip next to the courthouse is in like the center of town. So there's businesses right there that they're, these people are blocking
that one issue,
the way.
just briefly.
Which one issue? The witness list, okay?
Yes, we did turn over our witness list along with the information that's required under the new rules, which includes, telephone numbers, addresses. We gave that directly to the Commonwealth. We did not file that publicly.
Okay.
We'll happily add the towns for the court. But I would note that the Commonwealth has not yet turned over that information that's required under the new rules. I believe they put a footnote on their witness list. I think, they can't shield themselves from their discovery obligations. It's mandatory under the rules. We'd ask that they comply with, the requirement that they provide us contact information for their witnesses.
So there is a footnote. I'll hear you, Mr. Brennan.
PayPal actually has a website. You don't even need the app. I don't actually use the app either. It's on my phone. I'm pretty sure it's full. I have like memory full. I can't even put another app on my phone unless I delete one. I need like one of those little SD cards to put like extra memory and put all the other stuff
motion notes that the
onto it
Commonwealth
on my
rules to be
phone.
partially exempt from Rule 14 because of the past history of perceived harassment and intimidation of witnesses, which the Commonwealth believes is ongoing.
Yes, Hank. Yes.
I think a potential resolution to this to comply with Rule 14 is that we be allowed to provide it to the attorneys under seal. I think that is protecting the interests of the Commonwealth and the witnesses from.
I don't have a problem with that. I still need cities and towns.
Of course.
Okay.
Yeah.
My email.
All right.
Which one?
Thank you. So we will start with it's paper 593. The Commonwealth's response is paper 610. Defendant's motion eliminate to allow evidence of lack of bias. Who's arguing that for the Commonwealth?
The Commonwealth first, Your Honor.
Oh, it's defendant's motion. The Commonwealth opposed it.
You had asked who's arguing that for the Commonwealth. That's why
I'm sorry, defense motion. Okay,
that's fine.
sorry, I apologize.
I could go first if you'd like.
Excuse me?
I could go first if you'd like, whatever.
I'm fine with him going first if you'd like.
Okay.
I think the heart of this motion is that the defense would like to introduce the ARCA witnesses as witnesses that were employed by the federal government.
Yep.
I think the reason for that is it creates the image or the projection that they are independent at the time they did their assessment and at the time they wrote the report. And then subsequently being employed by the defense has no impact on their objectivity at the time they did their investigation and report. I think this would be an unfair proposition for a number of reasons. It would undermine Rule 403. It would cause a trial within a trial.
It was my email she was talking about.
As we stand here today, the Commonwealth does not have a clear answer why this investigation was initiated, what the purpose of it truly was, the scope of it. We don't know every witness that may have gone before the grand jury. We do not know of all the communications between the federal government and different parties, including witnesses. We will, I expect, never have truly a full accounting of the relationship between the United States Attorney's Office and ARCA and what, if any, impact the defense had on ARCA witnesses at the time they did the investigation. What we know is it was a comprehensive investigation. We know that a number of experts were retained by the federal government, including the ARCA witnesses. What we also know is that there was an inquiry lodged by the defendant to the federal government to investigate her situation, her case. What we know is that the defense had the opportunity to provide information to the federal government advocating for their perspective on the case, including the specific perspective of Ms. Reed. We also know the Commonwealth was unaware of this initiation and engagement and had no input whatsoever. What we know is that the ARCA witnesses were supposedly tasked to conduct an independent investigation, and they were given materials. We do not know who decided what materials to give them. We do not know what materials in totality they viewed. We know many of the materials that they weren't given. And so clearly there is an undefined relationship between the defense and the United States Attorney's Office around this time of this investigation. And we subsequently learned that there was a continued relationship. And so today, as we sit here, we really don't know. What we know is ARCA listed materials that they reviewed that came from our discovery that we didn't provide. What we know is there was materials that they didn't review that were inculpatory. And so that's why we began by asking for discovery. We filed an extensive motion for discovery that the court allowed. It still hasn't been complied with. Perhaps some of it through no fault of the defense, because I don't think they will be able to comply with much of it. Other Rule 14 discovery obligations have not been complied with. We've received no information since that production on February 13th, nothing. And we know just inherently from that information that there is more. There are more communications, there's more interaction. And so it would be misleading to have ARCA witnesses get on the stand and then suggest that they were independently hired by the federal government and all of their attempts and efforts in report was wholly and entirely objective. Just to give one point that emphasizes the concern, the ARCA witnesses were never given information about DNA. And yet when they testified, one of the witnesses tried to address the issue of DNA because it was hurtful to their position. In their report, they say one of the reasons why they believe that there was no impact between the car and Mr. O'Keefe is because there was no DNA. Well, in fact, there was. There was DNA, and separately, there was a hair, Mr. O'Keefe's hair. And so we know they didn't have all of the inculpatory information, and then the question still remains, how did they learn of that? How did they learn of that information before cross-examination? And so I think what is most appropriate before Your Honor makes a decision on the so-called objectivity of these witnesses is they should come into court before trial, well before trial, and they should answer questions about their directives from the United States Attorney's Office. They should answer questions about the materials they received. They should answer questions about what they were told or what they knew about the case. They should answer questions about all of their correspondence with the defense, including phone calls, emails, text messages. All that should be produced. It's not a Lanigan hearing where I question their qualifications, but if we're truly going to think about presenting them as objective witnesses, they truly should be objective. And I think if we have an opportunity to question these witnesses, we will learn much more about the relationship. Inevitably, even if the ARCA witnesses come in to be questioned, as they should well before trial, in my opinion, we do not have the opportunity to question the United States Attorney's Office. We're resigned to TUI letters, which inevitably have been unhelpful. And so I think it sets a bad playing ground to have them get up and say they were hired by the federal government, because then the Commonwealth will be inclined to explain the inculpatory evidence, the role of the federal government, the limitations of the federal government, the fact that the federal government has closed this entire case in all related investigations, which implies something quite the opposite of what the defense would like to propose. And so in a vacuum, it would be misleading. I think what the court ultimately should do is they should present these witnesses as they did at the first trial. They were hired independently. And then subsequent to that, the defense retain them if that's what they chose to do. We still don't know that because we don't have any Rule 14 discovery. And inevitably at trial, part of the credibility issue will be the information that they considered and the limitations on it, and ask them why they didn't ask for more information or why they didn't receive more information. Notably, we still don't have an answer to Mr. Klein, who was the third biomechanic person involved. And
Is his name on the witness list?
I haven't seen it on the witness list.
No, Your Honor.
And we still don't know why the defense chose to call 2 of 3. As you noted, that report is vague. And so it doesn't identify or articulate which witness did what. So it's impossible for me to imagine how you would choose 2 of 3 of those witnesses. But more importantly, you can't effectively cross-examine a witness because, as we saw from the second witness, Dr. Rentschler, when he disputed DNA, which we don't know where the source of that came from, he is not held to the opinion in the report saying that we would have found DNA. He can simply defer and say that was somebody else. That could have been Mr. Klein, could have been Mr. Wolf. We don't know. So that report really is quite unhelpful. And I think we need answers to these questions before any of these witnesses testify. And I do not want to be moving during trial to exclude the defense witnesses for failure to comply, but we haven't seen compliance, and I don't think we will. So my suggestion is to follow the protocol of the last trial, but before that, these witnesses should be brought in so that we can obtain actual records, not just ask them the questions and rely on their word. I think based on their past performances, that's insufficient. I think we should have a right to the records to demonstrate the relationship.
Mr. Yannetti?
Thank you, Your Honor. Your Honor, the Commonwealth and the defense certainly have opposite arguments when it comes to what the jury should be allowed to hear about how the ARCA witnesses became involved in this case. Mr. Brennan speaks about the heart of our motion. The heart of our motion is that the Commonwealth wants to hide the truth from the jury. The defense wants the jury to know the truth.
No, the defense wants to lie to the jury and say they're independent when they're not.
In the first trial, this court disallowed the ARCA witnesses from testifying about who hired them.
Or prejudice the jury.
We were therefore forced to ask oblique questions, trying to show the jury that we didn't hire them.
Doesn't matter.
That we didn't provide them with information.
I'll be
that
back,
we
guys.
didn't influence their opinions and conclusions. But we weren't allowed to tell the jury that the Department of Justice, the U.S. Attorney's Office, hired them. So the jury was left to speculate about how they became involved. I think the court will agree that it's ironic in a way that the court excluded mention of the Department of Justice and the U.S. Attorney's Office because the court rightly did not want the jury to speculate about a federal investigation. But by excluding mention of the federal government having retained ARCA, the jury was left to speculate incorrectly about how they became involved.
They were also instructed more than once not to speculate, right?
But the point of the fact of the matter is, Your Honor, they did speculate. At least one juror thought that ARCA was hired by Ms. Reed's car insurance or home insurance company. And think about the implications of that. If Ms. Reed's insurance company had hired ARCA, they would have had a motive to absolve Ms. Reed of responsibility. That clearly would have adversely affected their credibility in the eyes of the jury, and unfairly so.
Let me ask you a question. If I allow, and I'd be very surprised if I did, mention that this was a federal grand jury and that the federal, how does that not open the door to all the testimony that Mr. Brennan just brought up that he'd be able to get into?
Okay, so first of all, and this is later in my argument, we're not asking.
So no, could you answer that now, and then I'll let you say everything.
Your Honor.
Oh, you just said it's late. Hold on, you just said it's later in the argument.
I know, but I said you interrupted me, and I was just about to say, but I'll address it now.
Okay.
We are not asking that the jury be told that there is or ever was a federal investigation. The that phrase, federal investigation, never has to be part of this trial. We're only asking that they be told that the Department of Justice or the U.S. Attorney's Office hired these witnesses. That's it. We don't have to speculate about an investigation, whether there was an investigation, whether there was a federal grand jury, what that grand jury did, what that grand jury considered, nothing. That's not what we're asking. And the problem here is that without knowing that the Department of Justice or the U.S. Attorney's Office retained ARCA, the jury's left to speculate about how they became involved, and it all inures to my clients, to prejudice my client. Thinking that they were potentially hired by an insurance company of Ms. Reed really perverts the truth in this case. It's unfair to my client, and it's the opposite of the truth. There was another juror that speculated that the ARCA witnesses were just attention seekers, looking to make a name for themselves in a high-profile case. That's also the furthest thing from the truth. They had never heard of this case before the Department of Justice called them. That's how the Department of Justice wanted it. They wanted clean experts who would take a sober and strictly scientific look at the evidence. The federal prosecutors did not want them to be tainted by news reports or opinion pieces. And recall that the Commonwealth attacked ARCA on cross-examination for the discovery that they were not provided. That was patently unfair. ARCA should have been allowed to explain why they were given what they were given and who gave it to them. The inference is, and the Commonwealth suggested, that it was the defense that was playing hide the ball, when that inference is, again, the furthest thing from the truth. In terms of the information that the federal government got, Mr. Brennan engages in a ton of speculation about what happened or didn't happen based on nothing. There's no affidavit to establish any of that. I will tell the court that I received a subpoena for my entire file from the federal government, and I complied with that subpoena. We had nothing to hide. We provided everything that the Commonwealth provided to us, to the federal government. They chose what to give ARCA or what not to give ARCA. And they did that again to preserve the scientific integrity of their opinion. So, again, we're just asking that ARCA should be allowed to testify that they were hired by the federal government to prevent speculation about who hired them or why they became involved in the case. If the issue is we don't want the jury to speculate, the way to do that is to tell them the truth. We did not hire them. We did not influence their opinions. We didn't even know that they existed until that TUI request was complied with, and all of a sudden it was revealed to us that the federal government had hired these ARCA witnesses. And we read that information at the very same time that the Commonwealth read that information. Those witnesses, importantly, were available to be called by both sides. The Commonwealth chose not to speak to them. The Commonwealth chose not to contact them because the information was exculpatory. The jury should not be left with the impression that Karen Reed or the defense team had anything to do with hiring them or with their conclusions and opinions. The conclusions and opinions were revealed to us at the same time, and the court should guard against rank speculation. Mr. Brennan's other arguments about what they were provided or what the relationship was or what the understanding was, that's all cross-examination material. He's free to explore whatever he wants on cross-examination. So with that, Your Honor, we would ask the court to issue a ruling that does not mislead the jury about how ARCA came into the case.
Okay. Any follow-up?
Yes. Respectfully, the Commonwealth does not look to hide the truth. The reality is, if the jury is going to hear information, they should hear the entire truth, not a version or a slice of it, not one advocate's side of the truth, the whole truth. And if we interject that these witnesses were hired by the federal government and the jury's entitled to hear the whole truth, then they should know the motivations behind the hiring, the input from the defense team prior to their decisions, and what, if anything, they considered, and what their directive was. We don't have any materials from the federal government regarding direction, scope, purpose. We have nothing. Now, I didn't know that Attorney Iannetti's file was subpoenaed. That's new to me. Perhaps the Commonwealth knew. I've never heard that before. I don't know how the defense knows what the federal prosecutors wanted. They've never discussed that with us. We don't have that type of relationship with the federal prosecution in this case or their investigation. We didn't have any interaction, not because we chose to hide from exculpatory evidence, so we were hiding from the truth. We weren't invited. We didn't know. Now, I hear now that Mr. Iannetti's file was subpoenaed and information, whatever it was, his entire file was given to the federal government and they chose whatever they chose. This report by ARCA was produced by letter February 12, 2024. We know from at least some of the materials we got, there's a document from Attorney Iannetti on March 29, 2023, describing his client's best memories of events, a number of pages talking about the case. So there clearly is a relationship that we are not privy to. I'm not casting aspersions or trying to suggest there was anything improper about the relationship. I'm not suggesting that, but there was obviously a relationship between the parties that the Commonwealth was not involved in. And so we can't take a fraction of something and say we present them as independent witnesses when there was a purpose, there was an agenda, and it wasn't in the Commonwealth's interest, obviously. The ability to cross-examine a witness is only as good as the evidence information you have. As you've seen from the ARCA witnesses, from my opinion, my perspective, respectfully, is when they answered questions, perhaps it was not perjury, but it was quite misleading, suggesting no relationship with the defense, talking about DNA with no DNA evidence. I do not think that cross-examining a witness, you should consider the witness a trustworthy guide unless they've established their credibility. I don't see that in these transcripts. So I will need materials to hold them in check and to hold them accountable for whatever it is their bias. And so simply cross-examining aimlessly is totally ineffective. It's a recipe for disaster, and that's not the type of examination we're going to engage in. If we're going to tell the whole truth, it has to be the whole truth. And I think that becomes a dangerous game. There'll be an entire trial trying to advocate influence or no undue influence with these witnesses. It's unnecessary. It can be resolved through questioning these witnesses prior to trial and following the same protocol you did last time.
All right. So if the defense intends to call the ARCA witnesses, we need to have a voir dire next week. All right. So we're going to move on. I'll take this under advisement.
Can I just ask the parameters of that voir dire, the purpose of that voir dire?
Unless Rule 14 is complied with, it will be for the Rule 14 information. We can discuss this later. Let's move on, and I'll hear any objections later. All right, so the next motion is the defendant's motion for stating grounds for objections. I'll hear you on that, Mr. Iannetti.
Okay, I'm going to throw in a fuck you, David Iannetti. Fuck you on behalf of every insurance adjuster in the fucking country. Fuck you.
Actually makes the argument, Judge, but
okay.
During the last trial, as a result of our inability to state in one or two words the basis for an objection, we had to go to sidebar far more often than we'd like to. And we're also conscious of the fact that we have a jury sitting for weeks at a time away from their families, away from their jobs, and any sort of view that one side may be delaying the trial could engender some hostility from the jury. So, there were many times during the trial, I won't speak for my co-counsel, I'll speak for myself, where an objection was made. I had no idea what the basis of the objection was. And the court made a ruling on that objection. And I had no idea what the court's basis for the ruling was. We would go to sidebar, and the first thing the court would ask the Commonwealth was, what's the basis for your objection?
To make a record at that point.
Oh, I understand, but it's, what's the basis for your objection? If it were that obvious that it could be ruled in open court, we should have known the basis for the objection. I didn't know
I
it.
agree with that.
And
You
I'm-
should have known the basis of the objection.
Well, I'm hearing it for the first time at sidebar. There were objections made that I thought had no basis in the law or.
I don't believe for a second he doesn't know what he did wrong every time he got called to that bench.
This will avoid us having to go to sidebar multiple times. There were times when we had to sort of pick and choose when we went to sidebar because, again, we didn't want to engender hostility from the jury. My motion also points out, Your Honor, there's at least one case that talks about how an objection could be potentially waived if it is not stated with particularity. We think that this would, and look, different judges have different opinions regarding this. I've been in front of plenty of judges over my career who endorse speaking objections as long as there's no trying to coach a witness or,
But if she doesn't like them, she doesn't allow them. Shut up.
And that's not what we're seeking to do here. The objection hearsay, the objection lack of foundation, just standard basic objections. There's no prejudice to stating them in open court. It will move the trial along more quickly. It'll allow my client to preserve her due process rights. And we'd ask the court to change its ruling from the first trial.
Okay, that motion is denied. So the
Thank
next
you.
motion.
You can't talk her out of her own damn policy. Jesus
Jesus Christ.
Christ.
Irrelevant statements of Michael Proctor, 591. Does the Commonwealth intend to put this evidence into the case?
We do not.
Okay.
So we can agree to that motion.
All right, so that motion's allowed, Ms. Giannetti. There's a defendant's motion for reconsideration of the March 6th court order denying defendant's motion to exclude witness Crosby. Mr. Lessie, what I'm going to do with that is if I can readdress that before rebuttal, before the witness is called. So we don't need to do this now. We'll wait and see what Dr. Russell's testimony is and if the Commonwealth's going to call the witness. All right, so we can address it later.
Thank you,
Yeah,
Your Honor.
Carson,
And
I'll
just
explain.
so I'm clear on that, and to the
When
extent
we go on break, what I'm pissed off
we
about.
argue for the need for a voir dire, would that also be part of Your Honor's consideration?
So if I feel I need to reconsider it, that's the time to do it, after
Thank you.
Dr. Russell's testimony. All right, there's a motion, it's 599. Defendant's motion in limine to prohibit the Norfolk District Attorney and Massachusetts State Police from having juror contact. So we don't need to belabor this. We talked about this before.
So fucking insulting that they
They
even filed that.
fucking-
You're
No one
insulting
has
the judge.
contact with the jurors.
Yeah, they
other
fucking
than the
don't.
Court officers. So defendant's motion eliminate to prohibit Norfolk DA and Massachusetts State Police from having
Denied as
juror
moot.
contact. I'll also include prohibiting defense counsel and the media as well. No one is to have contact with the jurors. The court officers are the only ones
She added
that
the
have ever
defense
had
counsel
contact
in.
with the jurors. So
Nice.
there's that. So I think now we move on to something that may take a little bit more time. The defendant's motion eliminate to
Take your break
exclude the
now so I can rant.
testimony of Dr. Judson Welcher. How do you pronounce his name, Mr. Brennan? Welcher, and the Commonwealth's opposition. So who's arguing for the defendant and how long do you think this might take? Because we can do some of the quicker Commonwealth motions if you want.
I am going to make the argument, Your Honor, and I estimate 40 to
Commonwealth.
45 minutes for this motion.
Okay.
Definitely Commonwealth.
No, he just said 45
Mr.
minutes
Brennan,
to
how long
argue
do you
a
think it'll
fucking
take?
motion, which means over an hour
It's really
with him.
dependent on what Mr. Lisi says, but I can't imagine it's more than 15 minutes, perhaps 10.
Okay. All right. Before we go there, there are a couple of the Commonwealth's motions that seem pretty quick that I just wanted to know if the defense had objections to. To appoint a stenographer, we've already done that. Prevent identification of jurors and impound the juror names during trial. Why don't we do a few of these, then we'll take the recess around 11, and then we'll come back with the.
Okay,
lengthier
15 minutes.
motion.
I get to rant in 15
So
minutes.
I'll hear you on this, Mr. Brennan.
Thank you. Which motion, Your
Sitting
Honor?
here getting more pissed as it goes.
You're number 1, 575. Commonwealth's motion eliminate to appoint court stenographer, prevent identification of jurors, and impound juror names during trial.
Commonwealth believes appointing a stenographer is a prudent practice.
We've already done that.
Okay. Preventing identification of jurors. This case is a case that has garnered extraordinary public interest. There are some
Oh, that's a
concerns that
perfect
in the
shot for
history of
this argument,
case,
because look who he's looking right
jurors
at.
have been identified by different characteristics, whether it's their hair color,
Their line of
their
vision is
profession,
crossing, and
inevitably,
Aiden knows
as
he's
trial
being talked
progresses,
about.
It seems
Because fuck
through
you, Aiden.
sometimes the media, the jurors, although maybe not identified by name, have some of those characteristics promoted. That would cause, I would think, a strong concern by a juror that their verdict could be disfavored by one side or the other. That's the last thing I think anybody in the courtroom would want. And so the jurors, I suggest, should not be.
Except that guy right there in the middle, the one with the pink
before,
tie.
during, or
Yeah,
following,
fuck him.
During the trial. I think the jurors' names should be impounded. There has been past efforts by many to identify jurors, interview jurors, get information about jurors.
Turtle
that has been
boy
highly
squirming.
publicized. That will chill, I think, the process of deliberation in a fair trial for both sides. I think it is a measure that is accepted, it's appropriate, and under the circumstances of this case, I ask the court to do that.
Any objection from the defense?
Your Honor, we have no objection to appointing a court stenographer, impounding jurors' names and information, and in fact, we join in that request.
Okay.
The motion, however, also.
Only 'cause you know
asks for
he's
the
there.
impoundment of all sidebar discussions. Before I address that, I guess I would first ask whether Mr. Brennan is pursuing that part of the motion.
I think that's a good question. Sidebar discussions regarding jurors?
Oh, well, if it's sidebar discussions regarding jurors, we're in complete agreement.
So sidebars are impounded regarding jurors anyway.
Right. So we're in agreement with that. I interpreted the motion, perhaps incorrectly, that Mr. Brennan was seeking the impoundment of all sidebar discussions regarding all issues.
It sounds like he is because of the fact of people listening to FTR.
Okay, well, that's what I'd like to address.
All right, so I'll hear you on that.
Thank you. So we do question the impoundment of all sidebar discussions.
Okay, you agreed to it last time, right? So this is a
This is a
change.
new trial, Judge.
Right, no, so just to be clear, this is a change.
I don't recall what we did or didn't do last time, but this is our position for this
Okay.
trial. Obviously, the reason some discussions are held at sidebar is to prevent jurors from hearing legal arguments on the admissibility of evidence. But this is otherwise a public courtroom. The public typically has a First Amendment right to know in Massachusetts what is going on in a public courtroom. And in fact, in Massachusetts, it's not just a First Amendment right, there's also a common law right to know what's going on in the courtrooms. And when justice is open to the public, it serves as a check and balance to the conduct of the parties and of the court. Consonant with these policies, in one of your recent rulings, Your Honor, the court recently cited to the strong presumption of Massachusetts law that a courtroom be open to the public. Therefore, there's both a state policy and a benefit to public disclosure of courtroom discussions and rulings. Of course, if there's something that is discussed at sidebar that involves information subject to a protective order, portions of sidebars can be impounded. If there's some other reason for a sidebar conference to be impounded, the courts can so rule at the time. But a prophylactic blanket impoundment covering all arguments made at sidebar would sweep too broadly over these important rights and policies. There's a lot of publicly available information.
Where is the right
about this
to know
case already
sidebars
in the public
until after the
domain.
trial's over?
There are commentators who write and speak about this case every day on the internet. Sidebar discussions become yet another source of information But the court's able to guard against the jury being influenced by extraneous information outside the courtroom by instructing them every day, as you did during the first trial, that they're not to read or watch or pay attention to anything about this case outside the courtroom. And in that sense, sidebar discussions are no different than the daily news about this case that is discussed incessantly. And for that reason, we believe they should be generally made public.
All right. So last time they were sealed, and that was by agreement of all the parties. So this time there's an objection. What is the authority for me sealing or impounding sidebars?
I don't have an answer to that. It's something I'll need to look into because it is a legitimate concern of the Commonwealth, but there needs to be authority. And I can't say right now I have authority for it. I can tell you the concern is that many of the sidebars help vet out information that should not be heard by the jury. It's not the community that's the concern. Even the most diligent of juror in a trial of this magnitude and this length may hear extraneous information, whether they're looking at news reports or not, whether they're simply getting lunch. If there's evidence that is deemed inadmissible and prejudicial to the jury, there runs a real risk if the public hears the promotion of sidebar conferences. It's not an attempt to stifle First Amendment. It's not an attempt to deprive the community of the full value of the public trial. Rather, it is the concern that this case, unlike most or any, seems to have a political event component to it, and factions and sides and heavy promotion. It's a cottage industry in ways, unfortunately. And that creates an enormous amount of social media and media attention, which I embrace for the First Amendment, but we want to keep the jurors from hearing information that would be prejudicial or extraneous. And given the length of the trial and the heavy scrutiny of social media, that's the government's concern. But I agree the government should have a legal basis. If you'd give me an opportunity, we can offer the court whether we have that basis or not, but I can't tell you that now.
All right. So I am taking a lot of these motions under advisement. I'll give you until tomorrow afternoon.
Thank you very much.
Hey, ask Yannetti if he wants people to find out, standing at the lunch counter, about the
Is there an
texts
objection
Karen sent him
to
admitting she killed him.
577, it's the.
Does he want her to know that? Does he want the jury to know?
Commonwealth's motion.
Does she know
for
she killed him?
in-court identification. Is there any objection to that?
No objection.
All right, so that's allowed, Mr. Clerk. And the next one, Commonwealth's motion eliminate to admit the victim, one photograph of the victim, 2 photographs of the victim's injuries as observed by medical providers during the autopsy. Is there an objection to
No
that, Ms.
objection.
Little? That's allowed.
Real
578.
autopsy photos?
So the manner of death, so that is on the death certificate. So this is your number 5, Mr. Brennan. Paper 579, Commonwealth's motion eliminate to preclude reference to and redact the manner of death contained on the victim's death certificate. I'll hear you on that. Yes.
Pursuant to Mass case law, Commonwealth versus Almonte and Wallace, as we've laid out in our memorandum, we would like to have the cause of death redacted from the certificate. Certainly, the defense can cross-examine any witnesses that are called regarding the manner of death, but this notation on the death certificate is extraneous and it should be inadmissible. General Laws, Chapter 46, Section 19, provides nothing contained in the record of a death which is reference to the question of liability for causing the death shall be admissible in evidence. Again, different when questioning a witness that is offering an opinion regarding the cause of death, but the certificate itself should be redacted and it should follow Massachusetts general laws and it should follow Massachusetts case law. And for those reasons, we ask the court to redact any cause of death in the death certificate itself.
All right, who's arguing this for your defense? Ms. Little?
Thank you, Your Honor. In this case, the medical examiner who completed the death certificate concluded that the manner of death was undetermined. The Commonwealth is seeking to exclude this information from the death certificate because it is exculpatory. The Commonwealth seeks not only to have the court redact the manner of death here, but they're also not calling the medical examiner in this case, which creates certain issues. All of the cases cited by the Commonwealth in this matter deal with.
Can
the
you call
issue
her
of
if she
whether
backs
it's
you up?
error for the Commonwealth to admit a death certificate listing the manner of death without redacting the word homicide, because it violates a defendant's constitutional right under the 5th and 14th Amendments to the United States Constitution. That is not the situation that we're presented with here. None of the cases cited by the Commonwealth that were just referenced by Attorney Brennan stand for the proposition that a death certificate listing the cause of death as undetermined should be redacted. If the court looks closely at even the cases cited by the Commonwealth, specifically Commonwealth versus Ellis, I'd urge the court to carefully read that opinion, because what it says
Ellis
is that the
is a Sean
SJC
Ellis case.
identified the words that best practice dictates should be redacted from a death certificate. And what the SJC said is this, and this is dicta, it's not even true case law. The better and safer course is to exclude from a death certificate the words homicide, suicide, or accident in a criminal trial. Notably missing from that is the word undetermined. And that's because undetermined is not a finding of liability. That is what the whole statute was meant to protect from.
It's not exculpatory either.
That suggests
No.
that the word undetermined should be redacted from a death certificate.
If you can redact
Commonwealth
homicide,
proof in this case,
you can
they have to
redact
prove beyond a
undetermined.
reasonable doubt that a homicide occurred. And the Commonwealth's
Yeah.
own medical examiner has opined that she was unable to make that determination in this
Oh.
case. That finding is relevant, it's exculpatory, and it should not be redacted from
And
the
call
death
her.
certificate.
So you say the medical
call her.
examiner is not testifying?
It's not, I believe the medical examiner is not on their witness list.
Oh, I thought I saw her. Dr. Scorti-Bello? Oh,
Not on their witness list.
all right.
I heard Lally say she is. I don't know how Elizabeth Little has been practicing law for 10 years. She sounds like she's an afraid little girl who's just getting up there for the first year of practicing.
I'll take this under advisement. I'll take a quick look at Ellis again.
I would just note, I apologize. I know Attorney Brennan did represent at one point that they are not likely to call the medical examiner. So that was my impression.
Okay.
Perhaps I'm incorrect.
That's fine. Thank you. All right. One
Oh, yeah, 'cause
last
you don't want to get in trouble
quick
for
one.
lying
Commonwealth's
again.
Motion to eliminate to introduce certified records from the Registry of Motor Vehicles. Is there an objection to that? Ms. Little?
I'm sure there is.
No objection.
Okay.
Interesting.
Probably one more quick, so that's paper 580, Jim?
Thank you.
Commonwealth's motion to eliminate with the intent to obtain Corey records of potential jurors. That's allowed as long as it doesn't disrupt the trial in any way.
May we be heard on that? Your Honor?
Sure.
Oh, for fuck's sake.
Your Honor, potential jurors are asked when they fill out the jury questionnaire whether they
Yeah,
have
and
a
some of them
criminal
lie,
record.
as we know.
They're also asked if they know anybody in law enforcement. They're asked if they've ever been a victim of a crime. And for every other answer on the questionnaire, the parties must accept the potential juror's answer.
No,
which that juror
they
is
lie.
given Under oath on the form
Which
itself.
some of them did,
In
as
fact,
we
there are
know.
times when a court may deny an attorney from inquiring further about a clear answer on the jury questionnaire, precisely because the answer was clear and it was given under oath. It is solely through the issue of a past criminal record that the Commonwealth seeks to question whether potential jurors are telling the truth. If someone claims not to know law enforcement, the Commonwealth is content with that answer. Does not ask for permission to conduct any further research. If someone
This is a
claims not
highly
to be a victim of
publicized
a
case,
crime,
Mr.
again,
Yannetti.
the Commonwealth is
Come on.
content with that answer and is not curious about whether the potential juror is telling the truth. In other words, it is the potentially hidden, if the potentially hidden information benefits the Commonwealth in their viewpoint, they're fine with that. The only way to make this process fair to both sides, therefore, with regard to this motion.
Finally
would be
turned do not
to
disturb
the
on.
parties, the jurors' questionnaires in advance of trial, so that each side can do their own independent research and investigation to vet the potential jurors in the pool. I know that there is case law to support the invasion into a juror's privacy regarding a check on the existence or not of their criminal records and a vetting of potential jurors' truthfulness. But it is interesting that the very first case the Commonwealth cites, the Hampton case, stands for the proposition that criminal records of prospective jurors are not an indispensable or necessary means to the selection of an impartial jury as a matter of federal or Massachusetts constitutional law. That was a case in which the defense had sought a query check
Doesn't matter.
of potential jurors,
sought it.
and the judge denied that request. And the SJC said it was fine to deny the defense's request. That means, Your Honor, that you would be justified in exercising your discretion to deny the Commonwealth's request to be allowed to invade the privacy of potential jurors.
Because you want a free Karen Reed to sneak on there like they did last time.
It's simply not an indispensable or necessary way to select an impartial jury. Having said that, Your Honor, if the court is inclined nonetheless to allow the motion, we ask for an order that every bit of information turned up by the Commonwealth in their investigation of jurors be turned over to the defense.
I think that's the common practice of this office. What do you say to that, Mr. Brennan?
A jury full of convicted drunks isn't impartial?
Right. Come on.
Your Honor, is the court's question common practice of giving everything, or is it common practice of running queries?
It's actually seems to be both.
I believe I've been informed that it is the common practice, and that is the practice we would follow to give everything to the defense. I think the assumption that the Commonwealth would not want somebody with a criminal record on the jury might be misplaced.
They
Somebody
might.
who has a criminal record shouldn't be precluded from jury service. In fact, maybe people who have a criminal record in reactive society who the Commonwealth would embrace as jurors. But sometimes people forget or mistake that they have a criminal past. I understand may have happened in this case, has happened in many of my cases, and the nature of any past criminal record is sometimes helpful to see if there's an association between that and the charges in this case. So we would embrace providing everything to the defense and ask the court to allow our motion.
All right. If you remember, I give a catch-all too to the jury that sometimes we're in a hurry to fill out these forms. Sometimes that when we get these questionnaires, we think, well, this situation may not apply to me. So I give them time before they come up. And I specifically say, perhaps your experience as a witness or a juror or a defendant in a criminal case, or if there's any prior record, things that you may have forgotten. If you didn't include it and you remember it, please tell us when you come to sidebar. And inevitably, every trial, there's somebody that says they forgot to say something, or they had a record that, got in trouble when they were 17 or something. So it happens.
Right, and that's an argument against the Commonwealth's motion, because you're giving the jurors a chance to correct what they put on the initial form. There's no need for the Commonwealth to do their own independent research to confirm or deny that.
There's a difference between an omission and a misrepresentation. Sit down.
You'll get the copies?
Correct.
Okay. All right, why don't we take the morning break at this time, and we'll come back and we'll do that motion, the defense motion regarding Dr. Welcher.
All right, please.
You are muted.
Let me just mute that real quick.
Okay.
And
okay.
Hold on 1 second.
Okay.
Let me mute it. Let me get it muted. Hold on. My mouse is like playing tricks. That wasn't even me. I think they shut their sound off. But you can go. You can go on your rant in 1 second, Bree, because I know you want to tell everybody. Yes, I talked to Lindsay yesterday. But speaking of Lindsay, I don't know what that is, Frank. I have no idea what that is. But speaking of Lindsay, she does have a defense fund for this civil lawsuit that Aiden is trying to sue her for, basically to shut her up, to stop her from saying anything that he has done. And well, we're not going to let that happen because the truth is the truth, and he just doesn't want it to come out. It's literally that simple. But her defense fund is pinned on my Twitter X. It's the first pinned thing. You have to hit read all, but it's there, and she needs our help. She needs our help. You know, it's not. It hasn't moved much in a while, and the amount of attorneys, like the amount of money they want, is a lot. So if anybody can help, I would ask that you please do, because if he succeeds with this and continues on with this, there's just going to be a list of people that he's going to do it to. If he doesn't succeed in this, it would probably be stupid of him and his attorney to continue on spending money going after people if this doesn't work. And the only way this works is if he keeps going and she runs out of money to be able to fight it. And he wins based on a default, which is what he's actually trying to do. He has literally stated such, because he knows she's a single mother of 4 children, most under 3 under the age of 7. So I would ask that if anybody can help, please do. Frank, I have no idea what that is. I've never seen that before in my life. I'm going to have to look into that, or you're going to have to explain to me what the hell that is, Frank, because that's quite interesting. And go ahead, Bree. Oh,
Okay.
yeah, we got to get him screen.
David Yannetti, about 20 minutes ago, stood at that podium and said that insurance adjusters have justification to lie on the stand. Fuck you. Because unlike lawyers in Massachusetts and apparently federal witnesses handpicked by Josh Levy, if I lie to a judge, I get a $50,000 fine, go to prison for 5 years, and can never do my job again.
That's right.
And fuck you for implying I would ever lie to either person about the other side. My job is not to save the insurance company money. My job is not to give the claimant more money they're entitled to. My job is to look at the fucking facts and lay the facts down. Because you see, also unlike lawyers in Massachusetts, insurance adjusters know what fucking facts are.
It's true.
And fuck you for lying on every goddamn adjuster in this country and making it sound like we're all fucking crooked because you can't own your own goddamn bullshit.
They will never own their bullshit. That's half this problem, right? Is that the defense team loves to go up there and twist shit. Oh my, it's a hacking terminal? Oh God. That's interesting. Yeah, I was offended by that too, like for you, because you're not the only one I know that works in insurance. And we have, like, each state has like an insurance, like, oversight, a government oversight for insurance, not just auto
State
insurance.
Department of Insurance. That's who I report to.
But life insurance as well. I was going to sell life insurance. So I took all the classes, I was ready to get the certifications, and I ended up getting sick and having all these medical issues right during COVID. But there's an actual body that governs what we can and can't do. So when I went to go get my life insurance license, that is something you have to study and pass a test for. Like what governing body, what you can and can't do, what the ethics are, like what your responsibilities are to the clients who are buying the life insurance, your fiduciary responsibility to the company versus the client. And it's to the client. And it's the same, just a little different with auto insurance. So it's like, for him to say like, well, basically all insurance people would just have a reason to lie. I highly disagree with that. And I also say that if you want to keep your effing job, then you just do it fairly. Are there people who lie? I'm sure there are. Are there people who lie for both sides? I'm sure there are. But don't speak for the whole industry and everyone who wants to keep their jobs and careers, because they don't just go in a courtroom and start lying like you, Mr. Spaghetti and Eddie. That's not how it works. They also don't try to claim plausible deniability and have Jackson do it instead because he's not a state attorney, which is what I believe exactly happened here. Is Yannetti let Jackson take most of the heat because, well, he's just pro hoc BJ. He can just go back to his state and practice. If Yannetti had, he could be disbarred. I think they should all be disbarred. I think a BBO complaint needs to happen. I think the judge put up with far too much. I think shame on her for not giving any sanctions to them whatsoever. I think she should have absolutely given sanctions. I think that pro hoc vice should have been pulled, rightly so. And I don't understand in any world where she would just allow them to continue on. Because as she said, I'm not going to deal with any more lying, misrepresentations, stretches of the truth. And then 10 seconds later, they did just exactly that. And she did nothing.
Okay, calming down. I have been doing this for going on 2 decades. In that time, I have known one person, a man, who did lie and misrepresent and did keep a value down for an insurance company. Without that insurance company's authorization or approval, he did shaft an owner. I picked up all of his files because his license was revoked. He was fired. He is facing criminal charges for what he did. One person in almost 20 years.
Yeah. Yep.
Versus how many fucking lies have come out of David Gannetti's mouth in the last 10 minutes.
So true.
And for him to have the gall. You want an actual, truly unbiased person who looks at the facts, who looks at the reconstruction, who looks at the physical damage in context of where we know the point of impact to have been on the vehicle. You want someone who can sit down and truly give you an impartial view of it? Ask fucking me.
Mm-hmm.
Not the ones that your buddy Josh hired.
That's such a problem. Like, I don't understand why she's even allowing them to testify. Court's on a break, by the way. Anybody who's joining us right now, I have it down at the bottom of my screen. I am watching it to make sure we don't miss anything. I just don't understand. Actually, I put it back up on the screen because I already muted it, but I just don't understand how she could even allow Arca to testify at this point. Like, never mind sitting there and saying, like, you know, they want the federal investigation to be known. They do. Brennan was 100% right. And of course, the defense sat there and lied. Like, no, Your Honor. That's not what we want. We don't want the federal investigation to be known. Yes, you do. That's exactly what you want. No ifs, ands, or buts. Like,
my opinion that Karen is guilty. See, the facts of the damage to the car is not why I think Karen, you know, I'm not finding the damage to the car because I think Karen is guilty. I know Karen is guilty because of what I see when I look at the car. There's a difference.
Yeah.
And if I can do that as an insurance adjuster, Michael Proctor sure as fuck did it as a cop.
Right.
And so did every other cop that touched this case.
Mm-hmm.
And that I, who have no amount of influence anywhere near what these lawyers have, that I can go to prison for 5 years for doing anything even remotely close to what he just implied I do. But he can stand there and lie about it all goddamn day and get nothing?
Yeah. Well, you know, the court can basically say, like, that's his opinion. So they're not going to call it out as a lie because they're going to say that's his opinion. But I think there's a very fine line between an opinion when you're an attorney and misrepresenting to the court.
Since when does the lawyer's opinion have any fucking role in a motion?
Yeah. I mean,
facts, not
there
opinions.
are a million facts in this case, not rank speculation, not, oh, this looks a little funny or sounds a little funny because we don't know why X, Y, or Z happened. Because then when you do get the reasons to why certain things happen, you're like, wow, that was pretty mundane and there was actually nothing suspicious or weird about it at all. But hold on, I just saw that freeze. I gotta fix that. But I think that, yeah, sorry. I wanted to make sure it just like froze on me. but there are a million actual facts to prove Karen's guilt. One of those very major facts is John's phone stops moving forever in the spot that he is found underneath him seconds after Karen backs her car up at 75% pedal. Okay, seconds. That's as good as a snapshot in time on video. He never enters the residence. He doesn't move from the spot that he's found, and his phone is found underneath him. And the only thing that I didn't understand was underneath him how, and I said this early on, I said, well, what if the phone was in his back pocket? Lots of guys do that. I've dated plenty of guys that put their phones right in their back pocket, not their side pocket because it's too tight if you put it in your regular front pocket in your jeans for guys. So a lot of them will put their wallet and their phone in their back pocket. So I said way, way, way back at the beginning of this, why underneath him? But now we know the answer to that. We know the answer. Hey, Leah, we know the answer to that now because specifically Karen told us on the documentary. She freaking told us that she tried to get his phone out of his pocket and was going to flip him over. But Kerry told her to fucking stop and get the fuck away from him. So she could do CPR.
People who know nothing more about cars than how to put gas in them and turn them on are very easy to convince that all kinds of things are nefarious when it's not. People are always oh, don't you find it suspicious that there's still pieces of taillight being found today? No.
Like not in New England where we live, where it could take months for that snow to actually melt. And if they were searching with shovels, they could have overturned it, thrown it, strewn it about the yard, and it's going to take time for that snow to melt for them to find it. So no, I don't find it. Like in the beginning, if you're telling me that it's put on top of the snow, then yeah, that's a little suspicious. As we know now, that was not the truth, and Turtle Boy and Karen both lied to you. It was not on top of the fucking snow. It was underneath the snow. They used shovels to get it out.
And not just months. I'm talking months. I'm still picking up taillight pieces from the road where my taillight was hit by the trash truck 2 years ago.
Oh yeah.
And I know exactly where it was parked when it was hit, and I'm still finding them. It's the reason that it's the reason that archaeologists have shit to dig up because people dropped random stuff that got buried over the years. It's not uncommon. It's perfectly fucking normal.
There's so many things that happen here that might look nefarious in the beginning. And if you listen to the sewer turtle 24/7, then everything's nefarious. Every tiny thing's nefarious. Everyone's being framed, including him. But let's go back before Karen's case ever happened. Let's go back to when John was still alive and none of this existed. Aiden existed, Turtle Boy existed, but the sewer turtle has been claiming every time he's caught in some controversy or something he shouldn't have been doing that he was set up, that it's all a farce, it's a lie, and he did nothing wrong every time, years before this case ever happened. It's a pattern of behavior with him. And every single one of the instances where he claimed everyone else was wrong and he was being set up, he went after the people who were speaking truth. Tom CPU was actually one of those people at one point. He found out that Aiden was having an affair with someone on his wife and thought it was gross and found out who it was and was right. Aiden called him a liar, wrote a blog about him, wrote all this awful shit. Come to find out, Tom was right the entire time. Aiden was trying to cover for himself and he did awful, awful shit. And during that time, he also made up evidence to use against other people. And I literally mean like made it up, doctored it, and then used it in a court of law. Okay. Numerous different cases, numerous different times. One of his most favorite things to do besides making up evidence, calling himself, emailing himself, doing or having someone else do it to use as evidence, doctored for court, is to, in real life, try to retaliate against anybody who's trying to hold him responsible through the court system, and then go to his local PD or whatever PD, go back 25 times if he has to, and keep hassling them to then charge the person with some crime that he made up, with made up evidence, with a crime because he's mad. This goes back long before the Karen Reed case. And if you speed back up to right now, it's the exact same playbook he has been playing for years and years and years and years. The man's a creature of habit. He's a narcissist. He's egotistical. He's a cluster B personality. No doubt about it.
He also developed an apparently rapid onset ass rash that he really had to scratch while Hank was talking about him.
Yeah, well, here's the thing. A lot of people don't know, and I didn't even, when I first started covering this case, really much about him. I knew he was talking about this case, but other than, I had heard the name, obviously, but besides that, really not much about his past. Since he decided that I was public enemy number one when I found out about him cheating on his wife and Lauren and Lindsay and Carol at the same time, I became public enemy number one after that because I knew something I shouldn't know. I would have never told it to the world because that's not my business and I don't care. But he felt that it was a threat that I just knew. So he launched an attack, which is what he does on every person who he sees as some sort of threat, even if they're not a threat. So I want people to actually listen here and like absorb this. This is not something that he just started doing during the Karen Reed case. He was not framed. Leah, Kate, and Lindsay did not frame him. Okay. There was no collusion between Kate, Leah, and Lindsay to frame him. None of that exists, which you'll find out at trial that he's just a big liar. The man does the exact same thing every time. Takes a snapshot of a text message, removes his portions of it, so nobody gets to see that part, and takes one part of it that by itself could seem like it's sketchy or nefarious or wrong, but completely takes it out of its context and then adds his own narrative to what he wants you to believe that this is. This is what he's been doing the entire time. The fact that people haven't picked up on it yet, I mean, I'm not going to say people haven't because people actually have. I've gotten many messages from people who have. But let's go back to the core people who haven't. Some of these people have been following him quite a long time. They know every nefarious, sketchy effing thing he's ever done. A, they're just afraid that he will attack if they ever open their mouths. B, some of them are just fanboying and fangirling for reasons that are not clear to anyone other than their own brain. And C, I really believe that he attracts people that just want to belong to something and have some seriously mentally unwell issues. Because there's no amount of people in the world that if you do 10 minutes of research on this man, don't realize that he's a pathological liar, that he goes after people he just doesn't like. And most of the people that he, quote, doesn't like are because they know something about him they're not supposed to. Or they know something about something he did that they're not supposed to. And so therefore, his MO is to attack that person first before they can ever say anything. Try to discredit anything that they have to say so that the mob will just go, oh, well, that's just someone he talked about, so they're just mad about that. Take that out of your brain for a second, okay? Two things can be true. Karen Reed can be guilty and Aiden can be a piece of shit, all right? Two things can be true. You could think Karen is innocent. You can also think Aiden's a piece of shit. I've met many people who think she's innocent and also think he's a giant piece of human garbage. The man is a waste of oxygen, okay? And I don't say that lightly because I don't think many people are a waste of oxygen. But he is a waste of oxygen, okay?
And it's not possible for them to hold that opinion without giving his weight. So, no, you don't think he's a giant piece of shit if you're listening to what he says.
Right. That's another, like, if you're listening to what he says, then I pray one day you figure it out. And when you do, I'll be here. And you absolutely can come and talk to me and I'd be happy. And that's the thing people don't realize. Like, I'm like an open book when you're not harassing me or trying to be
Before we begin,
a mob member. Like,
really
hit another one.
I need to go because my break is over, but let me throw out there one more time. Fuck you, David Yannetti. And I hope she
testify. We'll
Denies
do it
every
the day
goddamn
before they
motion you filed
testify.
because you deserve it.
And
I'll be in chat.
we'll give you
Love
until
you.
then
Love
to
you.
comply with all Rule 14 discovery and see where we stand. So we don't need to bring them here next week unless you made arrangements.
No, I didn't make arrangements. I just want to make sure that we're very well defined on what issue is before the court that would justify a voir dire. I
I'm
just want to
confused, Frank.
make sure.
She did another
I
what?
don't think that's been clearly articulated. I just need to know what the parameters are.
Okay.
We need to know. I think Mr. Alessi is going to handle the argument in substance, but I need to know what are we dealing with for a voir dire?
Okay. All right. So what I need you to do beforehand is make sure that all Rule 14 discovery is complied with. And if it is, then we'll see. Okay?
Okay, so it's basically
Yes.
defined on Rule 14.
Yes.
Got it. Thank you.
Does that work for the Commonwealth?
My concern is if we have questioning of the witnesses the day before their testimony, and part of that includes the production of records, and they don't have the records with them, they're going to be unable to produce them because they would have to return home. And so having.
So we'll need that, Mr. Alessi, okay? Well in advance.
Yeah,
That would be part of the Rule 14 discovery. If they comply with Rule 14 discovery in advance, you'll have all of that.
That was exactly my understanding, what Your Honor was suggesting, and we will comply with that.
So see where we stand. If we need to address it, we'll address it before then.
My discovery motion extends beyond Rule 14, and the reason why is it includes the communications between the parties, which is necessary to understand. It's not simply Rule 14. We have a court order
Just
discovery
me.
motion that we filed that includes the request for this information to show bias, and I don't want that to be overlooked.
All right, so talk to Mr. Alessi in advance. All right, and I'd like you to be able to tell me before we start the trial where you stand with that. Okay?
Yes, Your Honor.
And what you still think you need, Mr. Brennan.
I'll inform the court.
Okay.
And I'm pleased to speak with Mr. Brennan at Your Honor's direction.
All right, thank you very much. All right, so now we'll go on to your motion, Mr. Alessi.
Oh, get ready to want to fall
May it
asleep and
please the
talk in
court.
circles.
In my presentation today,
Dingdingding.com.
Major times 8.
Oh.
That's like 600 sweepstakes coin. Are you kidding me?
today, Your Honor, I'm going to, just so Your Honor has the documents in front of you that I'm going to be referencing. I'm going to be referencing the 140 slide presentation.
Okay.
What the Commonwealth has dubbed a report, which is approximately 12 pages of a letter dated January 30, 2025 from Dr. Welcher to Mr. Brennan. And I am also going to be referencing a case law that the parties have cited. What Dr. Welcher has submitted is notable both for what is submitted and what is not provided. Dr. Welcher has gone extraordinarily well beyond not only his area of expertise, but he has, and that's in terms of what he has provided, but as remarkable is he has not provided any documentation of how his methodology is tethered to any study, any common acceptance, or any of the Daubert factors. And this, again, is a pattern of the Commonwealth where they provide, as they did with Dr. Wolf, as they have done with Dr. Crosby, they provide long CVs, long qualification lists, and then are completely silent on the tethering of the methodology to a common acceptance or the App Daubert factors. So that is the jurisprudential motivation for me to hit the case law with regard to why that deficiency is fatal to their burden of proof under the Massachusetts law. So I'll start with case of Canavan, the SJC's decision of 2000. And I am going to provide 4 parts of Canavan. Number 1, it's in head note 11. And this case was about, as the court may know, the Commonwealth, not the Commonwealth, a party proposing an expert that was commenting on, which was fashionable at the time, multiple chemical sensitivity. And the expert witness trying to state that an individual suffered from multiple chemical sensitivity. Here's what the SJC stated in response to the expert that was proffering that testimony, and it's extraordinarily close to what is happening with Dr. Welcher, what happened with Dr. Wolf and Dr. Crosby. The SJC said there was no evidence in the record to show that Dr. LaCava, that was the proffered expert, used a reliable methodology to transform his general finding of chemical exposure to his more specific diagnosis of MCS, multiple chemical sensitivity. Immediately after that, the High Court said, and I quote, Dr. LaCava referred to the, quote, literature as confirming the existence of MCS and asserted that based on the examination and tests he conducted, the employee had symptoms highly suggestive of environmental sensitivity. However, Dr. LaCava did not identify any specific studies that showed the existence of MCS based on specific symptoms and did not identify tests that can be performed to prove that the patient suffers from MCS. Skipping one sentence. Thus, the only evidence on this record tending to show that the employee suffered from MCS was Dr. LaCava's assertion. The purpose of the Lanigan test is to prevent an expert from offering testimony to a fact finder that is not based on a reasonable or reliable methodology. We cannot conclude that the expert's mere assertion that a methodology is reliable is sufficient to pass the Lanigan test, absent any other evidence showing its reliability. And I have used the Latin phrase ipsi dixit, translated into because he says so, or he said. And it's not my pejorative, that's the ipsi dixit, comes right and is used in case of Canavan. And that's what the SJC calls it when you don't tether a methodology to a study or common acceptance. It's just that expert witness saying it. The reason I perseverate on this is because that's exactly what Dr. Welcher is doing in a 140-slide presentation. It's exactly what he did in his 12-page letter to Mr. Brennan. Nowhere in either of those voluminous documents does he mention one word about 2 things he did. He did an analysis. He has a purported methodology, just like Dr. LaCava in case of Canavan. He doesn't mention one study to support his methodology. Unless there be any concerns, the law is clear that the Lanigan analysis is applicable to medicine, science, and technology. And clearly, Dr. Welcher is in the technology area, and the Dalbert Lanigan analysis is
It's like take a shot every time he says methodology.
He also, Dr. Welcher, conducted an experiment.
Methodology.
And I'm going to treat that separately from the lack of a methodology. So I want to stay just with the methodology that is purported to be used by Dr. Welcher. So keeping on with the methodology of Canavan, Dr. Welcher also is proffering to provide opinions on the medical causation of the injury
Methodology.
to the right arm of the decedent. It's clearly what he is doing. Here is what the SJC said about causation. It's head note 14, and they labeled the heading of it causation.
I hope all 185
The
of you watching
SJC
right now
said,
at least have a good laugh
quote,
on this.
"There is no suggestion that the judge conducted a Lanigan analysis to determine whether Dr. LaCava used a reliable methodology to conclude that the chemical exposures to which the employee was subjected caused," and caused is italics in the opinion,
on the
her to
methodology.
suffer from MCS. This was an error. They went on, quote, "Because understanding medical causation is beyond the knowledge of the ordinary layman, proof of it must rest upon expert medical testimony. Because and I'm skipping several sentences, because the judge below did not conduct a Lanigan analysis to determine whether Dr. LaCava relied on a reliable methodology to determine that chemical exposures caused the employee's MCS, it was an error to admit the opinion." In the concurring opinion of Justice Greene, he added an important point. I quote, "Further and perhaps more importantly, the application of the standard will make little difference in how an appellate court decides a hard science." The issue was, what was the standard of review? Is it going to be abuse of discretion? And the concurring justice said, in hard science, it really doesn't make a difference. But here is apt for what we're here for today. The goal of Lanigan, as was the goal of the preceding tests, is to keep unreliable or so-called junk science from fact finders, thereby reducing the prospect of the return of verdicts or the rendition of decisions with dubious validity. So I rehearse apt provisions of the case of Catavan because the SJC sets forth what the burden is of the proponent. And I know Your Honor has heard me make this argument before, but I am now providing the SJC decision for direct support, what I've said with regard to the experts, Dr. Wolf, Dr. Crosby, and now Dr. Welcher. Next case I provide is Commonwealth v. Meeks. And that is another SJC decision. And if I'm not mistaken, I think all of the cases that I'm providing in my oral argument are cases cited to by the Commonwealth as part of this motion. I'm not 100% sure with regard to Meeks, but I think it's a decision that they cite as well. And oddly, all these decisions favor the defense.
We'll be here, Anna.
So here is, I'm only going to need to read one part of Meeks, even though it's a very long decision of 2006. It states at 2006 Westlaw 2819423, and this is on page 53 of the Westlaw copy. Quote, "At trial, this court will require the Commonwealth's firearm identification witness to provide on direct examination, et cetera, et cetera." Last sentence. "Such discovery is essential to an effective cross-examination and therefore to a fair trial." And I've made this argument many times before about the prejudice to Ms. Reed from the pattern of the Commonwealth to provide experts, long reports, long CVs, completely silent on tethering the methodology to a study, etc. And the SJC points out that that information is essential to an effective cross-examination and therefore to a fair trial.
Oh, sorry. You never know when those are coming, so you can only skip them when you know they're freaking coming.
Last case that's really more apt to the experiment that Dr. Welcher apparently performed, not apparently did perform, that is the subject of his slide presentation. And this is, there's various experiments, but the most prominent of which is painting someone's arm blue, painting a hand yellow, and then trying to use the results of that experiment to support some wayward theory as to how the SUV made contact with the decedent. There's no doubt that's an experiment. So it's important when I get to that experiment, what the legal standard is before such an experiment can be admitted in evidence, and what's the test under the Commonwealth v. Davis and Lanigan as to how an experiment could possibly come into court. So you've heard of the case, and I know Your Honor knows of Rentalo. We basically cited it for the proposition of qualifications, but substantively, we haven't talked about it. And I know Your Honor is well familiar with it, so I'm just going to summarize what's apt for our motion. Okay. What the High Court said there is that the precise question is whether Giulianelli, this was the paint expert proffered by the Commonwealth, possessed sufficient education, training, experience, and familiarity to determine forensically when and how the paint was applied to the basement floor in the victim's body based on the information he was provided. And a large part of Rentalo was, listen, this person was a paint engineer at his company and he had a lot of experience in that. But what he really didn't show and didn't have was experience forensically addressing the question. And that was certainly a big part of Rentalo. So the court, to that point, said there is a significant distinction, however, between what Giulianelli had done in the paint industry for over 20 years and what the Commonwealth asked him to do in this case. So the court went on and discussed the difference, and it said he also, this is Giulianelli, he also did not do any research on the topic or search for any academic or industry materials on this topic. So the court, with that predicate as to what was lacking, which is completely the same as what's lacking with Dr. Welcher and his experiment, the court said this.
I know, B. Tim.
And this is on Westlaw
Frustrating.
14, head notes 19 through 22. I quote,
You're
expert
numbing.
testimony also may be based on or informed by the results of experimentation.
Go back to environmental law. Skippy.
The conditions in the experiments must nonetheless be substantially similar to those at the crime scene for the experiments to be of any value, and where new hard science is involved, an appellate court will always take a hard look at the trial judge's decision to admit or exclude the evidence.
Can't help it. I get mad.
So here's what happened that's very apt to Dr. Welcher.
I get mad.
Our analysis of Giulianelli's approach begins with the important principle that judges should closely scrutinize expert testimony where the testimony is prepared solely for the purpose of litigation, as opposed to testimony flowing naturally from an expert's line of scientific research or technical work.
It was so pathetic.
There is no evidence whatsoever in the Commonwealth papers that Dr. Welcher had ever performed this experiment as part of his line of scientific research or technical work. From all indications, it appears that he performed this experiment specifically and exclusively for purposes of this litigation. And that's where the SJC started. So they immediately said, if it's just experiment done for this litigation, we right off the jump have a big issue with it. The SJC then goes on with this very, very questionable area of experiments and said, rather than flowing naturally from his work, therefore, his experiments greatly differed from the work he ordinarily performed and the observations he had experience making in the key. And his opinions were developed solely to assist the Commonwealth's prosecution of the defendant, which from all indications appears exactly the purpose of Dr. Welcher. And here now to the tethering of the methodology to a study which Dr. Welcher does not do at all. The court said, footnote 31, because Gianelli conceived of and designed the experiments without any stated basis in existing science or literature, and because neither the Commonwealth nor the trial judge applied the Daubert-Lanigan factors, it would make little sense to attempt to apply them here. The SJC said, we're not even going to go do this analysis because the proposed expert didn't cite to it. So we're not going to guess at what happened. And it then said, relatedly, and I'm quoting, the Commonwealth has not pointed to any basis in existing scientific literature or research for Gianelli's methodology or experience. Instead, it appears that Gianelli designed these experiments on his own without any guidance. Reading down below, quote, Gianelli's experiments also did not appear
like he has to read the whole thing
consistently
like the judge
with
can't.
basic scientific principles.
The judge
We
can't.
have no evidence in anything the Commonwealth submitted that the experiment of Dr. Welcher was performed in accordance with any scientific principles, because his report and the slide presentation is completely bereft of any citation to basic scientific principles. Next, the court said Gianelli did not repeat or validate any of his 6 experiments is also significant. There is 0 in the current record that Dr. Welcher repeated or validated his experiment. Nothing. That is the legal standard for experiments in the Commonwealth of Massachusetts. It's not the defense creating the standard. It's not the defense suggesting what the standard should be. What I just read is a 2021 opinion of the SJC. With those important legal precepts stated, I now turn to the letter, what the Commonwealth provides as, or calls a report, which is the January 30, 2025 document from Dr. Welcher. And I start on page 9 of that report. And if Dr. Welcher had adhered to his own standards about what a biomechanical engineer is to do, my presentation would be much shorter.
No, it wouldn't.
So let's see what he said
No, it
the
wouldn't.
biomechanical engineer is, and then what he did. Because this goes to the point of him exceeding the scope of his qualifications wildly. So on page 9,
Good point, Barb.
he said in the first full paragraph under numeral 11, he says, in the middle of the paragraph, my biomechanical engineering analysis is determining the effects of physical forces on the human anatomy. I have not made any type of diagnosis. He then goes down below, in 2/3 of the way down, he says, injury causation analysis is a multidisciplinary endeavor that employs objective medical and biomechanical data and analysis to determine whether a MVC caused a pathological condition or symptom diagnosed clinically. He continues, the entire body region will be covered under 3 of the 4 main branches of impact biomechanics, which are injury mechanisms, mechanical response, tolerance, and the biofidelity of surrogates. Thus, injury criteria are needed by biomechanical engineers to describe the relationship between one or more physical parameters and the injury they cause. These criteria usually take the form of a simple mathematical expression or a force or acceleration level. I couldn't agree with him more that that is what biomechanical engineers do. And he then goes on the next page, first full paragraph, I understand my current assignment in this matter is to analyze the available
He understood
data
the assignment.
in this case including but not limited to the data in and damage to the Reed 2001 Lexus LX 570, and
Sewer
to
Turtle looks
determine
really upset
the
right now.
events that applied forces to Mr. O'Keefe that resulted in the damage to his body, structural failures, fractures, injuries. I agree completely again. That's what a biomechanical engineer is supposed to do. And what is it that he's talking about with force acceleration? At the risk of getting a little too nerdy, but it's really important, what biomechanical engineers do is they apply Newton's second law of physics, which is force net equals mass times acceleration. That's the mathematical formula, because biomechanical engineers want to know what's the force being applied. And when you do that, then you can then say, okay, is this force capable of causing this result? And if that's what Dr. Welcher had done, again, my presentation would be very short. But that's the setup that he says are his guardrails, his boundaries. Now let's see what he actually did in this cases where we have great objections. It's his conclusions and opinions, which take up about 1.75 pages only on page 10. Let's see what he did and how he honored or didn't honor his own standard. And I'm going to, hopefully to assist the court, identify what I believe should absolutely be disallowed from him opining on.
Now, with
Disallowed
lotto.com,
from him
any stolen
opining on.
second, any
You should be
casual
disallowed
mindless
from
scroll
speaking.
That are clearly wayward
Ever.
and improper. 1C. He cites to Julie Nagel and occupants of Richard D'Antonio Ford F-150, Ryan Nagel and Heather Maxim, arrival in time outside 34 Fairview, not seeing anybody exit Lexus or damage to the Lexus. What he is doing is he is not only using,
And
but
the ball
he's trying to credit contested testimony.
So let me find out, do you intend to introduce that?
Yeah, let me find
testimony,
out.
Mr. Brennan, through this witness.
I intend to introduce that testimony prior to Dr. Welcher testifying. If it's not in the record, he would not be able to testify to it, but if it is in the record, he can refer to it as part of his opinion.
All right.
That's a very apt question, and Mr. Brennan's answer underscores the issue. So what I understand completely the foundational evidence issue. I understand all of that. But the transcending issue is an expert witness can't use contested testimony because experts are not allowed to credit and talk about the credibility of witnesses. It's clear case law in every jurisdiction, including Massachusetts. And he does that throughout his report. And
does he?
We've provided in our supplement correction the clear case law. I'm not going to go through it because I know Your Honor knows this. It's almost Hornbook law. So based upon Mr. Brennan's answer, it only underscores and establishes our concern. So 1C should be excluded. Now to 2. 2A Romanettes 3 and 4.
Sewer Turtle looks very uncomfortable.
Romanet 3,
right
2A3. No evidence light was broken at 1 Meadows Ave.
Probably.
When does a biomechanical engineer get to testify about a contested issue
right now
and say no evidence?
There is no evidence.
That's not for a biomechanical engineer.
Yeah.
And when he set up his own boundaries, he didn't talk that he was going to be looking at contested evidence. Romanet 4, 2A4.
It's there.
No
other than
fragments
the
of
Karen hit it.
taillight on or in snow behind O'Keefe Chevrolet. That's an evidence, collection of evidence, preservation of evidence, etc. It's not for a biomechanical engineer. Then he goes on to 2C. Testimony of Jen McCabe. That's his heading. Karen Reed stated to her, etc., etc. In other words, given Jennifer McCabe's testimony, And then he talks about what he believes Ms. Reed knew. That is not only trying to credit testimony, we've got now a biomechanical engineer that is going to be stating the Commonwealth's case for it. What is the biomechanical force calculation for talking about Julie Nagel, Ryan Nagel, Jen McCabe, or frankly anybody's testimony? It's unprecedented. Now, continuing on page 11 at the top, and this is C Romanet 1-1, 42622 Julie McCabe, 42622 state grand jury page, etc. Grand jury minutes. It's testimony. It's testimony of lay witnesses. Inherently, he is crediting that testimony as truthful. That's not what any expert can do, let alone a biomechanical engineer.
You want Dr. Russell to do that? What do you mean?
The location and orientation of the laceration on John O'Keefe's right forearm and arm are consistent with the geometry and orientation of the right tail light of the Reed 2001 Lexus LX 570. So let's cut through the euphemism of orientation. What he is referring to is pattern recognition. He is saying that the pattern of the lacerations on Mr. O'Keefe's right forearm are supporting his opinion. Where is his qualifications to determine pattern recognition of a wound on a decedent? They don't exist. 4, and that should be stricken and not allowed. 4, perhaps the most egregious of all, and I respectfully submit what I've pointed out are incredibly egregious. 4, the totality of the evidence is consistent with the right rear corner of the Reed 2021 Lexus impacting, etc., of his head on the frozen ground.
Shut up.
So there are several maladies with that statement. First,
It is frozen.
where
That's a fact.
is his qualifications to testify as to frozen ground? He's not a pedologist. He's not a hydrogeologist. He's not a geologist.
Doesn't need to be.
He has no
Common
basis
sense.
to testify in that regard. But more importantly is his phrase, the totality of the evidence. And if Your Honor now looks at what he considers to be the totality of the evidence,
Your Honor's done listening to you, sir.
he is,
Your
and I
arguments
will
are
state
way
each
too
one,
long
he is becoming
and
a medical
ridiculous.
examiner. He's
So?
becoming a lead investigator. He's becoming
Dr. Russell's an
a
expert
cell
in
phone
everything.
data forensics
What do you
expert.
mean?
He is also, once again, talking about testimony
Bree.
of individual witnesses. So he says the totality of the evidence is consistent with the right rear corner of the Reed Lexus impacting John O'Keefe and Mr. O'Keefe, etc., and of his head on the frozen ground.
Yeah.
So what he's doing is
18 degrees
he's
outside.
now
It's kind of common
talking
sense.
about
It's frozen.
cause of death and manner of death.
Do you intend to introduce that evidence, Mr. Brennan?
Wouldn't be introducing evidence of frozen ground through Dr. Welch. Is there other parts of the,
Cause of death.
he would not be offering a cause of death. I think the spirit of the report is putting all the information together to see his observations, but I recognize that he's limited to his field. The hard ground and the cause of death are not within his bailiwick.
All right, thank you.
Again, I appreciate that.
No, I don't have
aspect,
anything
and
to
I'm gonna
argue,
go
Your Honor.
into why there's still an issue. So I think it's best just to go through each one.
No.
Thank you. So 4A,
No.
he says and this is what he means by totality of the evidence. Cell phone data. Where's his qualifications to discuss
He's
cell phone
not
data?
going to.
That's a data forensics. We had obviously many moments I'm sure your Honor may wish to not remember, but with regard to Mr. Green, etc., we went through a lot of
Turtle's
issues
typing away
about
over there.
the expertise,
Very
needed, the
angry.
methodologies, the various tools.
Methodology.
Where is his qualifications to talk about cell phone data? There
my
are
copy.
none. It's improper. So A,
They're
its
improper.
entirety
The
should
face
be
is improper.
stricken.
You should be
C,
stricken in
Arm,
this case, in the
forearm
record.
lacerations 3 above. So that goes back to the euphemism orientation where he wants to talk about pattern recognition. And it's interesting that the Commonwealth vigorously contested Dr. Russell, and we all know her credentials on pattern recognition.
He doesn't have credentials.
But yet they're proffering a biomechanical engineer to talk about pattern recognition. D, air temperature and frozen ground. I'm understanding, if I understand correctly, that the Commonwealth is now stipulating to excluding that. And it's really the frozen ground aspect of it.
Okay, you said he's not arguing
D.
that.
Then
Over.
E.
Done.
I'm sorry, Mr. Brennan.
I don't mean to interrupt. The frozen ground, we're not going to bring in. The air temperature is important because it talks about the density of the strength of the taillight. And that's part of the conclusion. So there'll be evidence before he testifies about the weather we expect. Okay. And he can rely on that to talk about how that might affect the taillight. But frozen ground, we agree, that would not come in through Dr. Welcher.
We have no objection to the air temperature testimony of Dr. Welcher.
Okay. All right, so shut the F up.
E, hat line and fracture location consistent with fall and posterior head strike. Extraordinary.
Your face is extraordinarily annoying.
Even the medical
Your
examiner
voice
in
is
this
extraordinarily
case
annoying.
wouldn't venture onto that. But that is clearly
Doesn't
an
matter
example
what
of what
you
I'm
do.
talking about in terms of Dr. Welcher going well beyond his field. He's talking about hat line and
Anna,
fracture location. That's a wound to the back of the head. And to make matters worse, he makes clear fall versus assault. He's making a distinction between a fall and an assault occurring. We've contested Dr. Wolf on that issue.
Dude.
Now with regard to
to shutting the F up. How about in regard to that?
This is the wayward, undocumented
You're
experiment that Dr. Welcher conducted.
You mean like a potato cannon?
F Romanet 2 should be excluded. It says drop test conducted by me with a hybrid 3 falling backwards, measured heads, G's of approximately, et cetera, et cetera.
So Turtle's not listening, by the way. He's not taking in any of this. None of it. Zero.
That experiment I've covered in what the case law requires for him to show.
Space buns are taking in more than he is.
Support for this experiment. I went through in Rentola.
Zero support from you.
I won't repeat it. Of all that needs to be established before an expert can talk about an experiment. Dr. Welcher supports his experience with zero. This very experiment that he did, this drop test,
You're an
has
experiment.
zero documentation.
And how to not gouge your eardrums out.
Where the methodology for that is supported by science. Recall in Rentola, the paint person conducted an experiment and the SJC said, yeah, you conducted it. Yeah, you know, this is your area, but you've got to show all of these things, including where is this supported by the scientific method?
Dr. Russell didn't do
Did you
that.
repeat this experiment to make sure that there wasn't an error rate of concern?
Pattern recognition.
Every single
Life's full of coulda, shoulda,
Arguing
woulda.
against your
I coulda hired a
own
plumber. Shoulda locked
effing
the
witness,
windows.
you moron.
Woulda-
Dr. Welcher.
Okay. No,
His
Dr.
experiment
Russell.
must be excluded if Rentola is to have any meaning in Massachusetts
How about that?
jurisprudence. G. Julie Nagel and Ford occupants. Again, what does he say? Pulled in behind Lexus and never saw anybody enter or exit Lexus or walk into 34 Fairview. He's crediting, again, testimony and contested issues with regard to some important issues in the case. Unprecedented, the biomechanical engineer gets to come anywhere near that. And we provided, again, the clear case law where in Massachusetts that's not allowed. And as egregiously, H, people inside of 34 Fairview on evening of 128, early morning of 129. H, Romanet I. John O'Keefe never entered 34 Fairview. Is there any more of a contested issue than that? But yet he's proposing to testify and state that what biomechanical engineering principle is being applied there? The answer is none. Except for Karen Reed, everyone at 30 and outside 34 hours indicated John O'Keefe did not enter 34.
That's right.
Even more egregious than H. Romanet I.
It's egregious.
So
GPS backs it up, buddy.
With regard to Dr. Welcher, I have,
looks constipated.
again,
Keeps
genuinely
wiggling around
tried
in
to
his chair.
assist the court with regard to blue penciling his report to make clear, based upon the case law, what is within his bounds and what is not within his bounds based upon his own stated parameters. And with regard to the case law about commenting, not being able to comment on a witness, crediting their testimony, Commonwealth v. Quinn, which we cite, says such testimony impermissibly intrudes on the jury's province to assess the credibility of the witnesses. So not only is Dr. Welcher beyond his qualifications, but he's intruding on the province of the jury. And the Massachusetts courts state such testimony, the kind where an expert witness assesses the credibility of another witness, could substantially influence the jury's decision about whom to believe. And lastly, and importantly, should the Commonwealth try to save this wayward part of the report by saying, well, you know, is he really directly or explicitly doing it? The Commonwealth v. Lopez case, and I quote, vouching for the credibility of a witness, here's the key part, whether explicitly or implicitly is impermissible. So I believe it's explicit for the reasons I've given, but even if the court were to conclude that some of his references to witnesses is not explicit what he's doing, it certainly at a minimum is implicit. So with regard to the experiment, the case law is clear as I have recited. With regard to this experiment, prepared solely for the purpose of litigation, not repeated, not retested, no documentation in the scientific engineering literature for the methodology or the experiment, dooms Dr. Welcher's experiment. And the bases in the jurisprudence of Massachusetts couldn't be clearer. Experiments come to courts.
Oh my God, you said this already,
extremely
dude.
Jaded
Twice
eye,
now.
as Rentalo talks about. The eye gets, both eyes
Your 45
get
minutes
even
is up,
more
bub.
jaded when it's created purposely for the litigation. And what is clear from the case law is the prejudice to
Your face is prejudice.
the defendant
and voice.
in these
Defendant.
cases by allowing
Defendant.
experts such as Dr. Welcher
And Dr.
to
Russell.
stray into all of these areas. In conclusion, Dr. Welcher is not qualified to do anything more than what the ARCA witnesses did, which is talk about and calculate forces and then determine whether or not those forces are sufficient to, and based on physics, are sufficient. So, Your Honor, we would request that because all of these deficiencies so infect all of his report, meaning the experiment is the entire basis for his opinions. You pull out the experiment, he has no basis for an opinion. You pull out a lot of his items, there is no basis for his testimony, and it frankly shouldn't be the job of the defendant or the court to fly spec his report in his slide presentation. And that is the final data point I want to hit.
Thank
which is
God.
his slide presentation.
You're
We
Why
have
saying the same
a
thing 72 times?
140-page slide presentation
So?
that is unintelligible on its own.
Oh,
You can't understand
please.
it, and the report merely references it. It doesn't explain it.
Let me stop. Mr. Brennan, do you intend to use this PowerPoint presentation?
Parts of it. It certainly needs redactions. Any reference to witness testimony needs to be redacted. Opinions on credibility needs to be redacted, but there are different demonstrations that we do expect. The demonstration at Meadows Road, which clearly depicts that the cars didn't contact the taillight, we want to produce. The drop test, similar to Arca's test, we intend to offer that. But as far as the extraneous commentary, no, that's not intended to be, it's not proper, and we wouldn't even try to.
Do you intend to use all 140 or however many?
No, that is, we were comprehensive in the production to the defense so they could see the data points, how it was produced. And so we've included, you see many of the slides is the cameras showing the different data downloads. There's only a fraction of that we would show. What we would show is the drop test, the demonstration of the Lexus hitting Mr. Welch's arm. And also we would want to show the Waze locations based on the data that will be introduced through other witnesses and after it's been attested to and its reliability.
Okay.
If I may be heard on that.
Sure.
Thank you. I still don't know the answer to your question. The defense is entitled to know.
Right, so this will have to be provided to you prior to it's done.
Thank you. And do we have a date so we can adequately prepare for trial, Your Honor, in cross-examination?
When will you have the redacted slides?
I could have them by Monday.
Okay.
And Your Honor, if we have an issue, still,
You
can we
do
submit
still
something to the
tell you,
court?
yeah.
Don't need it, another court hearing, but if Your Honor would like it, we're happy to do it just to get the basics.
Sure, so you'll get what you're entitled to, and which is just a narrowing down of what you already have. And then if you need to respond, you can respond and we'll take it from there.
Thank you.
Okay.
So in conclusion, Your Honor, the proffered information from Dr. Welcher is, in my experience, unprecedented. It is all-encompassing. It veers extraordinarily beyond his own stated boundaries. And even if he didn't state his boundaries, it's clear he's trying to perform roles, even with regard to what the Commonwealth has just said they're stipulating not to produce, still getting in extraordinarily to other disciplines for which there's no documentation.
Judge already told him he wasn't using that, and he still continued to argue.
My last point is
like an idiot.
The point made by the Supreme Judicial Court.
His texts aren't shady. They're mean, but they're
These
not shady.
experiments,
His personal phone.
Especially of the insufficiency of Dr. Welcher,
Exactly, Bree.
cannot
There's a
be
big difference.
admitted into courts and go before juries for the reasons of the improper influence on the jury. And secondly, the methodology has to be tethered to a study or something in the literature to give the court, as the gatekeeper, a basis to say, this is science. This was done pursuant to the scientific method. And Dr. Crosby, Dr. Wolf, and now Dr. Welcher are completely absent with regard to that tethering. And as the SJC says, that deprives the defendant of cross-examination and a fair trial. And I don't know why the Commonwealth, I've been saying this for months, literally, as to why the Commonwealth doesn't produce it, either in reports or in their responses to our motion. I am left with one conclusion, Your Honor, and that is they don't want to provide it, and they want to, as the Commonwealth's favorite phrase appears to be, do trial by ambush. But that can't work with a defendant in a criminal proceeding. The Commonwealth can't ambush, and that's not my standard. That's the standard of the SJC.
You don't have any standards, bud. That's clear.
That Dr. Welcher's report and his testimony be disallowed in its entirety.
No.
We will, of course, await the
Not going to
narrowing,
happen.
as Your Honor has
Judge isn't going to do that.
ordered.
Make no mistake.
And we would urge at a minimum that the defense know
She's not even
clearly
paying attention.
what this witness is going to be allowed
She
to
didn't get a gift.
testify to. And we would like to avoid an evidentiary hearing because I think it's pretty clear what the parameters are. But I have to reserve, Your Honor, our request in the alternative for an evidentiary hearing if what we get from the Commonwealth continues to be the vagueness that we've been getting all along. Thank you, Your Honor.
Okay. Mr. Brennan?
He declined any sort of gift and said, give it to Elizabeth, as in give Elizabeth a hug. I don't think you can call a gift a hug a gift.
That Mr. or Attorney Alessi sees this as some type of.
Tired of being in the denied club where building credit feels out of reach?
That would be amazing,
Meet Wendy,
Eva.
a literal supermom. But her credit, that's another story. She applied for a loan.
She owed $13. That's amazing. I love you for saying that.
Simple Rule 14 discovery. ARCA and Mr. Welcher have some similarities because they're biomechanical engineers. Now, in our production, we gave over 8 gigabytes of information from Dr. Welcher. We gave any reference material, whether he was going to use it or not.
Or not.
We gave all studies, all data, anything that he considered, even if it was irrelevant, we provided to the defense. It was an extraordinary production. I've never seen a more complete production. But Dr. Welcher gave his entire file to the defense with all of the raw material, all of the studies, all of the reference material. It's not limited to this report. As you can see, Dr. Welcher is extraordinarily thorough. You can see in the letter report all of the different things that he looked at, far beyond what any other expert has looked at in this case, far beyond, I dare say, what ARCA even considered in this case. And so it is obvious, but maybe not to the defense, so I will narrow it, that Mr. Welcher, Dr. Welcher, cannot come in and talk about the opinions or testimony of witnesses as it relates to their statement. So, for example, as Attorney Alessi points out, 1C, he won't be able to come in and would not want to come in and say that the witness did not see damage to the taillight. She'll testify to that herself, that there was no damage. In fact, all the witnesses did not see damage to that taillight. As to 2C, the testimony of Jen McCabe, that is for reference.
Oh, you said there's no damage to the taillight? Yeah, before it happened, dumbass. Pay attention. He had been paying attention.
Jen McCabe or offering anything that relates to it.
You'd know.
Similarly, 2.1 regarding Julie McCabe and grand jury minutes, he won't reference grand jury minutes in the abstract, let alone the details of it. Number 4, he will talk about the weather if it is already in evidence. It's a proper basis for an expert, but he will not be talking about the frozen ground. Similarly, in 4G and H, this is reference material regarding Julie Nagel and the Ford occupants. They'll testify to what they did and what they saw. And the people inside 34 Fairview, even though every single witness says John O'Keefe never came into Fairview, that is left for the witnesses, not for Mr. Welcher. And so the basic argument of the defense is that this biomechanical engineer should not be testifying using his principles and his education about demonstrations. What is suggested is that there's no evidence that he ever engaged in these demonstrations before, that they were exclusive for litigation, they weren't tethered to a specific study, and the methodology for each one is not outlined in a report. I wasn't sure if he was talking about Dr. Welcher or he was talking about the ARCA experts, because when I'm looking at the ARCA report, which apparently they're very comfortable with, we don't even know which witness did what. Importantly, when we look at the ARCA report, you have one witness who decided to build a potato cannon for no reason that we know of. No evidence that anybody threw a glass, but apparently it was a cool idea, he cited on the stand. That wasn't tethered to a specific study. That didn't lay out the methodology of the potato cannon. That wasn't repeated or validated. There was no specific literature that was referred to in that report. And yet, not only were they allowed to offer this evidence, it wasn't inappropriate. Now, it would be nice to know a little bit about the potato cannon, maybe a picture or a video or some specs on it, or maybe some details on how it actually operated. See, these are the things that Dr. Welcher provides to the defense. He doesn't just provide the information, the raw data, and the studies. He actually shows the demonstrations. He doesn't hide from his basis of his opinions and conclusions. He shows and demonstrates them with videos and pictures and photographs, quite unlike ARCA, where it is just simply a conclusion based on just trust me. And so when you look at the production by Dr. Welcher, it is not comparable to the standard that the defense accepts for their experts. He is a biomechanical engineer. That is a combination and study of engineering and physics and science. And it also details medicine. He's not a medical doctor. He's not diagnosing an injury, but it includes all of those arts. Now, this is the same thing that ARCA says in their report. If you look at their report, they talk about the study. And they outline what they believe the study of being a biomechanical engineer is all about. In fact, one of the complaints by Attorney Alisi is Mr. Welcher's drop test. If you look at the ARCA report on page 10, they do the very same thing, except that they don't show it. They don't actually demonstrate it. It's pale in comparison, but they give the conclusions and they give a chart. No different. And so there are no medical diagnoses by Dr. Welcher. These are his opinions based on a study of the evidence, and he goes to the extent of actually demonstrating those different assessments that he has made. In particular, the defense takes issue with basically everything he's done. And just as a general perspective, they would like the ARCA witnesses to come in and say that the injuries were not consistent with striking the taillight of the Lexus. That's what they want to say. Dr. Welcher's opinion is different. It's the same engineering, it's the same science, it's the same concept. It's just a different opinion than they like. So if they like the opinion, all of these standards that Attorney Alisi is insisting on are excused, but if they don't like the opinion, somehow should be excluded. They're really polar opposites when you think about the perspective and the opinions they give it. They both have a different opinion about the taillight causing the injury to Mr. O'Keefe's arm. One the defense likes, one they don't. It is the same science, same study, same analysis. And so if it's acceptable for ARCA, it must be acceptable for Dr. Welcher. Dr. Welcher actually downloaded the text stream data. He didn't ignore it. He didn't know that it didn't exist. He didn't fail to consider it. He actually downloaded it himself. He is experienced. He looked the material, studied the material. The text stream data is critical in this case because it shows time and place with the new information that we have. So we know from the Waze information exactly where that car went from the waterfall to the flagpole. We know where it did and didn't stop along the way. We know, based on the phone data, Mr. O'Keefe's phone data, when he was in the car until. We have all that evidence, and as a bioengineer, he can consider all of that technical data, which will be introduced through other witnesses at trial before he testifies. And it's important. The location and timing of that car is important. This is all science and data. It's not witness testimony. It's science and data. And it puts that car at that flagpole at the time Mr. O'Keefe is there with his cell phone, locked into the Bluetooth in that Lexus until he gets out of the car after 12:30. And within 2 minutes, we allege this collision occurs. And there's Apple Health data, there's location data, there's cell phone battery temperature. It all coincides. He should be able to consider these things in his study. This is what he does. The demonstration at Meadowbrook, John O'Keefe's house, is depicted by measurements which has been provided, science and data, by the ring videos, which will be independently admissible. And we see the gentle nudging of that Lexus into Mr. O'Keefe's car. And there has been allegations, claims, suggestions that that's where the taillight may have broken despite the other contrary evidence. You can see in the presentation, he actually shows not only the nudging and the car leaving through the ring video, but analyzes it, and you can see exactly where those two cars came into contact, and it wasn't the taillight. You can see through his demonstration or through his study of the materials he presented that the snow is on the back of Mr. O'Keefe's bumper until the nudge, and you can see the exact spots where the snow comes off. This is science and data. This is an opinion. This isn't witness testimony. And the jury should see that very evidence. It'll be admissible not only through him, but through independent witnesses. The defense takes issue with Dr. Welcher providing an opinion that the lacerations and cuts are consistent with the geometry and orientation of the right taillight. There has been many claims about alternative sources, which the Commonwealth disagrees with, as to those abrasions. But if you've seen the PowerPoint that's been presented and provided to the court, will be presented to the jury, it shows the symmetry of the arm and the location of the arm, the height of the broken taillight, and it shows with great continuity the height, location of that broken taillight, and how it relates to a bent arm. And that is based on engineering, biomechanics, the same things that ARCA employs. They just didn't do this. And so that's not witness testimony. That's not beyond the bounds of anything. That is powerful evidence, and we intend to introduce that. And then, as I mentioned, finally, the drop test. This is the same information that ARCA proposes in their report. For some reason, I don't think that was offered as evidence at trial, but it's clearly within the bailiwick of this expert. And so we will file on Monday a PowerPoint presentation redacting all the inadmissible parts of it, which is witness statements. And we expect to present the demonstrations to support the opinions as corroborative evidence of those opinions rather than just naked opinions. And there will be no trial by ambush. Now, we will be studious in getting that information to the defense. We would like them to be as studious getting us the ARCA information. It does concern me delaying that information because, as Attorney Alisi eloquently said, you need time to prepare. We know he's a very prepared attorney. We'd like to prepare as well. And if we wait to get records and information and know who wrote what part of the report, we won't be prepared. There's a third.
$1,500 a month if you also take care of a friend or relative at home? No way, right? Most people don't know that there is an easy way to receive personalized.
Also inclined to ask the court to consider we have that questioning well before their testimony. But we will meet our commitment and provide those slides on Monday.
All right. And Mr. Alessi, again, you've already said you agree to talk to Mr. Brennan about the reciprocal discovery.
Yes.
Okay.
May I be heard your response?
Sure.
Thank you.
Like with Dr. Welcher's report, what Attorney Brennan did not say is even more important than what he did say moments ago. He didn't state or even address where is the methodology employed by Dr. Welcher tethered to a study, the scientific literature. He kept using the phrase, it's science and data, quote. Someone alleging that it's science and data doesn't even begin to approach that the methodology is established in the literature or satisfies the Dalbert-Lanigan factors. So, Your Honor, on the record before you, there's no better evidence that that tethering doesn't exist than the absence now for the fourth time upon challenge of that in Attorney Brennan's comments. That dooms Dr. Welcher. Now I want to address the false equivalency argument of Attorney Brennan. Attorney Brennan said falsely just now that the ARCA report does not set forth the methodology. There are 14 footnotes in the ARCA report. I just looked at them again. Footnotes 1, 2, and 3 tether the methodology of the ARCA experts to the literature. The methodology is documented. I do not understand how an attorney can get up and say a report doesn't have something without having a basis for saying it. On a key issue that is disputed. Attorney Brennan also falsely stated
No, he didn't
that
falsely
ARCA
state
did
anything.
exactly what
They did.
Dr. Welcher did with regard to medicine and medical issues. That is completely false. ARCA, as is clear as day from the report, and I'll repeat it, did a force net equals mass time acceleration calculation and said the forces that come from 15 miles an hour, 24 miles an hour, and then so the unknown is the force, the F in the calculation. What is known is the M and the A. The M is the mass of the head and the mass of the arm. The mass is 11 pounds. The mass of the arm is 11 pounds. You then take the acceleration theory, even assuming the theory of the Commonwealth, which we can test, which is it's 15 miles per hour or 24 miles per hour. You multiply the mass times the acceleration and you get a force. And then they said this force is expected to cause or not cause these types of injuries. That is a proper biomechanical engineering analysis. The ARCA experts didn't get into
I didn't know you were an engineer, so you know the proper
with
way,
regard to the wounds, the orientation, etc. But most importantly, there is no equivalency between what ARCA did and what Dr. Welcher did. With regard to Mr. Brennan stating, quote, this is what he does, referring to Dr. Welcher.
Yeah, it's his job.
The question is not, is this what he does?
Yeah, it is.
The question is what he does rooted in science. And what it means is not just any science, it has to be a commonly accepted methodology, commonly accepted for satisfying the Daubert factors. And Mr. Brennan did not contest one aspect. He didn't say, Your Honor, here is where what Dr. Welcher did can be found. It's commonly accepted either in court opinions, which the court can take judicial notice of, or in peer-reviewed literature, because it's not there. And with regard to the 5 non-exclusive Daubert factors, I covered that in my presentation in the beginning. I'm not going to repeat it, only to say that Mr. Brennan didn't address any of those 5 factors to show a proper foundation for that. With regard to what Mr. Brennan called arm experiment, relating to a bent arm, relating to injuries. I understand what Dr. Welcher did.
Oh, God.
The question's not what did he do, but is
Half
it
the day on
accepted
him.
in the medical literature? So with regard to the arm experiment that Mr. Brennan just went through, he talked about it, but he didn't mention once where that's rooted in the literature. He finally concluded by saying, this is within the bailiwick of Dr. Welcher. I don't know what this is, but bailiwick is a tautology. It doesn't say anything about whether what he did is rooted in the literature or that it satisfies the App Daubert factors. So in conclusion, Your Honor, I go back to Rintala, I go back to Meeks, I go back to Case of Caravan. The Commonwealth has not today, not before, this is their 4th time, has not satisfied what the Supreme Judicial Court requires in these instances. And what it has come down to is the defendants, which states in a different position. equivalency between ARCA, I've shown, and it's easily documented, the court can see it, that contrary to Attorney Brennan's false statement, ARCA did cite to and tether their methodology to the literature. But when you have a defendant on trial for the seriousness of the charges here, to have no methodology, to have no tethering to the literature.
He knows how to say it right, though.
That's, as Your Honor knows, the gatekeeper's function to
I'm going to give him
stop
$1 in breadstick money to say it right.
those opinions from going to the jury, to ensure not what the defense has created, but what the Supreme Judicial Court has created, which is the purpose is to allow for cross-examination and a fair trial. They have satisfied their burden, they have the preponderance of the evidence burden, and the consequences should be borne by the Commonwealth, not the defendant.
Defendant!
Okay. Go ahead, I'll hear a quick response.
Defendant! An idiot.
Regrettably, I know Attorney Alisi has decided to join the fray of disparagement. Now, he has said 3 times that I've made false statements. This isn't the first time that Mr. Alessi has tried to portray the Commonwealth as being disingenuous, because they know full well this is being covered by the media, and they want to create a sense to dehumanize anything that they don't like, whether it's the government, the prosecution, the witnesses, or the evidence.
Yep.
There's no place for it. 3 times. This follows when he made representations, reckless representations in court, that Brennan lied 10 times. We found some of those transcripts, and I took enough dignity not to mention it, because I didn't think I needed to.
What you did?
The transcripts were not even accurate. Mr. Alisi was actually wrong when he was claiming I was lying about reading reports. Now, I don't want to stand up here and have a dispute, but when you use words like false statements as an officer of the court, they better be supported. That is a strong statement to repeatedly make, and it's a tactical one. It's purposeful. Attorney Alisi is joining the fray, and that is all part of the strategy here. Now, if you look at page 13 and 14 of Dr. Welch's report, perhaps that was missed in the review. There are resources in that report that number 26 different items of resources. And so if we're talking about support and tethering, it is at the end of the report. It's not footnoted like ARCA, it's at the end of the report. It's all there.
All right, thank you.
I found that out 2 years ago. The turkeys actually can fly.
Try and get some motions in quickly.
Yeah, because Lacey takes up half
motion
a day,
regarding the
every day.
chalks. Is there an objection to the Commonwealth's motion requesting the use of chalks and directing both parties to provide visual presentations and chalks prior to using?
No objection.
Okay, thank you.
Oh, shocker.
583.
I object to everything. From the helicopter.
Is there an
No, not
objection
dropping.
to the Commonwealth's motion eliminate to allow the expert Celebrite demonstration? We had it before. Is there an objection to that from the defense?
Yes, Your Honor.
Okay.
Yeah, it is.
Is
Pretty-
this something that can be done quickly, or
Pretty
is
bad.
this something you need more time on?
Yeah.
15 to 20 minutes, Your Honor.
All right,
Come
so
on.
we're gonna have to table this. We may end up coming back tomorrow.
Ooh.
I can do it unless you tell me what
No,
Your Honor.
let's see what we can get before the luncheon break.
Yeah,
The
'cause you
paper
take
number
forever.
585, it's the Commonwealth's number 11. Motion eliminate to admit the victim's out-of-court statements relating to John O'Keefe's state of mind, the quals, bins, types of cases.
I love you, Casey.
So is there an
Shocker,
objection
don't you?
from the defense on that? If there is, I'll hear it quickly from the Commonwealth on its motion.
There is, Your Honor.
Okay, so I'll hear you on this, Mr. Brennan.
Let's go, Brennan. She never has fucking full days, but I think she has other shit on her schedule.
Evidence of Mr. O'Keefe's state of mind is particularly relevant in this case. In addition to the charges, this has a domestic aspect to the case. We know from his statements that he was in a relationship with the defendant. We know
Maybe it's
from the
lunch break,
statements
I don't know.
that there was a tumult in that relationship. And many of those statements are reduced to writing. The state of mind of Mr. O'Keefe is reflected in those statements. There was no time or reason to fabricate. You can tell by the content and the volume of them that there is a legitimacy to them. And it is clear based on that.
Oh, dish soap is on sale. We need it.
Yeah, I think we need ketchup too.
What's in there?
Over the course of the day of this incident.
All right, so what's the time frame? It's so over the course of the day. I realize that the Aruba incident is too remote and you're not using that, but what's your time frame for me to be able to evaluate
As
this?
far as his messages, I will
Or
look.
the statements or the evidence that you're trying to put in under this doctrine?
His niece would testify, as she did in the last trial, about the tumult in the relationship.
Okay.
And we'd introduce the same text messages that we introduced at the last trial, reflecting Mr. O'Keefe's state of mind about the relationship.
Okay.
And there would be nothing different from the last trial, other than the fact that we are not going to pursue the Aruba information. So it is actually a narrower time window than before.
Okay. All right, I'll hear you, Mr. Jackson.
Thank you, Your Honor. I may be a little more brief given that explanation by Mr. Brennan than I intended or anticipated. I will say that where the Commonwealth's motion fails is in its explanation as to the relevancy and how it comes in under a state of mind theory. These are obviously hearsay statements. In some cases, they are multiple hearsay statements. Or potentially multiple hearsay statements. John O'Keefe's state of mind is irrelevant unless there is a specific admissible evidence that he communicated those statements, and we'll have to sort of take them as they come, given I don't have the full breadth or an understanding of the full breadth of the information that is being sought. Mr. Brennan just indicated it's going to be consistent with the last trial, so that gives me some target range. But without knowing more, under a normal hearsay or even state of mind analysis, it's irrelevant unless there's a specific admissible point that he communicated that, or point at which he communicated that state of mind to Ms. Reed. She was aware of his state of mind, and very importantly, that the information that was communicated to her was of such a nature that she would have acted on it in a manner that's consistent
That's
with.
what we were talking about, the bins, calls, those points that
Correct.
need to be made.
And that's what I'm getting to. With that last point, and to drive this point home, that's preposterous. The idea, there is no evidence to support that last point, that this type of information, let's say, for instance, it's information that he wanted to break up with her, or he was mad at her, or he was angry at her about something, some incident, some specific thing having to do with feeding the kids donuts or not feeding the kids donuts, or they had what was considered, what was testified to in the first trial as a very normal row or argument about something as insignificant as that. The fact is, the state of the evidence is that on the night in question, it's uncontroverted by even the Commonwealth that the two of them were getting along extraordinarily well. The facts are borne out in both videos that are uncontested. They're borne out in witness statement that went uncontested, that they were affectionate, they were happy together. They were described by basically everyone on the Albert side, the McCabe side, as well as individuals who also saw, that were not related to those families, who also saw Karen and John interacting throughout the evening. And they all said that they were getting along very, very well. One person described them, the court may remember this phrase, as lovey-dovey. I think that it's pretty clear that through this testimony, or through this rubric of bringing in John O'Keefe's state of mind, the Commonwealth really wants an opportunity to call one or more or several witnesses who will basically say he wanted to break up with her, she was not a good girlfriend, he didn't like her. That is an assassination of her character. You can couch it in whatever terms he wants, but that's really what it is. These witnesses will have no corroboration, we expect. I'm leaving the text messages aside. If there are text messages between John O'Keefe and Karen Reed, that may be a different analysis, but certainly where it comes down to the witnesses, like the niece, they'll have no corroboration or no documents, no writings, no recordings, no videos, no audios, nothing but their word. And to allow a witness to walk in and to say negative things about Miss Reed with no way of verifying those statements is highly prejudicial. It's not just prejudicial, it's far more prejudicial than it would ever be probative in this circumstance. Even if he did, even if the evidence was that he had discussed breaking up with other people, there are two major impediments to the Commonwealth's request. First, there is no evidence that, for instance, from the niece, I don't believe that there will be evidence that was imparted, or those specific conversations were imparted to Ms. Reed. The state of the facts very clearly show the opposite. If we look at the circumstantial evidence, the videos of Ms. Reed at both C.F. McCarthy that night, as well as at the waterfall that night, showed the two of them getting along, completely inconsistent with two people who were talking about breaking up. John O'Keefe wanting to dump her and her knowing that she was going to be dumped, which is what the Commonwealth is generally suggesting. And second, there's absolutely no evidence that even if she thought that John O'Keefe, if she was aware that John O'Keefe was unhappy in the relationship, that he might want to break up or end the relationship, that would have been a catalyst for murder. And that's where the rubber meets the road in this analysis. That's what the Commonwealth has an obligation to prove before this evidence is admissible. And that's a ridiculous stretch. They'd been together for about 2 years, notwithstanding the prior relationship many years earlier. She had her own career. Karen Reed had her own money. She had her own life. She had her own job, had her own house. She was not dependent upon John for anything, not for money, not for room and board, nothing. They were, at the end of the day, just dating. The fact that she had some text messages with other individuals, and other individual, Higgins, is actually evidence that she knew she had options, and John O'Keefe likely knew he had options as well. Both of these individuals were not tethered to each other in a way that if one wanted to break up with the other one was going to murder the other one. And that's what the Commonwealth would have to prove to make this admissible. There's no suggestion in the facts that Karen Reed would kill John O'Keefe rather than simply break up with him or allow him to break up with her, and they both go on their own way. It's absurd. And there's no evidence that she was angry with him that night before she got out of her SUV. All of the evidence that we have, all of the uncontroverted evidence that we have, establishes exactly the opposite. They were a loving couple, out one evening, having drinks with friends, in a good mood, and happy with one another. We cite a case called McGraw, M-A-G-R-A-W. And just for the record, I'll state the site. I think it's at 426 Mass 589. And the McGraw court provided a very defined quote that I think is illustrative for our purposes, Your Honor. Quote, a murder victim's state of mind may be material to the defendant's motive, but only if the defendant knew of the victim's state of mind, and most importantly, the court's words, not mine, and most importantly, would be likely to respond to it. The best evidence that this second prong cannot be met is the fact that the Commonwealth will attempt to bring in these prior statements of John, which, if believed, Ms. Reed never acted on. In other words, they're going to bring in prior statements to say she would necessarily act on it and act on it in a violent way that would take someone's life. But at the same time, they're stuck with the very clear fact that if in fact that's true and it was imparted to her that he was unhappy in the relationship, she never acted on it, not once. And the moment that we do have frozen in time that we can go look back on is the night of January 29th, or the evening of January 28th, going into the early morning hours of January 29th, in which they were both getting along perfectly well, completely in opposite of what the court in McGraw defines as necessary for that sort of evidence to be admissible. The reason that the Commonwealth's theory for admission doesn't make sense is because it's not really their theory for admission, I suspect. I suspect that it's more that they would like to have someone or some people get on the witness stand and assail Miss Reed's character, make her look bad, and say that she was either a bad girlfriend or that John was not happy with her. It's an attempt to inflame the jury, to make them dislike her for something that has nothing to do with the evidence that she hit him with her SUV on the night in question. And it's a very transparent attempt. We strongly believe that this attempt does not meet the evidentiary standards that are required. The Commonwealth cannot meet those standards, and pursuant to McGraw and its progeny, we would ask that this evidence be deemed inadmissible.
Okay. Quick follow-up.
It seems the thrust of the defense argument, and I appreciate their advocacy and argument, but it's not shared by the Commonwealth, is that they were lovey-dovey and got along well that night. Well, at the time of this incident, it seems there's substantial evidence that Ms. Reed was not happy with Mr. O'Keefe. On 2020, transcript page 43, line 1, she was asked, would you say that you were angry with John that night? Her answer was yes. She was asked by Ms. Voss on June 20th, 2023 about that night, or the day before, and she says, I was temporarily frustrated. It wasn't an argument. She also says to Ms. Voss, were you worried at him or pissed at him or both? I was pissed until I fell asleep. Now, in addition to her anger, she specifies some of the tension. We heard from the testimony of Jen McCabe that when she gave directions to John O'Keefe, she mentioned a mother of a child who Mr. O'Keefe had a prior relationship with. That this is minutes before we allege the collision happened. And so in the interviews that she has provided to these different outlets, she...
What if the lottery was on your phone? With real tickets, real winners.
And that there was an issue or some type of interaction about the fact that he was previously dated another woman. And this is a conversation that takes place minutes before the collision. And so we have statements from the defendant herself that show the discord in the relationship, the anger, being pissed, the motive, without leading them because it's unnecessary. There is substantial corroborative evidence. Not only that the text messages, which are corroborated by the niece's testimony, but the imminency of it, that this is happening in real time, moments before John O'Keefe's death. And so all of this should be admissible. It's all supportive of each other.
Your Honor, if I could just correct the record very quickly.
Sure.
If anything Mr. Brennan just said was true, he might have an argument. My goodness. It's important to get some of the facts right. You got to get some of them right. The conversation that he just referenced with Jen McCabe was the next day. It was the next morning, not minutes before the collision. He's read the transcript. Every time he stands up, he says, I read the I wasn't there. I read the transcript. We got to hold him to that burden, Your Honor. You got to get the facts right. That conversation with Jen McCabe was the next morning after John O'Keefe had been found, after he didn't come home.
I'm sorry, I just need to correct.
I'm sorry. I was talking to my client real quick. I'm not quite done. This was during the time after 5:07, after the SUV leaves, we see One Meadows, and Jen McCabe and Carrie Roberts get together. And as they're looking for them, as they're looking for him and searching for him, that's the point at which they have the conversation about being some other woman, or why he might not have come home, or what her mindset might have been at the time. It's after the fact, well after the fact. The other issues concerning Karen Reed's statements about being upset, or in Gretchen Voss's words, were you pissed at him? It was in context of when. When were you upset with him? When he didn't come back out, when he didn't come back to the car. After she left, she was angry. That's where all the voicemails take place. That's what she was talking about, having been angry. There is no evidence, none whatsoever, no evidence in the record. I want to make this as crystal clear as I can. no controverted evidence, no suspect, no evidence at all that John O'Keefe and Karen Reed had a single crossword that night before he ended up missing and she went home. Before he ended up walking out of the car, going toward the house, and she ended up leaving when he didn't come back out. Zero. The only evidence that was propounded throughout that entire day was hours and hours earlier that morning dealing with, did you feed the kids donuts? And yeah, I did. You know I don't like it when you feed the kids donuts. She was spoiling the kids. It was not enough to enrage anybody. It's ridiculous. And the evidence that it didn't enrage anybody is the fact that they ended up later that night together in a lovey-dovey environment, getting along fine, getting along wonderfully. That's why the Commonwealth cannot make their burden to establish that this was the type of information that she would have, by necessity, acted on, and not just acted on in any way, acted on in a way that's consistent with their theory that she would have received the information and murdered him for it. That's the hurdle over which the Commonwealth cannot leap for the admissibility of this type of evidence. It's far, far more prejudicial than it is probative.
Okay.
Before accusing somebody of getting it wrong, the person accusing should be right. I know that Mr. Jackson, Attorney Jackson, was present during the Voss interviews, but apparently they haven't listened to the interviews or read the transcripts. Page 88, line 22. Not the next morning. When Jen was navigating John to the Alberts, she said it's near Ashley's house. Ashley and John had hooked up prior to John and I dating. Similarly, page 92, line 1, totally contrary to what you just heard. Totally. There was a woman who was a mother to kids that were close to John's kids who lived very close to the Alberts. In fact, when Jen was navigating John to the Alberts, when I was driving, she said it near Ashley's house. Ashley and John had hooked up prior to John and I dating. She broke up briefly with her husband. Not my words.
All right. So we're going to break. We've got a lot of ground to still cover. I suggest that we take the personal attacks completely out of this.
Yeah, the defense is never going to do that.
Both sides. Both sides. I
Can't
wanna
say
get
both
through these
sides
motions today.
when he's
If we
just
don't,
defending
I'll bring you
himself.
back tomorrow. I'll bring you back Monday. Let's get through these motions. Leave all the attacks, all the falsehoods, all of that. Leave it all aside. Let's focus on the motions and get through this. So I'll see everybody at 2 o'clock.
Your Honor, if I could say one more thing.
No.
As the court ponders this last issue.
I'm not even thinking about it for the next hour. Let's leave it. Yeah.
Yeah, basically shut the fuck up. We're not going to let you sit there and try to backtrack your lie. Sorry. It's not going to happen, Jackson. Once again, you keep trying and trying and trying with these misrepresentations. Judge needs to do something. Although we know that she will not, she needs to. She absolutely fucking needs to. Enough is enough. And she really can't even say both sides because Hank has literally ignored so many of the things that they've like accused him of just to like be proper. Like, you know what I'm saying? Like, just to be proper, Hank has completely ignored some of this shit. Like, so when Hank finally does stick up for himself after repeated assertions that are completely false, then she says both sides. No, how about talk to the defense once again? I thought you said you weren't going to deal with, but yet here we are once again dealing with it, just like she did 5 minutes after she told them not to misrepresent or lie or stretch the truth the last time, and they did it not even 3 minutes later. Like, yeah, that is what I have heard, is that it's not good for Karen at all. And you have to remember that the data that they didn't have before, that they have now, like Jackson and Yannetti would be screaming from the rooftops if there was something in there. They would find a way to put it in motion, or so that everyone would know about it if it was somehow good for Karen. So make no mistake, it is not good for Karen at all. Unless he makes me want to smash my head off a brick wall repeatedly. I cannot, and I have to listen to him. So it's like the dude literally makes the same argument 3 different times, like over and over and over. And if you heard the judge and Hank Brennan being like, "Well, we know Mr. Alisi is very thorough," that's their way of saying, like, bro, shut the fuck up. You take too long. Okay. You take too long, sir. Like, you're taking up half of the court's time to say the same thing 17 times and to go around in effing circles. There's no need, dude. Make your argument and move along with it. Maybe you're used to making long-winded arguments when it comes to environmental law, but this ain't environmental law, sir. Like, it's time to actually, like, make the argument, make your point, and move on. Because when you make a point over and over and over 17 times in 17 different ways and take all that time, you have then lost it. Like, nobody's listening at that point. So if he does that in front of a jury, right, this whole going around in circles thing, he's going to lose the jury. You're going to lose the jury completely. The jury has now tuned you out because you're saying the same thing 7 different ways and they've heard it already. Never mind the fact that when the judge is like, okay, well, you can take that out and that out. They're not using the frozen ground with this witness, and they're not using whatever else it was with this witness. He still sits there and argues over it. It's like, bro, the judge just told you, like, they're taking that part out. So you should have taken that part of your argument and said, okay, thank you, Your Honor. I won't argue that portion of it. But he didn't. He continued on to argue that portion of it. And the judge was like, but we just said that's not going to be in. So, like, but he had to. He has to hear himself talk, you guys. He has to. Do you know how many times I wanted to interrupt, like, his ridiculous rant and just hit this button and play this? Because this is all I could think about every time he opened his mouth and ranted about nothingness, is this.
I think we got a super chat. I think we got a super chat.
That clown show. Because that is what Free Karen Read is. The crux of it. That clown show. Like, oh, the defense knows what's in the new text stream. Yeah. Yep. They have to. Because it has to be given to them. Everything has to be turned over. The defense has to know everything that the prosecution knows, and vice versa. So yeah, they know. They absolutely know. That's why I say make no mistake. If any of it was good for Karen, they'd be screaming it from the rooftops. And we do know that there's a lot of data that they got that was missed the first time around. So, and we heard Hank give us like a little bit of it, like a little bit of it. Also, while all that was happening, we did get a $13 dono for the 13 times he had said methodology. It says methodology from Eva. Thank you, Eva. I appreciate you. And then one from the House of Beaver. But as she said, it says House of Beaver methodology dodo, and it is $13 in Canadian, which then turns into $8.70. I think she said, yeah, $8.70 in American. So thanks, Canadians. I appreciate you. The exchange rate. But I appreciate you guys. And then we have a donation on Venmo from Bree, a very generous one. I appreciate you, Bree. Love you. Heart skis. So I just wanted to read those real quick because I don't want to forget about them. And I do appreciate donations to my channel because we are tiny. That's what we run on here. If we don't get them, we don't pay for costs and we don't run. So I appreciate it. If anybody else wants to, there's Cash App, Venmo, and PayPal. Or you can just like the video, you can share the video, hit the subscribe button if you already haven't. There is a ticker on the bottom of the screen. So if you just missed what I just put up to do it and you're like, ah, shit, Elise, you took it down too fast. Don't you worry. It's at the bottom of the screen and it scrolls by. It's very easy to miss. It's very small. I cannot make it bigger. People ask me all the time. I cannot. I'm sorry. I wish I could. But the ticker is that size, I guess, for a reason. I guess so it's not blocking everything else you're watching. But I can't make it bigger. I cannot. I cannot make it bigger. I did notice, let's go back for a second. I do want you guys to, I just want to point this out with my little pointer here now that you guys can see this part, right? I want to point out something funny. Hold on. Let's go back. Boop, boop, boop. And it's muted, so we don't need to like listen to the audio on it, but God, he talked for so long. Just look at this right here. This looks very upset. Looks like he's clenching his butt cheeks a little. Like he's very worried, you know, or you're worried, you know. And over here we have Sue, the dum-dum, who says she's commentary, but then often acts like she's some sort of journalist. I'm not really sure why a news channel employs her for commentary when she says things as if they are fact and when they in fact are not. So yeah, we got that over here. And here we have Ted Daniels. Oh, this is still clenching his butt cheeks. We have Ted Daniels here, right here, giving baseball signs now. This is Ted Daniels, who knew for a year that the federal investigation was over because he knew at the same time I did. And then this here, this is Christina Rex. You guys might see her. You've seen her in the documentary. This woman right here is a rock star. This is Peggy O'Keefe. This is Smithers over here. This right here. This is Smithers. This is, you know, Mr. Burns here, and this is Smithers here. So, you know, the errand boy right there, Karen's brother, Smithers. And then back here you got, you know, cult member. You know, 2 cult members left. I don't know where they went, but you know, culty. You know, Mrs. Reed, who always looks like she's just not even in this world. She looks like she's like always just staring off into the abyss of I don't even know where. No one's seems home up there. Almost like her body's moving, but like her brain is not. You know, just saying. Like, but if you notice, while Elise is going on and on, because that's what Grant calls him, right? Elise. I love that they call him Spanky, right? They like to call Brennan Spanky. It's like, yeah, you can call him Spanky all you want, dude. He spanks the fuck out of your arguments every goddamn time. Every goddamn time, dude. He spanks the ever-loving shit out of your crap arguments every time. And he comes with receipts. Just saying. He comes with receipts. Notice there's no receipts coming from the defense. They just rank speculation and pointing fingers. But Hanky, he comes with the receiptskis. The receiptskis this man has. I do. So I've, you know, watching this, I'm like watching. And I'm, you know, you pay attention to everybody's facial expressions and what they're looking at, what they're doing. And this particular sewer turtle here seems very concerned, worried about something, very upset. Could it be that he's realizing somebody hacked him? And I realized that during the stream when people sent it to me, and then I shared it on X. So I think he's probably getting messages now like, hey, you're hacked and tracked. Whoever did that, you are extremely bold, but it's still extremely funny. It's very slimy, but he's a slimy dude. Make no mistake, he's a slimy dude. There's nothing not slimy about him, you know? Yeah, apparently. So I found out during this live stream, probably like an hour ago, and I reshared it on X, and maybe a little more than an hour ago, and he found out shortly after that the cult was sending him a message. You could tell. Went from kind of relaxed to just staring at that screen and typing, which he doesn't ever do. He doesn't usually type. He just has it open. He, you know, he didn't hear a word of what was happening here. Not a frickin' single word. Most of the time, he doesn't actually listen to what's happening in court. He has to have somebody else tell him later. The problem with that is what he has other people tell him later is not accurate. And it's from the mob point of view because he doesn't pay attention. He's more worried about him being in the camera view and the camera seeing him than anything else that's going on. And usually that's due to the egotistical narcissism he has going on. You know, that's part of it. You know, the cluster B personality of thinking you're better than everyone else and you're so awesome and so smart and so everything. And that is who he is wrapped up in a little box. You know, he loves to think he is the shiznizzle. All that and a bag of chips, y'all. Snippity snap, snap, snap. Tells everybody how awesome he is. Because I think it's a way for him to believe it himself. I think that is a way for him to actually think he is a good person or a smart person, is by saying it over and over to his audience and hoping he just believes it after he says it so many times. A cult works that way, you know. A cult works that way where they use mantras. My reviews. They use mantras. They repeat them over and over and over and over so that ultimately the cult repeats them over and over and over and over. And the cult starts to believe them because they're said over and over and over and over. So, I mean, if you ever actually really look into the way cults operate, you would see this for exactly what it is when it comes to him and his zombie for Karen Reed bunch, which is, it is a cult. Absolutely. 100% a cult. Sad, but true. It is a cult. All of the things that he does, the dog whistles to make the mob attack people. What really has me the most, look, he's freaking out. He's worried. He's upset, stressed out. Have you ever seen a body language expert that shows you when somebody not just like is laying on their hands, because plenty of people do that, you know, like just sitting there watching, but when they sort of move back and forth and they do this and they can't help but to like keep doing a lot of this, squiggling around a lot, like it's because they're stressed out about something. Who knows? Maybe it's impending doom feeling of those 20 felony charges that he has on his record. And maybe it's the impending doom of all of the things that are in his phone that he knows could get him charged with numerous amounts of either wiretapping or blackmail, extortion, threats, you know, criminal harassment, cyber stalking, just a multitude of different, Rico, if you wanted to go there, just a multitude of charges. I mean, my butthole would be puckered if I did all that and I had to worry about all that. So you got a culty over here bobbing their head above the camera as they over on Karen's side. They want to be seen by the camera, so they keep sitting straight up so that the camera can see them, and they keep moving back and forth when Miss Reed moves her head. Mrs. Reed. When Mrs. Reed moves her head and blocks them, they bob around it. They care about the limelight. They don't give a shit about John. Karen said it herself. If you guys watch this documentary, like she wanted to differentiate for justice for John because she didn't want people to think she was justice for John, right? Please tell me some of you watched the documentary last night when it did the other two parts and they talked about the harassment. And Karen, and now you know why the sewer turtle uses this as an excuse, because Karen did. So that's where he got it from. Says, yeah, he goes to people's doors and says things, but is that harassment? Because they really shouldn't be witnesses. They should have been suspects. So is it harassment? Like, no, like should have, could have, would have. They are witnesses. They are not suspects. And it is witness intimidation and it is witness harassment. No matter how much you want or think it shouldn't have been, or they shouldn't have been witnesses, that's not reality. That's not the truth. So Karen essentially says, yeah, he did these things, but I mean, they shouldn't have been witnesses. So like, who cares, right? Like that's essentially what she says, is like, oh, but they shouldn't have been witnesses, so who gives a shit? Like, that's very bad for her. Like, that whole documentary is so bad for her. Usually people with cluster V personalities don't even realize how shitty they come across, how egotistical, how condescending, how inhumane and unsympathetic unempathetic that they look and sound. They think they're just everything. And that's part of the problem is they don't actually realize how awful they are. They actually believe somewhere here that they're not awful human beings. Well, as we know, that's not reality because they don't live in the realm of reality. They live in the realm of up here in their own heads where they have delusions of grandeur. Everything about them is amazing and awesome. You know, like I'm not saying people shouldn't have self-confidence. People should have self-confidence that they are amazing and awesome. But if you see the way these two do it, they never make a mistake. They never take responsibility for a goddamn single thing ever in life. It's always everyone else's fault. Most people make mistakes in life. I've made plenty. I was an addict, you know, after years of abuse as a kid and in foster care. But I got my shit together, right? Changed my entire life around. Been sober from opiates for 18 years. It's a long time. Like, people make mistakes. It's about owning them and moving forward afterwards. There's no secrets that I need to keep from my audience. My audience is fully aware that I was someone who used to be an addict. I was someone who had a baby very young. I was someone who was broken inside. I was broken. I'm a survivor of domestic violence. I am a survivor of addiction. I'm a survivor of abuse. All of those things make me who I am today. So I've made plenty of mistakes. So it's like, what do you guys want to talk about? The only thing they ever talk about when it comes to me is that I'm poor. Oh, shocker there. My family's the working poor. I should just be so ashamed that we're the working poor. I should be so ashamed that I have to spend more money to go back and forth with a sick kid so that I have to put less food in my house. I should be ashamed of that, right? No, I'm not ashamed. My family is the working poor because my family works. So no, I am not ashamed. My family is working poor. Nobody should be ashamed that they're rich, poor, middle. That doesn't make people who they are. As a matter of fact, some of the shittiest people I know make tons of money. Isn't that a fucking shocker? But also some of the best people I know make tons of money. And some of the best people I know make shit for money. Like, there's shitty people that make no money. That doesn't make anybody who they are. So it's like, you want to hammer away, make fake accounts about me because I'm poor. You go right ahead and do that. If that makes you feel good inside, then you go right ahead and do that. But I don't not take responsibility for the things in my life that I fucked up. I fucked up plenty. Everyone does. Newsflash. Newsflash for humans. We're imperfect. It's kind of how it works. Like, have any of you ever made a mistake? Someone tell me you haven't, please, for the love of God. I think when you have to attack other people and harass other people and constantly disparage other people, we've had this talk before, it's not the person who you're doing it to. That's the shitty person. It's you doing it to other people. You're the shitty person. You're the one with the problem. You're the one who might need some therapy. I can give you a good therapist. I mean, she's been my therapist for a long time. She's really good at what she does. Like, I have her for trauma therapy. Most people know I have CPTSD, which is complex post-traumatic stress. Not ashamed. Not ashamed. As a matter of fact, I embrace those imperfections about myself because no one's perfect. There's just no such thing. But at the end of the day, I can look myself in a mirror and I sleep just fine knowing who I am. When you go online all day long and just harass people, try to disparage them, try to insult them, try to make shit up about them just to push that out in the public sphere because you don't like what they said or you don't like their point on this case, like, you're the sad person living a pretty pathetic life. I don't spend time doing that. I never will, and I never have. I have defended myself when I've felt the need, but I've never taken time out of my day to go find other people on X and sit there and disparage them. There are two people that I call out, and I will always call out, and it's the sewer turtle here who looks very uncomfortable with his puckered butthole, and Karen Reed and her defense team and all the damage that they have done to all of the victims in this effing fiasco, in this case. There are far too many people these two have hurt. And as we saw on display in the documentary, Karen just thinks it's funny. And we already know that the sewer turtle thinks it's funny. That's no shocker or that's no surprise to anybody. Like, we all know that. He argues against his own arguments constantly. So I don't really know how he's going to argue his cases in court when he argues against his own arguments in his other cases. It just doesn't make logical sense. Then he gets on his show and argues against his own arguments he's using in court. And it's like, bro, do you ever shut up? Because attorney's job is to tell you when to shut the F up. You can do a show without shooting yourself in the foot, but you, sir, you are special kind of stupid. A special kind of stupid with no actual impulse control, just like Karen Reed, no actual self-awareness. You just keep on trucking. Just keep going. Like Dory, just keep swimming. Just keep swimming. You know, swim through the lies with these two. They just swimming on through the lies. And they go to the end, and make no mistake, neither one of these two, if they were offered any sort of deal, would take it. They're too egotistical. If Aiden is offered a deal right now to turn on Karen Reed, make no mistake, he's not going to do it. He would rather sit in jail than ever admit he was wrong or ever admit he hurt anyone or ever take responsibility for a damn thing. The man's never taken responsibility in his life for a goddamn thing. I find it funny this morning, though, that Bradel argued that they are filing a motion to keep out husband/wife communications. He's no longer married to his ex-wife. So I think I'd have to look into this, but I think she would have to agree to that for it being privileged material, because she can waive that right to not care if they have it or not. And if I was her, I would. I am shocked. Actually, I'm not shocked. I'm a little shocked that she hasn't stepped forward and said anything, because you would think after the years and years of what that woman went through, that she would at least have some of these victims' backs by saying, I know what you went through. It's awful. I know who he is. And even maybe give some evidence to the Commonwealth that would prove what a piece of human garbage and how many crimes he's committed just against his own family. Because make no mistake, if he's willing to threaten people on Facebook and X DMs, then you can bet your ass he did it in person to his wife. Like, control is a big thing with cluster B personalities. They can't not have control. Control is huge. If they think they're losing control, they snap. That's why oftentimes when something bad happens that he can't fix, then magically he gets on and he hate tweets, or he goes bonkers on a live stream, like absolutely just not thinking about the things he's doing or saying. It's because he's lost control of something, or he feels like he's losing control of something. Newsflash, you have control of nothing at this point, sir. Not a goddamn thing. You know what you have control over? Telling the truth, which you'll never do. It's about the only thing you have control over. The answer to that, Frank, is the sewer turtle. It's been hacked, apparently. He has been hacked. So that sucks. That sucks. Absolutely sucks to be him. But, you know, there was like 7 other times that he claimed he was hacked when he wasn't. To blame other people. I blame Brennan. That's what they're gonna do. They're gonna blame Brennan. They're gonna be like, well, the Commonwealth must have done it. It's a grand conspiracy, y'all. The Commonwealth must have hacked him. And that's what it was. Absolutely. It's definitely what it was. It was the Commonwealth. It's amazing to me. Absolutely freaking amazing. They will blame Brennan. I mean, just look at these people, like, in the background of all of this. Like, if you take a second to actually, like, look at all the people while Alessi, whatever you want to call him, is continuously running his mouth and not even remembering what he said the sentence before because he's got the same goddamn argument. You can see who pays attention, who doesn't, who's taking notes, who isn't, and who's just on X and Facebook. And I'll tell you, the sewer turtle lives online. He literally doesn't sleep. And all he does is go from his account to sock accounts, to his account to sock accounts, to harass, defame, intimidate, run his mouth, make fun of, over and over and over, all day, all night, never sleeps. Like, dude probably sleeps like 2 hours a night. I literally kid you not when I say his life is the internet. That is sad. That is literally so sad. Go touch some grass. Go do something with your children. Like, what? You don't ever take a break from the internet? Most people don't even hear from me on weekends because I spend it with my family. You know? I will always answer the phone for someone who needs me or who needs help. Everyone knows that. But I also don't spend all day and all night online, nor have I ever. I check, might write a few things, and then I get off. It's that simple. There are plenty of things I have to catch up on because I don't spend that kind of time on social media, especially X. It is just so gross. X is just a cesspool of nonsense and sock accounts and people impersonating each other. And it's a cesspool. It's a legit cesspool. And that's because there's no rules really on X. You can just say or do whatever you please, apparently. And Facebook doesn't work like that. So what you can get away with on X, you can't get away with on Facebook. So people who want to do that kind of shit, they go to X. They don't go to Facebook. So I think that's why it's become a cesspool. And it's unfortunate because X is a great way to get information out to a lot of people, just like Facebook. But people aren't even getting the information anymore because it's mostly just attacks. You know, we got to correct a lot of misinformation a lot of the time. When I get on X, usually that's what it is I have to correct misinformation, check my replies, check my messages, get back to people who have messaged me, which I try to do at least once a day. So if I haven't answered you, I apologize. I will. I've been very busy, as you guys know. I have a lot going on with my kiddo. So, and I have, you know, and I have a little, so almost I'm like, I thought I heard a knock, but it's like, what? Who would be knocking on my door? I think that's outside. It is. I'm like, what is that noise? She did at least give the couple of the motions were approved because there was no objections. I assumed that every Commonwealth motion would have an objection. So they wanted to go over one, and the judge said, okay, Mr. Alessi, how long do you need to argue it? And of course, he's like, 20 minutes. 20 minutes means 45 minutes. The man is never on time. The last time he said an hour in one of those hearings, it ended up being closer to 2 hours. He just like never shuts up. It's like, bro, he says things like offensive. Like, dude, your face and voice are offensive right now, okay? You say the same 10 things over and over and over. And I have noticed, just like Hank Brennan said, he sort of jumped on the defense team and then jumped on the bandwagon of trying to point fingers at the Commonwealth and disparage the Commonwealth. And it's like, bro, grow up. You're not helping yourself. You're not helping your team. This shit might work in New York. It might work in California. It doesn't effing work here. Boston is a different place, okay? You can go to California and you go to Boston. They're two different worlds, legitimately. I kid you not. It's like being on a different planet, okay? Same thing with New York. New York and Boston, it's like living on a different planet. If you go down south, the Midwest, look at her facial expressions. She's peeved. She's pissed off in this shot right here. She rolls her eyes. She bites her lip. She's annoyed. She's bored. Like, and all while her own attorney is just blabbing away the same 3 points he keeps making over and over that the judge made moot probably 5 minutes ago at this point in the argument. Oh, he's done now. He's done talking now. I think Hank, I'm going to unmute this part because Hank speaks so well.
I'm particularly disappointed that Mr. or Attorney Alessi sees this as some type of trial by ambush. I'm not going to digress the way he has, but a case study in that is the ARCA, and that's why I'm concerned about waiting until the day before trial to get simple Rule 14 discovery.
Which is exactly what the defense will do, or try to do.
ARCA and Mr. Welcher have some similarities because they're biomechanical engineers.
Correct.
Now, in our production, we gave over 8 gigabytes of information from Dr. Welcher. We gave any reference material, whether he was going to use it or not. We gave all studies, all data, anything that he considered, even if it was irrelevant, we provided to the defense. It was an extraordinary production. I've never seen a more complete production.
Interesting.
But Dr. Welcher gave his entire file to the defense with all of the raw material, all of the studies, all of the reference material. It's not limited to this report. As you can see, Dr. Welcher is extraordinarily thorough. You can see in the letter report all of the different things that he looked at, far beyond what any other expert has looked at in this case, far beyond, I dare say, what ARCA even considered in this case. And so it is obvious, but maybe not to the defense, so I will narrow it, that Mr. Welcher, Dr. Welcher, cannot come in and talk about the opinions or testimony of witnesses as it relates to their statement. So, for example, as Attorney Alessi points out, 1C, he won't be able to come in and would not want to come in and say that the witness did not see damage to the taillight. She'll testify to that herself, that there was no damage. In fact, all the witnesses did not see damage to that taillight. As to 2C, the testimony of Jen McCabe, that is for reference. Testimony of Jen McCabe is for Jen McCabe and the jury. He will not be offering testimony of Jen McCabe or offering anything that relates to it. Similarly, 2.1 regarding Julie McCabe and grand jury minutes, he won't reference grand jury minutes in the abstract, let alone the details of it. Number 4, he will talk about the weather if it is already in evidence. It's a proper basis for an expert, but he will not be talking about the frozen ground.
I have an itch on my back.
Similarly, in 4G and H, this is reference material regarding Julie Nagle and the Ford occupants. They'll testify to what they did and what they saw. And the people inside 34 Fairview, even though every single witness says John O'Keefe never came into Fairview, that is left for the witnesses, not for Mr. Welcher. And so the basic argument of the defense is that this biomechanical engineer should not be testifying using his principles and his education about demonstrations. What is suggested is that there's no evidence that he ever engaged in these demonstrations before, that they were exclusive for litigation, they weren't tethered to a specific study, and the methodology for each one is not outlined in a report. I wasn't sure if he was talking about Dr. Welcher or he was talking about the ARCA experts, because when I'm looking at the ARCA report, which apparently they're very comfortable with, we don't even know which witness did what. Importantly, when we look at the ARCA report, you have one witness who decided to build a potato cannon for no reason that we know of. No evidence that anybody threw a glass, but apparently it was a cool idea, he cited on the stand. That wasn't tethered to a specific study. That didn't lay out the methodology of the potato cannon. That wasn't repeated or validated. There was no specific literature that was referred to in that report. And yet, not only were they allowed to offer this evidence, it wasn't inappropriate. Now, it would be nice to know a little bit about the potato cannon, maybe a picture or a video or some specs on it, or maybe some details on how it actually operated. See, these are the things that Dr. Welcher provides to the defense. He doesn't just provide the information, the raw data, and the studies. He actually shows the demonstrations. He doesn't hide from his basis of his opinions and conclusions. He shows and demonstrates them with videos and pictures and photographs, quite unlike ARCA, where it is just simply a conclusion based on just trust me. And so when you look at the production by Dr. Welch,
Yeah, it's a replay.
it is not comparable
They're still on break.
to the standard
Or
that the
lunch.
defense accepts for their experts. He is a biomechanical engineer. That is a combination and study of engineering and physics and science. And it also details medicine. He's not a medical doctor. He's not diagnosing an injury, but it includes all of those arts. Now, this is the same thing that ARCA says in their report. If you look at their report, they talk about the study. And they outline what they believe the study of being a biomechanical engineer is all about. In fact, one of the complaints by Attorney Alisi is Mr. Welcher's drop test. If you look at the ARCA report on page 10, they do the very same thing, except that they don't show it. They don't actually demonstrate it. It's pale in comparison, but they give the conclusions and they give a chart. It's no different. And so there are no medical diagnoses by Dr. Welcher. These are his opinions based on his study of the evidence, and he goes to the extent of actually demonstrating those different assessments that he has made. In particular, the defense takes issue with basically everything he's done. And just as a general perspective, they would like the ARCA witnesses to come in and say that the injuries were not consistent with striking the taillight of the Lexus. That's what they want to say. Dr. Welch's opinion is different. It's the same engineering, it's the same science, it's the same concept. It's just a different opinion than they like. So if they like the opinion, all of these standards that Attorney Alisi is insisting on are excused, but if they don't like the opinion,
Bingo.
somehow should be excluded.
That's
They're really
right.
polar opposites when you think about the perspective and the opinions they give it.
Exactly.
They both have a different opinion about the taillight causing the injury to Mr. O'Keefe's arm. One the defense likes, one they don't. It is the same science, same study, same analysis. And so if it's acceptable for ARCA, it must be acceptable for Dr. Welcher. Dr. Welcher actually downloaded the text stream data. He didn't ignore it. He didn't know that it didn't exist.
The status
He
meaning
didn't
what?
fail to consider it. He actually downloaded it himself. He is experienced. He looked the material, studied the material. The text stream data is critical in this case because it shows time and place with the new information that we have. So we know from the Waze information exactly where that car went from the waterfall to the flagpole. We know where it did and didn't stop along the way. We know, based on the phone data, Mr. O'Keefe's phone data, when he was in the car until. We have all that evidence, and as a bioengineer, he can consider all of that technical data, which will be introduced through other witnesses at trial before he testifies. And it's important. The location and timing of that car is important.
Oh, yeah.
This is
It's
all
complete.
science
It's been turned
data.
over.
It's not witness testimony. It's science.
It's been complete
data.
for a long time.
And it puts that car at that flagpole at the time Mr. O'Keefe is there with his cell phone, locked into the Bluetooth in that Lexus until he gets out of the car after 12:30.
Yeah, I
And
saw
within
that.
2 minutes, we allege this collision occurs. And there's Apple Health data, there's location data, there's cell phone battery temperature. It all coincides. He should be able to consider these things in his study. This is what he does. The demonstration at Meadowbrook, John O'Keefe's house, is depicted by measurements which has been provided, science and data,
I'll try to explain.
by the ring videos, which will be independently admissible. And we see the gentle nudging of that Lexus into Mr. O'Keefe's car. And there has been allegations, claims, suggestions that that's where the taillight may have broken despite the other contrary evidence. You can see in the presentation, he actually shows not only the nudging and the car leaving through the ring video, but analyzes it, and you can see exactly where those two cars came into contact, and it wasn't the taillight. You can see through his demonstration or through his study of the materials he presented that the snow is on the back of Mr. O'Keefe's bumper until the nudge, and you can see the exact spots where the snow comes off. This is science and data. This is an opinion. This isn't witness testimony. And the jury should see that very evidence. It'll be admissible not only through him, but through independent witnesses. The defense takes issue with Dr. Welcher providing an opinion that the lacerations and cuts are consistent with the geometry and orientation of the right tail light. There has been many claims about alternative sources, which the Commonwealth disagrees with, as to those abrasions. But if you've seen the PowerPoint that's been presented and provided to the court, will be presented to the jury, it shows the symmetry of the arm and the location of the arm, the height of the broken tail light, and it shows with great continuity the height, location of that broken tail light, and how it relates to a bent arm. And that is based on engineering, biomechanics, the same things that ARCA employs. They just didn't do this. And so that's not witness testimony. That's not beyond the bounds of anything. That is powerful evidence, and we intend to introduce that. And then, as I mentioned, finally, the drop test. This is the same information that ARCA proposes in their report. For some reason, I don't think that was offered at evidence at trial, but it's clearly within the bailiwick of this expert. And so we will file on Monday a PowerPoint presentation redacting all the inadmissible parts of it, which is witness statements. And we expect to present the demonstrations to support the opinions as corroborative evidence of those opinions rather than just naked opinions. And there will be no trial by ambush. Now, we will be studious in getting that information to the defense. We would like them to be as studious getting us the ARCA information. It does concern me delaying that information because, as Attorney Alisi eloquently said, you need time to prepare. We know he's a very prepared attorney. We'd like to prepare as well. And if we wait to get records and information and know who wrote what part of the report, we won't be prepared. There's a third engineer in their team that wasn't called. We'll have to add him to the witness list if he has any relevance. We won't know until we question those witnesses. So I think I'm also inclined to ask the court to consider we have that questioning well before their testimony. But we will meet our commitment and provide those slides on Monday.
All right. And Mr. Alessi, again, you've already said you agree to talk to Mr. Brennan about the reciprocal discovery.
Yes.
Okay.
May I be heard, your response?
Sure.
Thank you.
Okay, I'm not going to bore you with him because he just says the same 5 things over and over and over.
Like with,
So we shall speed up past him. Yada, yada. Back up a smidge. Back to Hank because he's brilliant. And there's Peggy.
Honor, our request in the alternative for an evidentiary
He's
hearing,
almost done, I promise.
if what we get from the
No,
Commonwealth
they
continues
don't,
to be
Maui.
the
They do
vagueness
not want
that
this
we've been
data in
getting all along.
because
Thank
it's
you, Your Honor.
very bad for them. Very bad.
Oh, please. I'm particularly disappointed that Mr. or Attorney Alessi sees this as some type of trial by ambush.
Exactly, Bree.
I'm not going to digress the way he has, but a case study in that is the ARCA, and that's why I'm concerned about waiting until the day before trial to get simple Rule 14 discovery.
Yep.
ARCA and Mr. Welcher have some similarities because they're biomechanical engineers.
I did, yes.
Now, in our production, we gave over 8 gigabytes of information from Dr. Welcher. We gave any reference material, whether he was going to use it or not. We gave all studies, all data, anything that he considered, even if it was irrelevant, we provided to the defense. It was an extraordinary production. I've never seen a more complete production. But Dr. Welcher gave his entire file to the defense with all of the raw material, all of the studies, all of the reference material. It's not limited to this report. As you can see, Dr. Welcher is extraordinarily
8
thorough.
gigabytes.
You can see in the letter report all of the different things that he looked at, far beyond what any other expert has looked at in this case, far beyond, I dare say, what ARCA even considered in this case.
Yep.
And so it is obvious, but maybe not to the defense, so I will narrow it, that Mr. Welcher, Dr. Welcher cannot come in and talk about the opinions or testimony of witnesses as it relates to their statements. So for example, as Attorney Alisi points out, 1C, he won't be able to come in and would not want to come in and say that the witness did not see damage to the taillight. She'll testify to that herself, that there was no damage. In fact, all the witnesses
They are definitely still
did not see
rattled.
damage to that taillight.
I agree.
As to 2C, the testimony of Jen McCabe, that is for reference. Testimony of Jen McCabe is for Jen McCabe and the jury. He will not be offering testimony of Jen McCabe or offering anything that relates to it. Similarly, 2.1 regarding Julie McCabe and grand jury minutes, he won't reference grand jury minutes in the abstract, let alone the details of it. Number 4, he will talk about the weather if it is already in evidence. It's a proper basis for an expert, but he will not be talking about the frozen ground. Similarly, in 4G and H, this is reference material regarding Julie Nagel and the Ford occupants. They'll testify to what they did and what they saw. And the people inside 34 Fairview, even though every single witness says John O'Keefe never came into Fairview, that is left for the witnesses, not for Mr. Welcher. And so the basic argument of the defense is that this biomechanical engineer should not be testifying using his principles and his education about demonstrations. What is suggested is that there's no evidence that he ever engaged in these demonstrations before, that they were exclusive for litigation, they weren't tethered to a specific study,
Let's
and the
hope so,
methodology
Maui.
for each one is not outlined in a report.
Let's hope so.
I wasn't sure if he was talking about Dr. Welcher or he was talking about the ARCA experts, because when I'm looking at the ARCA report, which apparently they're very comfortable with, we don't even know which witness did what. Importantly, when we look at the ARCA report, you have one witness who decided to build a potato cannon for no reason that we know of. No evidence that anybody threw a glass, but apparently it was a cool idea, he cited on the stand.
Yeah, it was a cool
That
idea.
wasn't tethered to a specific study.
Nope.
That didn't lay out the methodology of the potato cannon.
Nope.
That wasn't repeated or validated.
Nope.
There was no specific literature that was referred to in that report. And yet, not only were they allowed to offer this evidence, it wasn't inappropriate. Now, it would be nice to know a little bit about the potato cannon, maybe a picture or a video or some specs on it. Or maybe some details on how it actually operated. See, these are the things that Dr. Welcher provides.
There are
to the defense.
quite
He
a
doesn't
few
just provide
motions
the information, the raw
still,
data,
unfortunately,
studies.
Eva.
He actually shows the demonstrations. He doesn't hide
Yeah,
from his
ARCA was the potato cannon.
basis of his opinions and conclusions. He shows and demonstrates them with videos and pictures and photographs.
Yeah.
Quite unlike ARCA, where it is just simply a conclusion based on just trust me.
Yeah, just trust me, bro.
When you look at the production by Dr. Welcher, it is not comparable to the standard that the defense accepts for their experts.
Nope.
He is a biomechanical engineer. That is a combination and study of engineering and physics and science. And it also details medicine. He's not a medical doctor. He's not diagnosing an injury, but it includes all of those arts. Now, this is the same thing that ARCA says in their report. If you look at their report,
It
they
is.
talk about the study.
They also talk
And they
about John's
outline
injuries.
what
Isn't
they
that funny?
believe the study of being a biomechanical engineer is all about. In fact, one of the complaints by Attorney Alisi is Mr. Welcher's drop test. If you look at the ARCA report on page 10, they do the very same thing, except that they don't show it. They don't actually demonstrate it. It's pale in comparison, but they give the conclusions and they give a chart. No different.
No,
And
Commonwealth
so-
did a better job.
There are no medical diagnoses by Dr. Welcher. These are his opinions based on his study of the evidence.
They do that. It's annoying.
Assessments that he has made. In particular, the defense takes issue with basically everything he's done. And
Yep.
just as a general perspective, They would like the ARCA witnesses to come in and say that the injuries were not consistent with striking the taillight of the Lexus. That's what they want to say.
Yep.
Dr. Welch's opinion is
It's
different.
opposite.
It's the same engineering, it's the same science, it's the same concept. It's just a different opinion than they like. So if they like the opinion, all of these standards
Yeah, I wanna see that
Attorney
too,
Lisi is
Eva.
insisting on are excused, but if they don't like the opinion, somehow she would be excluded. They're really polar opposites when you think about the perspective and the opinions they give. They both have a different opinion about
That
the
would be a good
taillight
idea.
causing the injury to Mr. O'Keefe's arm.
I will
One
attempt
the
it.
defense
I don't
likes,
have
one they
time,
don't.
Anna.
It is the same science, same study, same analysis. And so if it's acceptable for ARCA, it must be acceptable for Dr. Welcher.
Yep.
Dr. Welcher actually downloaded the text stream data.
Ah.
He didn't ignore it. He didn't know that it didn't exist.
That's right.
He didn't fail to consider it. He actually downloaded it himself.
Yep.
He is experienced. He looked the material, studied the material. The text stream data is critical in this case because it shows time and place with the new information that we have.
Bingo.
So we know from the Waze information exactly where that car went from the waterfall to the flagpole. We know where it did and didn't stop along the way. We know, based on the phone data, Mr. O'Keefe's phone data, when he was in the car until. We have all that evidence, and as a bioengineer, he can consider all of that technical data, which will be introduced through other witnesses at trial before he testifies. And it's important. The location and timing of that car is important. This is all science and data. It's not witness testimony. It's science and data. And it puts that car at that flagpole at the time Mr. O'Keefe is there with his cell phone, locked into the Bluetooth in that Lexus until he gets out of the car after 12:30. And within 2 minutes, we allege this collision occurs. And there's Apple Health data, there's location data, there's cell phone battery temperature. It all coincides. He should be able to consider these things in his study. This is what he does.
That's right.
The demonstration at Meadowbrook, John O'Keefe's house,
Meadows
which
Ave.
is depicted by measurements which has been provided, science and data, by the ring videos, which will be independently admissible. And we see the gentle nudging of that Lexus into Mr. O'Keefe's car. And there has been allegations, claims, suggestions that that's where the taillight may have broken despite the other contrary evidence. You can see in the presentation, he actually shows not only the nudging in the car leaving through the ring video, but analyzes it, and you can see exactly where those two cars came into contact, and it wasn't the taillight. You can see through his demonstration or through his study of the materials he presented that the snow is on the back of Mr. O'Keefe's bumper until the nudge, and you can see the exact spots where the snow comes off. This is science and data. This is an opinion. This isn't witness testimony. And the jury should see that very evidence. It'll be admissible not only through him, but through independent witnesses. The defense takes issue with Dr. Welcher providing an opinion that the lacerations and cuts are consistent with the geometry and orientation of the right taillight. There has been many claims about alternative sources, which the Commonwealth disagrees with, as to those abrasions. But if you've seen the PowerPoint that's been presented and provided to the court, will be presented to the jury, it shows the symmetry of the arm and the location of the arm, the height of the broken taillight, and it shows with great continuity the height, location of that broken taillight and how it relates to a bent arm. And that is based on engineering, biomechanics, the same things that ARCA employs. They just didn't do this. And so that's not witness testimony. That's not beyond the bounds of anything. That is
Court's on
powerful
break
evidence, and we
for
intend to
another 5
introduce
minutes.
that.
We have heard this. I just wanted
And then, as
to.
I mentioned, finally, the
replay
drop
Hank.
test. This is the same information that ARCA proposes in their report. For some reason, I don't think that was offered as evidence at trial, but it's clearly within the bailiwick of this expert. And so we will file on Monday a PowerPoint presentation redacting all the
Look at this.
inadmissible parts of it, which is witness statements.
Hilarious.
And we expect to present the demonstrations.
He's
to
literally
support
hearing
the
nothing.
opinions
Mouth wide open, not listening.
as corroborative evidence of those opinions rather than just naked opinions.
Tweeting.
And there will be no trial by ambush. Now, we will be studious in getting that information to the defense. We would
Peggy,
like
you're a
them
rock star.
to be as studious getting us the ARCA information. It does concern me
Oh,
delaying
rock
that
star.
information because, as Attorney Alisi eloquently said, you need time to prepare. We know he's a very prepared attorney. We'd like to prepare as well. And if we wait to get records and information and know who wrote what part to consider.
Who wrote what part, then they won't be prepared. Yeah, we get it. Jackson gets up, says a bunch of nonsense.
In addition to her anger, she specifies some of the tension. We heard from the testimony of Jen McCabe that when she gave directions to John O'Keefe, she mentioned a mother of a child who Mr. O'Keefe had a prior relationship with. That this is minutes before we allege the collision happened.
Mm-hmm.
And so in the interviews that she has provided to these different outlets, she discusses the fact that she hears this information and that there was an issue or some type of interaction about the fact that he was previously dated another woman. And this is a conversation that takes place minutes before the collision. And so we have statements from the defendant herself that show the discord in the relationship, the anger, being pissed, the motive. Without reading them, because it's unnecessary, there is substantial corroborative evidence.
Yep.
Not only that the text messages, which are corroborated by the niece's testimony, but the imminency of it, that this is happening in real time, moments before John O'Keefe's death. And so all of this should be admissible. It's all supportive of each other.
And he is correct. Yeah, see, it's still on lunch break. I am like at the live point right now. Should be back any minute though. Yeah, I can't either, Lisa. It drives me bonkers, but this time he is looking very uncomfortable, looking very uneasy, very worried. And gee, I wonder why that could possibly be. Guess we'll have to opine on why that could possibly be. Gee, I don't know. I am stumped. I'm completely stumped. I have no idea why he would look like that at all. With all of the things that he has done to people and all of the things he could be charged with, I have no idea why he would be so worried. None. Not at all. Imagine having to live your life every single day worried that you're going to be arrested again or charged again. Imagine living every single day of your life doing stupid shit over and over and over that can get you charged again. Having no self-control whatsoever, no self-awareness at all. It's amazing to me. Like, it is absolutely... There you are. Yeah, it sneaks in late. Sneaks in very late, sir. You are late for this party, extremely late for this party. You owe us all a pizza party or very snarky comments very soon, okay? On some commentary. You owe us something, Tracy. Very late. I'm finger wagging you. It must be the ass rash. That must be what it is. Must be. It has to be. Has to be. Yep. Very rattled. Very rattled. But you have to remember, they are in very thin ice. They know this with the court. Extremely thin ice. Because they keep misrepresenting. They keep throwing them lies out there. And I mean, I know the judge said she wasn't going to deal with it, but clearly she is still dealing with it. But at some... No, you're not blocked. I can see you. What you talking about, Willis? What you talking about? I see you. I see you. You haven't seen anything yet? Oh, no. Oh, no. Oh, no. Sometimes that happens to me, too. Either it's too long or it might have like a triggering word. There are like 4 words that I have like banned here, but usually they're ones that like the cult uses. So if you tried to use one of them words, that might have been why. And I know you, and I know your words, and you're just as bad as me. Well, that's the thing. They don't. They have no respect for the judge. They have no respect for the court. But I also said that by not giving them any sanctions, she was opening the door to them basically spitting in their face over and over and over and continuing to do it. And like by not putting the hammer down on them, like that's exactly what was going to happen. Like it's that simple. Like they were going to continue on right down that line, like, you know, unfortunately, because the judge didn't put her foot down. Like, you know, like telling them they did it on purpose. They already knew they did it on purpose. Like they already knew they did it on purpose. So it's insane to me. Like it's insane that she did. Like it's just, well, you know what? Now that LG's here, we're gonna have to play her very favorite clip if she missed it earlier.
I think we got a super chat. I think we got a super chat.
It's her very favorite clip, so I have to play it when she's here so that she could see it. I just wish that the judge would be a little more like other judges in the aspect of putting her foot down, because so many, I don't know why that one didn't go through. That one should have went through. None of those words
And
are
I think we
banned.
can do it. We need to spend some time talking about
But they're still
voir dire, so I don't
nothing on the screen
want
yet.
to run out of time for that. So what I plan on doing is finishing these motions by 3 o'clock. We'll
We
give
hear
each
her,
side
but
2
we see
minutes.
nothing.
We'll see how we do with that, and we'll try and get through this. Juror questionnaires, have you provided those? Remember we talked about it the other day?
Why
The
are we
two of
only
you
getting audio?
Worked out a juror questionnaire.
I know you asked us to, we haven't
All
spoken.
right, so today's the
Well,
final trial conference.
least
where
we're
I'm
getting
supposed to
audio.
have This, right?
Understood.
Can you do it before you finish? Well, let's see where we get with the motions and we'll see about that.
And Your
Hold
Honor, if I could I finish that last point that I was about to make just before we broke?
No, you don't get to make that last point because it was literally a nothing point. I'm
Play
just
anytime,
refreshing it
anywhere.
because I feel like
Audio.com.
I don't think it's us. I think it's that. We'll just-
Boss interview.
Nope.
The reference to the she called John and talked about Ashley's home or Ashley's house. The she was Jennifer McCabe. But on the 28th, calling John to say 34 Fairview is down the street from Ashley's house. My client was not
I'll
part
read it
of
out
that
loud. Just give
conversation.
me
That was between
till
Jen
they
McCabe, as
stop
she
for a second.
testified, and John.
Okay.
Then the next day
Well,
is
you wrote it.
when the conversation, according to Jen, took place about Ashley and could it have been some sort of an interaction or an affair or something like that.
Okay.
My only point in making this, and I just want the record to be super clear, is
I understand what your point is in making
there
it.
was
Nobody
no
cares.
animus, no evidence of animus on the night in question.
I understand that's your position. We haven't heard the evidence yet.
Okay, I just want to make sure.
all right.
that's clear. Thank you.
All right. Well, Mr. Jackson, you can stand up again. Is the defendant pursuing a third-party culprit defense?
That's going to be my colleague, Mr. Yannick.
So you have 2 minutes, Mr.
There we
Yannick.
go.
That's sort of a yes or no, and then I'll hear the Commonwealth.
And I'm sorry, I did not hear the question. Yes.
All right. So I'll hear you on your motion, Mr. Brennan, and then a 2-minute response.
Yeah, not a 40-minute response. Spaghetti.
Jimmy, keep track, please.
Yeah.
Keep
Go ahead.
track.
Thank you. During the first trial, Your Honor made a ruling prior to defense presenting any evidence or questioning any witness about third-party culprit the defense needed to provide sufficient evidence to pursue or place that issue in front of the jury.
And I didn't.
The defense, in my opinion, looking at the opening argument, ignored that directive by the court.
Yes.
The very first words of the opening were directed to third-party culprit.
Yep.
And thereafter, throughout the case, there does not seem to be any boundaries, parameters, or identification of the walls or the length of third-party culprit. The varying representations by the defense over time make very unclear what the third-party culprit evidence is, whether it is a particular person, includes particular people, or unknown. We know from the defendant's statements that there was a position taken on the front of the courthouse steps that everybody knew who the third-party culprit was. That position changed in the Ted Daniels interview when they were asked about third-party culprit, Mr. Jackson.
We don't know who did it.
And the defendant said they did not know. And so despite the recent position that they did not know who the third-party culprit was, in our argument the other day, Attorney Little identified Brian Albert as third-party culprit, Mr. Albert. And so there is this vacillating position on who the third-party culprit is and what evidence they suggest supports third-party culprit. I took an opportunity to go back to the arguments last year for third-party culprit. I have a transcript, and it's equally undefined at that point.
Yep.
And so what we have now is the defense with a hope or an expectation or intention to pursue third-party culprit, but we have no basis for it. The court has been very clear on third-party culprit, and they can't just come in and start accusing people arbitrarily of committing the crime of murder. Section 1105 of the Mass Rule of Evidence makes clear that evidence that a third party committed the crime charged against the defendant.
So I will read again the Mass Guide to Evidence. I'm familiar with the law on third-party culprit. Your time is up at this point.
See?
I've read your motion. I've read your memo.
Okay.
Or the pleadings.
Thank you.
All right, Ms. Giannetti.
Dude, you got to give him time to argue his motion. That's...
Jim, why don't you stand when it's done? Can you stand when it's done?
Do you know what I'm saying?
You're
Like,
right, I can't do this in 2 minutes.
Well, then we'll hold it. We'll hold it to the end.
Neither. Okay, well, neither could
All
Hank.
right, Mr. Lessie, I'm going to hold you to 2 minutes. I've got the Commonwealth's motion on the Celebrate demonstration. I'll hear you for 2 minutes on that.
My 2 minutes start when I get to the podium?
Yes.
Thank you.
Unfucking real. Yo, where'd he go? He scurried off, y'all. The sewer turtle scurried down to the sewer. Also, Algie thinks that Howie Carr should be hit by a train. And I hopes get hit by a train. Hopes he gets it. I concur.
The courtroom demonstration that the Commonwealth proposes is incredibly vague, and it, to the extent it can be understood, is impermissible. I'm fully aware of what happened in trial one. Not only did I read the transcript, I went back and watched the video. The Commonwealth states that they want to conduct, I'm reading verbatim on page 1, a courtroom demonstration of how data was stored within Jen McCabe's cell phone. That's it. No elaboration, what it's going to be. They're looking, to me, this is a blank check. Similarly, with regard to Jessica Hyde, we'll use a courtroom demonstration to show jurors information and data on both the phones to explain concepts and to illustrate particular information of importance. Vague, again, we have no idea what it's going to be, nor does the court.
We do, because it happened last time.
And there are similar statements, and also on page 2, they concede they want Mr. Whiffen to use the highly disputed extraction reports to demonstrate Celebrate software. It says this demonstration would closely mirror the actual Google searches, but we don't know how. It's obviously not going to do it. And lastly, with regard to the law, section 1006 talks about the witness presenting the summary is not permitted to state deductions or inferences. That's right in the note to the rule, and that's exactly what they want them to do, is to give the deduction and the inference that the 227 timestamp means it came to at 6:30. It's in direct violation of the rule.
It's not an inference, it's a fact.
Secondly, under 1006, the appeals court held that because the presentation selectively presented excerpts of other exhibits and evidence in such a way that it served to both bolster the Commonwealth case and rebut the defendant's case, it was not merely a neutral summary. It was more akin to an argument than evidence. The Commonwealth concedes that's the case. And with regard to Commonwealth v. Sosa, page 14, the only thing that was allowed in Sosa, the case they cite, it says the complete video footage contained several camera angles of the property, and the condensed video merely was a compilation of that which already existed. They just shortened it down. What they're proposing to do is anything but that.
All right, I appreciate your brevity too. Thank you.
Okay, just go faster.
Ms. Brennan.
You could have done that last time. We don't have to hear you.
The demonstration we would be asking Ian Whiffen to engage in is the same demonstration as he did at the first trial. No different, based on the same qualifications, based on the same experience. It is essential that the jury understand and be able to see the data in action so they can appreciate the legitimacy of how the data is stored and how those windows are open. As far as Jessica Hyde, we've provided a number of different reports. We would like to provide chalks that come directly from those reports. So if there's anything that's particular.
Lemonade Renters Insurance protects you from life's coulda, shoulda,
Not
woulda.
that we don't know what he's
I
going to
coulda
say. We do. Oh, what the? I did not press
hired a plumber. Should have locked the window.
In her reports so that the jury can read along and see them.
Okay.
It's exactly the same as the
I'll
first
get a
trial.
decision quickly to you in that.
Yeah, allowed. There's no way it's going to be denied. Just FYI. It'll be
Does
allowed.
the defense intend to bring up any bad character or misconduct of John O'Keefe or any witness?
Yep, they do. Yep.
Bad
No?
character evidence is inadmissible.
Right.
To the extent that evidence could be used for like motive, opportunity, all the
No.
alternative.
You have to have a third party for that.
Under proposed rule 404.
You have to have a third party for that.
The right, but we would approach sidebar before
No.
introducing any such evidence, and certainly not against John O'Keefe.
What do you say, Mr. Brennan?
No.
If we have advance notice, I think that's appropriate. I don't want to wait until we get the sidebar. If the defense has an intention of offering what would otherwise be prior bad act evidence, but they think it meets an exception under the rule, then they should propose that evidence so we have time to consider it.
Especially if you intend to open on it. Are you doing the opening, Ms. Giannetti?
I will not be doing the opening this time, and I do
Okay.
not believe we will be opening on that at all.
All right. So,
You don't
okay.
believe.
So what I'll do is
Now they're
not
gonna change.
during the
That's why he
opening
said
and only
believe.
with advance notice
Yep.
and a ruling.
Good.
What would the advance notice be, Your Honor?
A week before a week before the evidence starts.
Thank you.
Okay, that's paper 587, Mr. Clerk.
Thank you.
Commonwealth's motion for an offer of proof regarding calling District Attorney Morrissey and victim witness advocate Steve Nelson.
No.
And it's
Not gonna
also,
be able to
it
call
also
Steve.
includes a request to exempt from sequestration.
Your Honor, with regard to this motion, we have on principle, we have no objection to an offer of proof as necessitated by the court's guidance.
Yeah.
The issues do go strictly to trial strategy and attorney work product. So any such offer of proof, we would ask, we make that ex parte. I can tell the court, just to kind of streamline things, we would not be seeking either of these individuals in our case in chief. They would be merely impeachment if necessary.
Okay.
So we could make those offers of proof at the appropriate time.
Okay,
Thank you.
all right. I'm satisfied with that. What's the Commonwealth's position? You satisfied with that?
I am. I would like the victim witness advocate to be able to.
Yes, the victim witness advocate, he'll be able to come in for trial.
I wasn't worried about the sequestration aspect of it. I should have mentioned that.
Okay.
Thank you.
All right, so they're both exempt from sequestration.
Oh, but the
Okay.
Stuart Turtle isn't. Merp, merp, merp. Wah.
So the other motions do seem like they may take a little bit more time. I'm going to well, actually, let's try this one, see how we can do with this. So the Commonwealth's motion eliminate to prohibit reference to the pending internal affairs investigation, sustained findings unrelated to this case or unfounded allegations. Well, this is in a little bit different posture now than when the Commonwealth filed it back on March 10th, right? With Michael
is.
Proctor being fired. Do you need some time to reconfigure this, or you want to just be heard? And for this, I'll give you both 3 or 4 minutes.
I think it'd be helpful to have more time. I can report that when we learned that Mr. Proctor was fired, we filed a request for all the IA files. We included the defense, and I understand there was a production produced to us,
Oh,
to
okay.
both of us. Now, I have not seen it.
Okay.
It may be voluminous. It's something I'd like to review. I'm expecting that there may be many pieces of material in that production that is going to be relevant for the defense in this case. And if I have a chance to review it, much of it I may not object to, but there are some fundamental things I'd object to. Traditionally, ultimate findings or opinions of a advisory board or a body aren't admissible. So there will be some constant argument about what is objectionable, but I think a review of the material is helpful so we can better define what is in there and what should be admissible and what shouldn't.
All right, so you just received it. When do you anticipate being able to review it and forward at least what you feel the rules require you to forward? And then if there's anything else that I have to decide, how long will it take you to review it and provide defense counsel with everything that you believe you're required to provide them?
They have a copy of everything that we got.
Oh, okay.
So we had them on the email so they could get everything that we received. We don't have anything they don't have.
Oh, okay.
So it's really just an evidentiary argument. Can, for example, a firing, can that come in that he was fired? Can the conclusions of the board come in, whatever their position is? Maybe they found him acting unbecoming of an officer. I don't know. But those type of conclusions are what I'll probably object to. The raw material, I haven't read it. I hear it's voluminous. Need some time to read it.
Okay. How much time?
Well, I think till the end of next week.
Is that a same timetable you would have whoever's arguing it for the defense?
That's fine, Your Honor. I would just ask for notice about what specifically the Commonwealth is seeking to exclude. There were some,
Right.
even just in the motion that they filed, there's inconsistencies.
Yeah, but I think it's all different now, right?
Exactly, but there's
So-
just inconsistencies between the title and then what's actually in the body of the motion. So as long as I have clarity, then I know what to address.
Okay. All right. Is this something we should come in the day before impanelment and deal with?
I'm happy to come in if the court's available.
Want to do that?
That's fine, Your Honor.
I'd rather not have anything, but I think it makes sense that we at least give you that time and then the weekend. And if you go through it, I'd like something by next Friday too. If there are materials that the two of you are disagreeing about, so that I can view it next weekend and then we can have a hearing the following Monday.
Yes, Your Honor.
Okay.
Does the court intend to have a hearing on the Monday after that? I just would like some time to be able to review their position so I can have time to respond.
So you need until next Friday. I'd like to do it before we start the trial, but I suppose we could start the trial and then hear it.
That's fine, Your Honor.
Can you
I'll move
have,
as quickly as I can. I have a lot of
Okay.
obligations over the next week. I'll try to facilitate it. I just don't know.
all right, without knowing how much is in dispute, Ms. Little, you have no idea how long it will take you to address that, right? So,
Correct.
All right, so Mr. Brennan, by the 28th, you're to provide the defendant with anything that is disputed and when you, or that you feel should be excluded. And when you provide that to the Commonwealth, I'd like you to let me know as well.
I will.
All right, and then Ms. Little, why don't you tell me on April 1st how much time you need to finish up? It may be nothing, you may have it, and we can do it. So I guess we won't meet on the 31st on this?
Thank you, Your Honor. I appreciate that.
All right, so on the 1st, you'll tell me how much time you need. All right, so Mr. Brennan, since we are making good time, I'll let you go back and finish what you
Yeah,
were
good.
saying when I gave you your 2-minute, when I cut you off after 2 minute on third-party culprit.
I don't know
And then
how
Ms.
she could,
Tierney,
I've
I'll
never
give
seen
you-
judges do this, where
I'll
it's
give
like
you both
2
up to
minutes
5
and
minutes
cut
on
you off in
this.
the middle of your actual argument or
5 minutes is a
closing like
long
she did
time,
with
Ms.
Lowy.
Tierney. Let's see how you do.
If the court's inclined to admit the evidence, then I don't need to speak at all. But if
Well,
you're,
last time I said I wasn't excluding it, you just couldn't open on it. Right? So that's where I'm at this point, and I'll hear the different sides. So,
if that's the ruling, Judge, I don't need to be heard.
and I know, Mr. Brennan, you wanted it in advance, but, you know, I guess I'll hear you on your motion on that then.
Yeah, I don't get it, dude. Like, Let him
The
finish.
requirements of providing evidence to support third-party culprit are clear. The
Yep.
evidence has to be relevant, it can't be speculative.
Nope.
And it can't tend to prejudice or confuse the jury.
Nope.
If it involves hearsay or inadmissible evidence, there has to be a substantial connection between the crime charged.
Bingo.
And so what we would want to avoid.
They have none of that.
Is
None
what
of it.
appeared happened in the last case when it
They were
was
just
just
allowed
a
to.
broad-based attack on
Everyone.
anybody.
Everyone.
There has to be relevance between who they choose as a target and the
As they
crime
do.
itself. Looking at the transcripts, I do not see that they've met a substantial
No.
basis between any particular individual
Nope.
and John O'Keefe.
Nope.
We start from the premise that every single witness who testified
Is third party.
testified that John O'Keefe never entered the home at 34 Fairview. Every witness. There is no substantive evidence that John O'Keefe ever entered that home. So to open up an invitation for the defense to start to present
No.
evidence, sometimes alleged prior bad act evidence or character evidence, is unfair because then it becomes a mini trial for each witness.
Yep.
And so I haven't heard any basis or any proffer by the defense that would substantiate any particular witness is a third-party culprit. Now, there are some cases that saying you don't have to actually identify the witness. Those are particular circumstances where there is still substantial evidence that an unknown person had committed the crime. That is not the case here. They have used names liberally, randomly, and those names have changed throughout litigation, whether it's in trial, after trial, but we've never seen a proffer by them. Who is it that they're going to claim as a third-party culprit?
Yep.
What evidence do they have that they want to introduce? There has to be parameters and limitations if they're going to try to introduce third-party culprit evidence, not only about who the person is, but what evidence are they going to introduce?
Yep.
Otherwise, we're going to spend half the trial at SAR by fighting whether this is substantial, whether it's supported. And so no proffer has been made. I think there's an obligation to the defense
Yep.
to identify who the third-party culprit is and what do they want to introduce. Do they have a witness?
Yep.
Do they have
They don't.
evidence?
They have nothing. They have nothing.
Do they have any records?
Nope.
Simply assailing
They have
people's
nothing.
character randomly
No.
is improper. It's unfair.
Yep.
And then it causes the Commonwealth to have to spend extraordinary time rebutting, which is going to confuse this jury. And it,
Just like it did last
Tired
time.
of being in the denied club where building
Literally.
credit feels out of reach?
That's why I
Meet
said
Wendy,
she should have
a
never
literal supermom.
allowed
Twitter
it
credit?
last time.
That's another story.
it's not until they articulate it we can really fashion an argument for the court whether we think it is appropriate or whether we think it's insufficient.
He
But now
absolutely
it's just
should
an
hold her to
empty
the fire.
box where, as in the last trial, the defense can simply get up and blame anybody and everybody. And that's not the way the court and the
Works.
courts have seen third-party culprit evidence.
Nope.
There's a standard, there's an obligation. It hasn't been met. So at this point, the court should preclude third-party culprit evidence.
Yep. Absolutely.
They shouldn't have, they could certainly pursue some type of critique on the police investigation, but as far as third party, without a proffer
Nope.
and a finding,
Then
there
no.
would be no guardrails, there'd be no parameters, and it would be chaos.
It was
All right.
chaos.
So, Ms. Gianetti, I will hear from you, and I'd ask you to focus on, could you tell me whether this is pure third-party culprit, third party as it goes to Bowden, or is it
Yep.
simply somebody else did it and we don't know who?
Somebody else didn't. We don't know who.
Alternative. In other words,
Okay, so that's a little bit different, Mr. Brennan, not pure third-party. I'll still, go ahead, you can go over there. It's a little bit different if it's third-party as it goes to Bowden.
No, it's
But
not.
we know
though.
that
Not really.
it's not admissible if the police didn't know about that third party.
Bingo.
And not act on it.
That's right.
So are you going to tell us who? Last time you told me you don't have to prove that, but can
well,
you make
it's
an
our
offer?
position that we don't have to prove or narrow it to one potential
do.
third-party culprit.
Are you saying it's several?
Three, yes.
Okay, so can you tell me
Right.
the three that you say it is?
Sure. So the potential third-party culprits that we have
Potential.
identified
This
are
is
Brian
potential.
Albert, Brian Higgins, and Colin Albert.
Colin Albert wasn't even there.
I have,
Wasn't even there.
evidence with regard to each. I'm sensitive to the fact, Your Honor, that, and I have a lengthy argument prepared detailing the evidence against each of them.
Do you want to put it in writing? Do
Well,
you
I'm just sensitive to the fact that the court is seeking not to, pollute the potential.
So we can do this over here.
It's up to Your Honor.
Why don't I see you preliminarily over here?
Let's make something abundantly clear. None of those 3 people did anything wrong other than being witnesses, and Colin Albert was not even there. Wasn't even there when Karen pulled up. So I find it funny that they said, we don't know who did it just a few weeks ago, but now we're back to Colin Albert, Brian Albert, and Brian Higgins. They have 0 evidence proving any of that. The feds had 0 evidence proving any of that. That is all a farce. It is all fake. It is all a lie. L-I-E, giant lie. I don't know how anybody in the freaking Reed cult at this point believes any of her story, because it changes on the daily. On the daily. And you need, and to argue third-party culprit, you have to have evidence, not speculation, not rank speculation, actual, tangible evidence to prove that they could have been the third party. I do not have that. It does not exist. Can't have something that doesn't exist. I once told the sewer turtle when he tried to tell me that I took those pictures of Lindsay at the Halloween party that Deanna actually took, and that Lauren and Deanna then hid from him that they took and blamed me for it, and then said nothing. When he, and I have these messages still from him saying, I know you took those pictures. And I laughed and I said, LOL. And I said, stop. I said, you can't have evidence of something that did not occur. You can't have evidence of something that doesn't exist, that didn't happen. It's not possible. And his exact words were, I have the evidence, I'm just not doing anything with it. And I laughed again. And I said, once again, you have to actually have evidence of something, and you can't have evidence of something that never happened and doesn't exist. And also, let's make no mistake, if you had evidence of something, it'd be out there the second you got it. You can't have evidence of something that doesn't exist. You just cannot. That's very true, freak. And that's another thing. Alan himself said Colin, and Karen herself with Colin had nothing to do with anything, and John had no problem with Colin. So where? Again, you disclude him, you reclude him. They have no actual evidence of any of what they're saying because it didn't happen. You can't have evidence of something that didn't happen. It can't be speculation. It can't be things misinterpreted and taken out of context and strewn together like the sewer turtle does. Has to be evidence that anybody did anything wrong, which they have about 0 of. And as we know, the federal investigation turned up no evidence anybody did anything wrong. Other than Karen, the person being charged. That's it. Like... Do me a favor while we're waiting and give this video a like and a subscribe. I'd really appreciate it. If you can give a donation to the channel, I would appreciate it. We're a small channel. We run on donations from you guys who are also always amazing. You can do it Venmo, Cash App, or PayPal. There's a ticker at the bottom of the screen. I'm going to pull the big ticker down because it's distracting as F. But the little ticker on the bottom has all the information so that if you're on my replay crew, I can thank you in the next live stream because I thank everyone. I think it's important. And I appreciate everyone. Fanny the fan, everyone. Like we haven't seen Fanny a million times. My fibro is killing me today. My legs are killing me. I have to keep squirming in my chair because my legs are so uncomfortable. I'm trying to like stretch my legs out so I can move the laptop down a little. I do have a footrest on my chair, but if I pull it out, then I'll be sitting like way back. Yeah, they are playing courtroom hokey pokey, literally. You do the hokey pokey and you turn yourself around, and that's what it's all about. They are. That's the thing. You'd have to be Doctor Who to be involved, literally. You'd have to jump into that phone booth and or police booth and, you know, go backwards in time. It's utterly ridiculous. You cannot have evidence of something that did not occur. You cannot have evidence of something that didn't happen. You just can't. It's not possible. Like, there's an actual Reddit that's justice for Karen Reed. Is that real life? I mean, if you mean justice for her, like, brain, or justice for the people around her that have to deal with her, sure, but yeah, no, like, that's absurd. Whoever made that should be ashamed. Mm-mm. This is just ridiculous. Yes, I know. I corrected myself. And it was you in my brain that corrected me. Police box. It's a police box. I corrected myself just for you, Parson. Police box. Police box. You'd have to jump into your police box with your breadsticks and go back in time. Don't shoot me, guys. Police box. I know. I'm sorry. I'm sorry. I'm sorry. I apologize. God damn it. Police box. Oh, man. Oh my God. There are people on the internet that are so stupid. If you really think that you're identifying someone on a sock account because of the way they spell names, like, you're Delulu. Let me make a public service announcement. Lindsay is no longer on social media. She's no longer on X. So if you're accusing her of being 17 different sock accounts, feel really stupid, because you should feel really stupid. She's not on X anymore. So you're going after someone and you're claiming that it's her because that account spells names the way that her account used to. Do you know how utterly delusional that sounds? Stop it. Literally. Stop it. She's not even on X anymore. That's how stupid you guys are. I can't. And not you guys as in my viewers, you guys as in the people I hate watching. The mob. The cult. The cultists that spend 24/7 on X going after people all day long and insulting people because they're very unhappy with themselves.
Defense has to make a
sad.
decision as to what you intend to provide me so that I can make this ruling.
Ooh.
So, all right, next is the Commonwealth's motion in limine to exclude the expert testimony of Garrett Wing. I know nothing about this person other than your motion just says that all you have is a CV. Does the defense intend to call this person?
I'm going to address that, Your Honor. How would you, I want to make sure I'm within your time constraints, so you want me to stand up?
2 minutes. Just my first question is, who is this person and why haven't you complied with your reciprocal discovery obligations?
Your Honor, because this witness is pending Dr. Crosby, and he's presented because of Dr. Crosby. So it depends upon what happens with that.
You still need to tell the court who it is.
Ruling on the motion for reconsideration, then we can have a better answer to.
If you have to have an answer to the court now. If that's somebody you intend to call, you need to tell the court that you may call them.
Happy to provide, once we get that determination, provide all the things that we
now.
I think Your Honor has in mind.
Well, I've already ruled on Dr. Crosby, right? It's just the reconsideration, whether I think I need to rule on it or not. I'd like you to provide the discovery on this, just so we can keep things moving and we don't have to suspend the trial.
We will do so, Your Honor.
All right, so what do you say, Mr. Brennan?
Well, discovery deadlines have passed, and
Yeah.
the Commonwealth shouldn't be in a compromised position
Nope.
of receiving late discovery and trying to deal with it. So I'd like a time certain.
You probably have it, Mr. Alessi, right? You're very well prepared. Do you have all the
calls him out.
reciprocal discovery that you need to give the Commonwealth on this witness?
I do not, and not only do I not have
What?
all of it, I need to go take a look at to make sure, in light of recent events, that I provide everything to the court. So I can meet a fairly short deadline, assuming I can communicate 3 days.
Can you do it by Monday?
Yes.
Is that acceptable, Mr. Brennan?
Yes, thank you.
All right.
Thank you, Your Honor.
Thank you. So 607, Jim, is the defendant will provide reciprocal discovery by Monday, the 24th.
Deadlines have passed. I would have asked that they not be allowed. You knew that this expert was going to be allowed. You should have had a rebuttal witness if you needed to.
The motion, Commonwealth's motion eliminate to
Nothing
exclude
yet,
defense
Eva.
expert Michael Easter's opinion of the investigation. So I'll hear you on that, Mr. Brennan. I figured this is probably lengthier than the others.
I'm sorry, Your Honor?
I figured this might be more than 2 minutes, might be lengthier than the others we've heard.
Nothing yet, Eva. She didn't rule on it yet. She wants
The defense would like to
information
call
from the defense.
Mr. Easter to essentially testify about his personal opinions of
no.
the investigation,
Absolutely not.
and then to purportedly give opinions about the police investigation, their failure, in his opinion, to pursue certain leads, and to give opinions about their efforts regarding writing reports. This is, from my perspective, tantamount to having a witness come in and vouch for the credibility of defense arguments.
Yep.
And essentially summarize arguments. This really, from my perspective, is the role of the defense attorney to
I'll explain
cross-examine
it.
the witnesses, to point out the inadequacies, to introduce any documents they have if they want to try to impeach the witnesses. And then the witness would have the opportunity to respond or explain or admit any type failures. This is an attempt to bolster a potential Bowden defense and a third-party culprit defense.
It
would involve having Mr. Easter come into court and give his own personal opinions about who a target was or who a third-party culprit may be.
Yep.
That would be totally improper opinion and inadmissible. They would want Mr. Easter to come in and to go through protocol of the state and local police and
Out of
point
a
out what
lot
he
of
thinks
state.
his failures. So essentially, he's a witness that would come in, promote the defense theories,
Yep.
tout reasonable doubt, and suggest why somebody else committed the crime.
Yep.
I've done quite a bit of research. This is
Can't
not
do
a
that.
summary witness. This is
Just can't. It's not permissible.
not a
You can't do
witness that has any relevance other than his own personal opinion.
Nope, he does
This
not.
Former FBI agent was a full-time member of the CAS department since 2013. He is not in a position to determine the best practices of local or state.
Nope.
If there are different rules and regulations that the defense will attempt to introduce, that will be a separate grounds of whether they're admissible and whether they can confront the witness. And a witness always has a right to explain or challenge accusations against them. And so I see that this witness is really simply a summary witness for the defense, but not summarizing information that the jury can then digest, like information in data records or phone records. Rather, a summary witness of a witness who wants to come in and give their personal opinions about this case.
Yep.
I don't see any grounds for admissibility for
Nope.
Mr. Easter to come into this case
Nope.
and give his opinions regarding whether he thinks the police investigation was appropriate or not, or whether he would have directed somebody to do something different,
Nope.
and inevitably whether he thinks somebody is a suspect that was not pursued. That is all in the province of the
Speculation.
defense in their case and in their cross-examination. So I don't see any relevance whatsoever of Mr. Easter.
I don't know. I'm not sure what
Right,
that
who's
means.
arguing for the defendant? So I need you to start by telling me what you expect him to testify to.
I do certainly tell the court that we do not expect to seek testimony or elicit testimony from Mr. Easter as to a third-party culprit.
All right, but who is
But-
he? He's a retired FBI agent?
Correct.
So what
Right?
purpose are you calling him for?
I'll also
What's his
testify.
testimony on?
To opine on the adequacy
Investigation?
of the
Yeah.
investigation.
No.
He is an expert
No.
as it pertains
No, he's
to
not.
investigations, investigative protocols.
He's not.
The adequacy of a proper investigation, what investigations should look like, what a proper investigation should
How
look
is he an expert on that?
He's
How-
not.
How is that a field and how is he an expert on it?
It's not a
Is
field.
it something he's done? Has he testified on that in other courts?
He's testified in dozens and dozens, if not hundreds of
About
courts
what?
on issues related to investigations. He was a lead case agent for the FBI for many, many years. He
Yeah,
taught
on FBI.
issues concerning or taught issues specific to proper investigations and investigative techniques.
That's opinion.
Do you have a report and CV and all that material
Yes.
that you can share with me?
Sure.
All right.
I've already shared it with the Commonwealth, but I'm happy to share it with
Witness
the
cannot
court
be
as well.
allowed.
If,
It's just crap.
I think I can address
no-
many of the court's concerns as
No,
it
you can't.
pertains to his expertise and why the law in the Commonwealth allows, in 702 allows
doesn't
him, someone
allow.
with his credentials, to testify to a very
Does not.
specific issue, like, for instance, something beyond the normal capacity.
The law
of a
doesn't
layperson or
allow
a lay
for
juror,
this,
and that is
for
proper
someone's
investigative
opinion on
techniques.
police
A lay juror might not
investigations.
know,
It
for
doesn't allow
instance,
that.
that collecting items in solo cups or grocery bags would be improper.
Doesn't allow that.
Mike Easter certainly would know that and could opine on
No,
whether or not that
he wouldn't.
followed
He's
standard
not local
protocols. What he's
police.
not going to do
Not state
to
police.
assuage the Commonwealth's concerns, he's not going to, or we're not going to seek to elicit testimony from Mr. Easter concerning
I
a
agree
third-party
with you
culprit
on that,
or
Lou.
who that third-party culprit was, but merely what investigators should do when they walk up to a crime scene and how those crime scenes should be dealt with, et cetera.
So is
No.
is the basis of his testimony just crime
His opinion.
scene, like collection of evidence? Or is it
Witness
when
interview.
somebody tells you somebody may have done it, you're supposed to go follow all those leads? Which is it?
That too, both.
All of it.
Because if someone
Yeah,
tells you
no.
as an investigator,
It's
someone
not
else may have done it,
under
you're
the law
supposed to
here.
follow that lead. That is a proper investigative technique. Of course
No.
it is. But it also includes, as the court just noted, things like cordoning off the crime scene, maintaining proper logs.
No.
Evidence recovery.
I'm
evidence
disgusted with her if she doesn't throw this out immediately.
Logging materials that are moved
I've already
from
been
the crime
disgusted,
scene
but
over to the crime lab.
he's not
how
an
that's supposed to
expert,
be
and
done,
the
what
law
types
and
of
math
logs
does
are
not allow
kept,
for this.
and why those logs are kept.
an opinion.
How you bag evidence, how you
personal
secure
opinion.
evidence, how you maintain the integrity of evidence.
He doesn't get
and
to
things
decide
of that
that.
law,
That's
of
not
that
how it works.
nature. There's certainly.
Don't leave me, guys, with the shit show.
702 in Massachusetts mirrors very specifically 702 in the federal courts. It's literally, I looked at them side
I
by
am
side.
covering
They're
the Idaho
literally
4,
word
though.
for word. And the advisory
good one.
committee notes for federal rules of evidence 702 is very, very instructive on this particular issue, it's specifically as it pertains to
I don't see
somebody
how
with
she
the
could
expertise
let
in
this
a
in.
field like crime scene investigations and
The law here
investigative
doesn't allow
protocols.
for these
And what the advisory
opinions on
committee
police
notes say
investigations.
is, quote,
Just doesn't.
702, the rule is broadly phrased. The
No.
fields of knowledge which may be drawn upon are not merely limited to, quote, scientific and, quote, technical,
But you just
the
argued that.
scientific and the technical, but extend to all specialized
that earlier.
knowledge. Similarly, the expert is viewed not in a narrow sense, but as a person qualified by knowledge, skill, experience, training, or education.
So I'm an expert on law then.
Thus, within the scope of the
Let
rule
me-
are not only experts in the strictest sense of the word,
You
for
testify as
example,
Pliny.
physicians,
and I'm not-
physicists, and architects, but also the large group sometimes called skilled witnesses, such as bankers and landowners testifying to land
Yeah,
values.
obviously not.
Now, again,
Listen,
obviously, we're not dealing with a banker or
Great
landowner,
point.
but the advisory notes and the advisory committee on the rules of evidence 702.
Yeah, I don't agree
the
with
federal
that, Lou.
rules
I
of
was
evidence
pissed.
702 clearly lay out
She should have.
this is exactly
And
the
this is
type
why.
of field that is subject to expert
No, it's
opinion.
not.
Clearly, the rule 702 allows for experts
It
with
doesn't
specialized
allow for this.
experience, specialized knowledge, specialized education, beyond that of an average layperson, in particular, in a field without, or in a particular field, without resort to, for instance, the generalized scientific methodology. That
Then
we've heard
I'm
so
an
much about
expert in law.
some of these
I
motions
have
to
the
eliminate.
experience, the
I
education.
can go through some of his credentials, but Mr. Easter is eminently qualified to provide the jury information about proper and accepted investigative techniques and protocols. As the court noted, or as I just noted to the court, he was an FBI special agent for more than 20 years. He formerly
worked in the criminal justice system for the criminally
with multi-agency investigative gang task forces in Los Angeles. He worked with multiple agencies responding to dozens of crime scenes, including shootings, stabbings, abductions, child abductions, both domestically and internationally. He was the lead case agent who oversaw arrests and indictments.
Great.
He received awards and recognitions for his work with the FBI, as well as the state agencies in which he was a task force member. For 11 years, he primarily assisted homicide detectives from LAPD, the Los Angeles Sheriff's Department, and the Los Angeles District Attorney, numerous other agencies as well, state and local agencies, with investigations and prosecution of thousands of homicides, robberies,
Why she's not shutting it off immediately.
Crimes.
She has to let him argue it.
His work and assistance on investigations in LA and across the United States and ultimately internationally has been noted by not only the FBI, but those agencies as well. Just a few of Mr. Easter's experiences and involvements in some of the domestic and international cases include the 2015 San Bernardino mass shooting.
So are these all on his CV that you're going to give me a copy of?
Everything, I believe, all.
So I don't need you time again of the restraint. If you're going to give me a copy of the CV, I can read it. You don't need to recite it.
It's either what I was reciting is either in the CV or in his report.
Okay, so if that's what I need, that would be much more helpful to me.
Then I don't know what more the court would like.
So I wanted to know.
Oh, dish soap is on sale. We need it.
She can't allow this. It's really not allowed by law here in Mass. He's
Not in the
lying
fridge?
once again.
Ketchup does not go in the fridge.
Playing.
Hello, McFly.
Question I'm going to ask him, but I can tell the court in broad brushstrokes. Obviously, we're going to ask him. We've already asked him to review. He's reviewed.
She has to hear the whole
1
thing.
Through 59. We're going to give him
From
the
both sides. She has to, and then she has to take it into consideration. I don't think she'll go on it right now, but I don't think she. If she lets him in, dude, I will hit the ceiling. It's just there's no law for this, for an opinion of investigation. There's actually law
for an investigative.
So
against
that's my question. So without seeing the report, where are their standards and best practices? Is that something that somebody can turn to and see codification of it, or is it just his experience?
No, it's not just his experience. Those standards and practices are oftentimes reduced to writing. They have been reduced to writing with the Massachusetts State Police. So he's reviewed the protocols that are in place for the MSP.
Okay.
He's very familiar with FBI's protocols for investigative techniques and investigative protocols. He'll utilize those skills and that knowledge base to assess his opinion, or to render an opinion and a conclusion concerning what he believes are the proper protocols that should have been followed in this case. That goes directly to our Bowdoin defense, and he is the primary expert that we use to propound that Bowdoin defense.
You don't have a right to vote.
Can you get me that report before we leave?
A constitutional right
I think we probably have an extra copy of it, yes.
to one of those.
Mr. Brennan, did you want to respond?
Oh yeah, they're definitely desperate. Yeah, he should respond. Absolutely. Lay it out, Hank.
Mr. Easter was a agent who did CAST. He did the CLSI. He may have been in hundreds of cases. I'd like to know what cases he's come into court and given his subjective opinion about how he feels an investigation was done. Not a report, not an assignment, but as an expert witness in Bowdoin. How many cases has he gone into court and testified and been allowed to testify about his personal opinion? His experience in the FBI is different than Canton Police Department and the state police. This is just Monday morning quarterbacking, and it's an attempt to bolster argument by counsel so that they can use some type of opinion to lean on when they're arguing to the jury. They stepped out because of the police investigation.
They really don't.
I don't see any recognition under 702 or in law where somebody can come in and subjectively give their opinions.
Nope.
If there is a state police protocol that wasn't followed, then the defense
can argue that,
can see if that state police protocol is appropriate. If they're speaking to a state police officer, question them about it and ask them if they did it and why. If this person comes in and gives opinions, there'll be a slew of opinions that are shot like a shotgun approach that we'll never be able to have an opportunity to explain. Are we going to call in the Canton Police Department again and call in the state police for a second round so they can explain why they chose certain actions that Mr. Easter is criticizing? I don't think this is an appropriate ground for an expert witness. I don't see any cases, I've looked through the state and federal court, that allow an expert to come in on a Bowden defense and give their subjective opinion about an investigation they weren't involved with. I don't know that this witness has ever been qualified as a Bowden-type witness in any court. He may have testified, but about what? And so I think this is a very dangerous proposition. What if the Commonwealth wants to counter and bring in a state police officer to say that the investigation was fantastic, that everybody did a remarkable job under the circumstances? What if we bring in a witness to talk about the fact that the evidence is so overwhelming that it should imply a certain finding by the jury? This invites that. This invites a debate between people's personal opinions. That's done outside of the courtroom.
That's right.
Not in a courtroom. We will never have an opportunity to be able to have all the witnesses come back to explain what this witness subjectively thinks was a deficiency. I don't think it's appropriate for expert witness testimony. This is argument by counsel.
Your Honor, very briefly, I gently disagree with,
I don't know how she could
Mr.
gently
Brennan.
disagree. I
He
don't think she can
indicates that
allow
we want
this.
to use an expert to bolster our argument. There's another word for that, or another phrase for that. It's called presenting a defense for someone charged with murder.
Dude, that's
He
not a
indicates, well,
defense.
what are we going to do? This
Not a
guy's going to
defense.
get up there and testify. What am I supposed to do? Call a bunch of other Canton PD officers to talk about
Yes.
how great their
Yes.
investigative techniques were? Yeah.
Yep.
There's another word for that. It's called rebuttal. That's
No.
what you're supposed to do.
Stop it.
And then he says, well,
You wouldn't
hang
be
on.
objecting if they called somebody in rebuttal
course,
to reinforce a great investigation?
Oh, no. Oh, no. Mr. Brennan said, what if I called in a Massachusetts state police officer to say that this was the best investigation ever? I have two words. Do it. Do it. I'd love that. I'd love a shot
Okay,
at that.
so I said, let's take personal.
That's not an invective. That's not a personal shot at Mr. Brennan.
Yes, it
I'm
is.
saying do it. You want to call in another expert? That's a classic battle of the experts. That's fine. I'll
No,
put Mike
it's just
Easter
'cause he
up
wants his
against
expert.
any
No.
expert they want to call. But the reality is, Your Honor,
Please.
we're entitled to present a defense. And part of that defense, the Bowden defense,
no, it's
is
not.
the adequacy of the investigation. And there's no question that a
Wrong.
proper homicide investigation is not something within.
I don't know. So if you can give me a case site for that.
He can't.
All right?
He can't. Doesn't
That-
exist here in Mass.
Expert testimony regarding a Bowden defense. I've never seen it.
Nope.
I've
Doesn't
never seen
exist.
it in research or anything. So
I've
I'd
got
like a
it.
case site.
There are certainly cases outside the jurisdiction.
Yeah, Massachusetts case. If not, you can give me the outside cases, but I don't believe there's a Massachusetts case where this has been done.
We have searched and searched for a specific case in Massachusetts. There, to my finding, to our finding,
Doesn't exist.
there isn't one directly on point.
Correct.
But there's a myriad cases outside the jurisdiction where investigators are called consistently, especially on behalf of the defense, to talk about adequacy of an investigation.
Exactly.
That is an
It was
expert
by
field,
Brennan.
one that's utilized throughout
So
the country
I
all
need
the
some
time.
authority, and the more persuasive the authority, the better chance you have at this. Okay?
Sure.
All right.
I don't think she
So
allows
I
this
think
in.
that's it
I just
for the
don't.
motions in
It-
limine.
there is no
Did I miss
law
anything?
in Mass that allows that. I highly doubt he's let in. I just, even with this judge, I'll tell you, there's nothing that would allow this witness in.
I
Nothing.
need that. Oh,
Your Honor, earlier you alluded to, this is what defense wanted to talk further about the ARCA issue, the Rule 14. You said we'll put that off until the end, if I heard you correctly.
I thought you and Mr. Brennan were going to talk about it first.
Right. Yeah, you were.
Is that your understanding, Mr. Brennan?
Yes, and we have not.
Yes. So that was my understanding. So impanelment, you don't have anything for me for impanelment?
Nah.
I regret we don't. We have not spoken.
Your Honor, if I may, on one point on the impanelment.
Sure.
I just know it's the court's preference to have a one-page front and back questionnaire.
Yes.
I was wondering if, in light of the unprecedented pretrial publicity in this case, if Your Honor would consider an additional one-page jury
Yeah,
questionnaire.
come on, dude.
That deals with just pretrial publicity. Last month in the Chisholm case, the SJC outlined kind of appropriate questions. If in additional to the front and back, there was just one questionnaire that focused just on pretrial publicity, I think that would expedite the impanelment process.
I think that makes sense. Is there any objection from the defense on that? There's been an extraordinary amount of publicity, even far more than the last trial, and so close to jury impanelment. It makes sense to me.
I'm sorry, Your Honor.
You guys are killing me.
Outside cases?
Killing me.
No, there's no objection.
All right. So I need the joint questionnaire, and it can be that third page, Ms. McLaughlin. I think that's a great idea. And I was thinking about Chisholm earlier when I was expecting something from the parties. All right. File your questionnaire, file your proposed questions that you would like me to ask the venire and that you would like to ask at sidebar. I need that by tomorrow. So tomorrow by the close of business, I need that. So if I need to see you again next week, we'll let
It
you
just
know.
doesn't
on Monday.
exist. It does not exist in a Bowdoin defense.
Yes, Your Honor.
Okay.
Obviously, it'd be a day after Monday then, Judge, right?
Yes, Mr. Unit, it would be after Monday.
We did file two
Not
motions
now.
today that at some point we'll need a hearing on.
Okay.
The defense just received notice this morning, so they're not prepared for today, but we would want a hearing on both of those motions. The sooner, the better for us.
So why don't we come in next week?
What day? No, it's a case. The Chisholm case. It was a case. Euphemism. Chisholm. What the fuck? I literally hate when they do this. I need to know what day. And you guys are effing it up for me. Not to rely on somebody else who's friggin' in the courtroom to tell me. Like, what? Come on, man. Signal lost? How about signal back? Go back. What is happening? It's live, so I'm not understanding. You guys gonna get it back, or we're just gonna no? Yeah, no. Okie dokie then. What the F? Yeah, camera do go boom. Flush down the hole. Jack, welcome. Yeah, well, it's not coming back, Bree. It's just crapped out. That was it. Welp, I'll find out. I'll find out what day next week we will all have to reconvene, but I do plan on attempting a show either tomorrow or Saturday, one of those days. So we'll see whether it'll be Friday or Saturday. Yeah, there is no case in Mass for that for Bowdoin. And as a matter of fact, there are, yeah, she said she wanted to finish by 3. What was I? Sorry, I lost my train of thought. There are laws that preclude somebody coming in and saying that an investigation should have done X, Y, or Z. There's actually cases for that. So I just don't see how the judge could allow that witness in. Is not an expert in any goddamn thing. Yeah, I'm looking. Just wants to give his opinion on what he thinks a investigation was or is. He's a damn YouTuber. Like, let's call it what it is here, people. He's a YouTuber, and he just wants to be part of this fucking circus. And
What if the lottery was on your phone? With real tickets, real winners, and really, really secure. Play your official state lottery with lotto.com.
okay, this one is just giving. Okay, weird. Audio now. Audio, it's just audio. It just ends on this one, I think. I'm watching it real quick just to see the end. In 46 seconds, it just, yeah, it's off this week, so that it does conk out here too. Like, what the hell? On court TV. Well, it conked out there too. So I don't know what happened, really. Mm,
File your questionnaire, file your
this
proposed
is it, but this is, I went back a
questions
little on this
that
one.
you would like me to ask the venire and that you would like to ask at sidebar. I need that by tomorrow. So tomorrow by the close of business, I need that. So if I need to see you again next week, we'll let you know on Monday.
Yeah, I don't know.
All right.
3:25, 11 a.m.
Obviously, it'd be a day after Monday then, Judge, right?
Yes, Mr. Unit, it would be after Monday.
We did file 2 motions today that at some point we'll need a hearing on.
Okay.
The defense just received notice this morning, so we're not prepared for today, but we would want a hearing on both of those motions. The sooner, the better for us.
So why don't we come in next week?
You didn't miss much this morning, Lou, because they had to go over, they didn't make a decision on what happened this morning with Aiden. It was really more about his communications that Hank wants for showing consciousness of guilt for Karen. So that was all that was, and there was no decision made on it. The judge took it under advisement, so. We did cover it, though. It was a little late. Okay, yeah, so that was it. That was freaking it. That was completely it. Welp. Do you guys have any questions for me? Give me 1 second. Think of your questions, write them in the comment section. Just give me 1 second, you guys. But if you have any questions before I wrap this up, it's been a long day. I want to wrap it up too. So think of your questions or comments or anything you want to talk about real quick. I got about 15 minutes before I got to go, but just give me 1 second. Sorry, my bladder was going to explode. Literally, I kid you not. I bet it is. Freak, I bet it is. Oh, hi, Suzanne. I know ruling on motion of joint venture. I don't know. It's a good question. I actually don't have the answer to that. I don't know. I'm guessing Hank is still trying to see if he can get those communications. Aiden's communications, get a ruling on that before they address it. Maybe, possibly. I don't actually know. I don't know why they didn't address that one. I know they tried to get through all of the motions in limine today, but as we know, Alessi likes to take up most of the time of the court just saying the same thing over and over or really saying nothing at all. He took over an hour of time, a little over an hour after he said 45 minutes. It's probably like an hour and some change if I went back and looked. That's a good question, and I will answer that, Casey. The answer to that is normally you don't file a civil suit until there's some sort of conclusion to a criminal suit. So if I were you guys, I would be keeping a very close eye on civil suits dropping at the conclusion of Karen's trial. No matter the outcome, you will see a flurry of civil suits coming down at that point. That's standard. It's normal. So that's when I would say keep an eye on civil suits popping out. She can try to claim she's broke, but they'll just seize any assets she has, stocks, bonds, bank accounts, all that stuff. They will literally go through all of her financials, with a fine-tooth comb. So the two separate things are consciousness of guilt, joint venture, and then you're talking about not bringing up the harassment. Remember I told you guys the other day when people were confused and were like, oh, well, how is he going to do joint venture and consciousness of guilt if the harassment's not allowed to come in? Remember I explained to you guys that it's two separate things, right? The harassment isn't going to be allowed to be brought up throughout the entirety of the trial unless the door gets opened for that specifically. But there does come a time when the Commonwealth is presenting their case that they may want to say, now we're going to do the consciousness of guilt part. And then they would be allowed to introduce it there. So those are separate things. So that's why people were like, well, the harassment's not allowed to come in. So, you know, I don't know how they're going to do consciousness of guilt. Like I saw the cult say this a lot, but I had already explained it to you guys. And I just don't have the time to tell the cult to just go back and watch my live stream to see like, you know, how they're wrong. Cause they'll just be like, you don't know what you're talking about. Yeah, you're right. I have no clue what I'm talking about. None at all. My batting average speaks for itself. Thank you very much. So I just laugh at them at this point when they say really dumb shit like that. But it's two separate things. Hank would be allowed to bring it in if he was doing consciousness of guilt, joint venture, sort of thing, versus being able to have people just talk about it the entirety of the time, you know? My God, he is an oxygen thief. It's real life, dude. I think that they were pursuing third party because they got away with it last time and they shouldn't have. So I think that was Hank's point, is they got away with doing third party, doing a pick one, anyone, all these people are suspect to the jury. It confused the jury, and that should have never been allowed to happen to begin with. And Hank makes that point, which is, if you're going to do third party, I need who the hell you're going to like say is your third parties and what evidence you have, because with a third party defense, you have to have some sort of evidence that these third parties did anything wrong. Can't be speculation, can't be, you know, misconstruing evidence. It can't be using their communication, one line of their text message to say, oh, that one thing that they said without the context might look slimy or sketchy or a little weird. And they don't have that because it doesn't exist. So I really don't see how they're going to be allowed to bring third party if they have no evidence to prove any third party. And I want the cult to remember that Karen just told everybody just a few weeks ago with Ted Daniel that they don't know who did it. They don't know, and it's not for them to know. When before that they said they knew who did it, Steve. They knew who did it, right? To the reporter outside, which was like a year prior. So they did. First they knew, now they didn't know. Now they know again. And they named Colin, who wasn't even there, which I find extremely funny that they even bothered that, because it's so risky knowing that he wasn't even effing there, how they would even attempt to prove that he has anything to do with anything. Like, he wasn't even there, dude. Wasn't even there. Wasn't even freaking there. Like, to me, it is, all of this is desperate for the defense. All of it. This whole thing is desperate. Extremely desperate. They are throwing more spaghetti at the wall than I've ever seen them throw before. And Jackson's doing more distracting than he normally does, because at this point they really don't have shit. Hence why they try to bring in the YouTuber. They don't have anything. They have nothing. They have a bunch of evidence against Karen and nothing to really rebut and say, well, if they were smart, they would just go with the Bowden defense. That's it. The investigation wasn't great. Like, that's, if they were smart, that's what they would have went with the first trial. Like, now they're saying it's part Bowden, part third party defense. That's not going to work. And I do not think that they're going to be allowed to bring third party defense this time around. I just don't. So, hey, listen, I have spelling mistakes all the time because my phone is old. Okay. And when I type, right, my fat fingers will press the button next to it, or the button above it, or below it, or sometimes it even gets stuck and does two over. I don't know. It's old, and I have other things to worry about. But I love when they try to like spelling police me. I just laugh. Like, dude, it's online. I'm not writing a theory or a thesis. Like, I don't give a shit. Okay. If I have to write you instead of YOU to save characters, then I'm frigging doing it. All right. I'm tired and I don't have time for this shit. Like, I don't care. You're going to be the spelling Gestapo. Good for you. You do that. You have fun being the spelling Gestapo on X all day. Like, It's kind of, once again, pathetic. Yep, they would have a specific instruction before hearing the consciousness of guilt, but they would also have another instruction right before they went and deliberated about that specific information. The judge even gave it twice last time. So, oh, he was so flustered. So did Alessi. You know, the sewer turtle's in the back, clenching his butt cheeks, like, you know, clearly very worried. I don't know what he could be worried about. I have no idea. No clue what he could be so worried about. None whatsoever. None. None at all. Nope. Oh, they're cooked. Their goose is cooked. Just absolutely cooked, Suzanne. You are completely right. It's cooked. I just don't see how they could convince a jury anything other than guilty in this case at this point. Hank is very thorough. He's a man who likes detail, and there is no detail that he overlooks. I'll promise you that. He's just one of those people. He's very thorough. He's a critical thinker, and he doesn't miss a beat. So make no mistake when I say he's not missing. He's not going to miss anything. Like, he is going to present this case in a way that the jury can remember, that's coherent, the timeline, and he's going to do it with lots of visuals so that it sticks into the jury's mind, which is exactly what you want. You don't want to confuse a jury with a bunch of nonsense, which is exactly what happened last trial. You just confused a jury. You gave them way too much. Commonwealth spent too much time rebutting a nonsense conspiracy theory that never happened than actually putting on the case for what happened and giving them the details. Give them the information. John stops moving forever seconds after Karen backs up. He never goes into the house. The phone is found underneath them. Why underneath them? Oh, because Karen tried to pull it out of his pocket. So, and they're being very diligent when it comes to the jury at this point. They want to make sure that no free Karen Reed, at least the Commonwealth, make sure that no free Karen Reed person gets to sneak in and lie to the jury like they did last time. Because we didn't just have one of those. We had a few of those last time, and they had to be dismissed from the jury. And yet, I think one still remained, or maybe even two. So, you know, they want to make sure that these people aren't lying just to get on a jury. And they want to make sure that these are people who actually have not heard of this case. And this is the first time that they're hearing. And there are people like that. I promise you there are. I promise you there are people who have never heard of this case, have no idea anything about it. Like, they might have heard the name once on the news, but like they didn't pay any mind to it. Okay. Because lots of people don't pay attention to this kind of stuff. Very busy people that just don't have time for even the news, you know? So, you know, they might read whatever they're interested in on their phone. Their algorithm gives them. If they're, you know, political stuff, then they read the political stuff. If they're like finance stuff, they read finance stuff. You know what I'm saying? Like, not everyone knows about this case here. Like, I know, right? It's an amazing thing, isn't it, Brie? Like, I do want to thank the couple of people that sent donations my way today. I appreciate you. Brie, appreciate you. Thank you. Because our channel runs only on donations from you guys. And I appreciate every single person that comes to watch and every person that shares and likes and puts comments on the video after it's up and I'm not live anymore. That helps the algorithm kick it out to other people. I appreciate you all for that. So it's 3:13. I am going to go. It has been a long day. I am hungry. I want to go grocery shopping, or try to go grocery shopping at least, and try to put some food in this house of mine. I got about a billion other things I have to do. So I love you all. I will try to pop in either tomorrow or Saturday. I will let you guys know on my X account, or even put like a little post up on YouTube, since you can do that now. You've been able to do it for a while. I just really haven't utilized that, but maybe I will, to let you guys know whether it's going to be Friday or Saturday, but it'll be one of those days. We can powwow. I usually do my Sunday morning show, so make sure you have your coffee ready for Sunday Fun Day show. But I love you guys, and I will see you either tomorrow or Saturday. I'll leave you with my outro.